My lord, I have very urgent motion. Urgency is, my lord. The petitioner took a loan in 2016 of 14 lakhs. My lord, till date he has already paid 19.54 lakhs. My lord, alleging default without supplying the copy of the loan agreement, on 26th of July, they forcibly seized the vehicle and are going to sell the vehicle by auction on 5th of September. My lord, I made a prayer for settlement. I made offer 5.250 lakhs, my lord.
Hand over this. No, file it in due course. File it and give the number. No.
5th September is the date.
File it and give the number to me.
Yes, yes, yes.
After number to deliver, please give it today itself.
Yes.
Upgrade.
May I have my lord's kind leave,
Yes,
my lord, to mention, my lord, item number 290 of my lord's today's list. My lord, there is some urgency. I just indicate, my lord, the urgency. My lord, the matter pertains to sexual harassment of, my lord, a lady, my lord, at workplace. My lord, I am the accused. My lord, internal complaint committee was, my lord, considering the matter. My lord, the lady, my lord, went to the local complaint committee, my lord, bypassing the internal complaint committee. The local complaint committee, my lord, passed an order on 23rd of May, communicated on 5th of July, my lord, directing, though, my lord, they don't have the jurisdiction to direct so, directing, my lord, my removal from service. My lord, that time is going to expire on 5th of September. And my lord, there's one more urgency. My lord, we applied for certified copies of the proceedings, my lord, before the local complaint committee. 3-4 documents have been made over to us. My lord,
it will appear under the top heading on
so
Monday.
Monday. My lord, I will serve notice upon that.
Yes.
May I pay for endorsement of leave granted by law? Otherwise, it won't be. They will not accept the.
In normal course, file it. File it in normal course.
Yeah, my lord.
As a motion is filed, give the number to my officer.
It may appear on before 5th.
Yes, তাই তো বললাম. Yes, it will appear before 5th, much before 5th.
Item monthly item number
1. No further mention.
This is regarding to
No, call the list. No further mention. Sorry. Yes.
To be mentioned, item number 1 to 3 for correction.
Yes, my lord.
What is the correction? Yes.
Correction is my name, my lord. I am appearing on the matter, the Premjit Mahato, 14924. Top, madam. I am appearing on last 2 days. State respondent, my lord.
For that, a correction of the order is necessary. You have prayed for a correction of the order for recording your name.
Yes, my lord. Otherwise, I am just.
You are appearing for the state.
State respondent.
You are in WPA?
WPA 14924. Premjit Mahato.
Learned, the name of the learned counsel appearing in WPA 14924 of 2023 was incorrectly recorded in the order dated July 20, 2023. Full stop. Learned counsel appearing for the state in the said matter is requested to furnish a slip, comma, the contents of which be incorporated in the appearance list of the order dated July 20, 2023. Full stop. This order be deemed to be a part of the said order.
Grateful one.
Thank you.
Contempt application. Item 4.
For the petitioner.
Yes. What is the contempt?
Your lordship's order.
Lord, I have instructions to appear on behalf of alleged contempt. I don't have received any copy. So let me, my lord, have a copy and I shall come back to your lordship.
Very good.
Because this is that matter where bulk connection is there. Unless all the bulk, unless bulk connection is.
Very good. Please give a copy.
Yes.
Mr. Kole, learned advocate, submits that he has instruction to appear for the alleged contemners. Full stop. Accordingly, the learned counsel for the petitioner is requested to serve a copy on Mr. Kole, comma, who intends to appear for the alleged contemner.
I was respondent number 4 and 5 in the original writ petition. I have also not received.
If you want to be joined as a party to the contempt,
No, my lord, I have not received any content.
I'll make you alleged contemners. I'll ask them.
No, because his presence is required because he is the connection holder. The bulk connection was given to
I have not received any copy, my lord.
his presence is required.
না না কি বললাম সেন্টেন্স শেষ করেছি বলো আরেকবার
নামাগুলো নিয়ে নাও
আচ্ছা কি বলেছি কি বুঝতে পেরেছি সেটা বল
এখন তো নেই আগে আপনার নাম্বারটা দিয়ে দেবেন।
হ্যাঁ হ্যাঁ ঠিকই বুঝেছো, এই পর্যন্তই বলেছি। Serve a copy of the contempt application on Mr. Kole during the course of the day, full stop. It is also submitted on behalf, you are Mr. Dotto.
Yes, my lord.
It is also submitted by Mr. Saptarshi Dotto that since he appeared on behalf of the respondent numbers 4 and 5 in the main writ petition and
কোনভাবে উনি আছে ওনার নাম্বার
may be a relevant party herein, comma, copies of the contempt application be also served on Mr. Dotto during the course of the day. Full stop. The matter shall be listed next on September 8, 2023.
23.
Grateful to you.
Careful, your lordship.
Yes.
Unless my lordship surrender the bulk connection, we are not.
I
Your lordship's
understand.
order is there.
I understand. Yes.
Item 5,
Yes.
আপনি একটু নাম্বারটা একটু জানিয়ে দিন।
My lord, item 5,
Yes, Mr.
my lord, on behalf of the, my lord, the superintendent of police, Purulia, one of the, my lord, the contemner.
You have to decide some representation, bro.
Yes. Now, my lord, if your lordship kindly have a look, my lord, it has been complied with. Now, my lord, if your lordship
This is
kindly-
appearing for the first time.
My lord,
A copy of the contempt has been given to you.
yes, my lord, copy. So far, my lord.
Because I
it
did not
appears.
direct them to serve.
Then, my lord, I think, my lord, the.
If you say that it has been complied with, just satisfy me on that, Mr. Sen, I'll
Yes.
record that and dispose
Yes,
of the
my
one.
lord. But because the matter is
No.
not so serious, but he says that unauthorized flying, if your lordship kindly have a look, my lord, at a glance, my lord, that the
No, let me first.
second page and third page, lordship kindly have a look, my lord. I think second page and third page, lordship kindly, that pursuant to my lord's order, my lord, the communication made between the superintendent of police Purulia and the concerned regional transport officer Purulia. And my lord, the fourth paragraph in the, my lord, the second page, a hearing was conducted. Resolution of the hearing was held on 10th November 2005, 2022.
Yeah,
Yes.
Yes, Mr. Bhattacharya, they said it has been complied with.
no, my lord.
They have considered the representation. Can you give a copy, Mr. Sen, of the report to
Yes,
Mr.
yes,
Bhattacharya?
yes, my lord.
My lord,
আগে দেয়নি না? ঠিক
There
আছে।
was a direction for representation, consideration, Mr. Bhattacharya.
তুমি সেকেন্ড পেজটা দেখো তো মক্কেল যদি না
Please
বলে
come
থাকে।
to that. Yes.
pursuant to your lordship's order,
Yes.
only STA PR has complied with your lordship's order by cancelling one permit.
Cancellation, was that my direction?
Yes,
My
my lord.
direction was-
No, consideration.
They have considered, they say, if you are aggrieved, you can challenge that in a writ petition.
No, my lord. After considering the representation pursuant to your lordship's order,
Yes.
STA Bihar
Hmm.
has cancelled one permit out of 30 permits.
All right.
And my lord, STA Jharkhand,
If they have passed, they have considered your representation, the contempt does not
no,
lie.
no, STA Jharkhand has
Not considered.
not considered. STA Jharkhand and as well as the Regional Transport Authority Purulia.
No, that is not correct. That is not correct.
But
The Regional Transport Authority
I-
Purulia
the-
considered his grievances. My
But
lord,
the illegal-
hearing
illegal price of-
taken.
So, Bhattacharya, both of you cannot argue together. Sorry. Since he is explaining himself, let Mr. Sen explain, then I'll come. Yes.
Now, my lord, better lordship kindly have a look. My lord's order, I think, my
Yes.
lord, kindly come to my lord, page number 19, I think.
19, yes.
Page number 19, my lord, the order. What was the
Right,
actual
right.
order? Right, 19 to.
only considered.
Yes, now, my lord, kindly have a look, my lord. Petitioner submits that complaining about some vehicles plying in an unauthorized and illegal manner over certain routes. Now, this was the complaint. Now, even without going to the merits, my lord was kind enough to ask the, my lord, concerned authorities to consider and decide the representation.
Yes.
Now, my lord, kindly come to my lord, now the report, lordship, kindly come to straightway at the, my lord, the second page of the report.
Yes.
And my lord, the middle portion, 1, 2, 3, fourth paragraph, my lord.
Right.
That accordingly, as per letter issued by memo number, memo number such and such, RTA Purulia, a hearing was conducted on 10th November 2022 by the RTO Purulia in compliance to the order dated 5th July, passed in WPA such and such. Resolution of hearing held on 10th November in connection with order dated such and such was circulated. Copy of resolution of hearing was held on, and the If any bus is found plying illegally or without permit, necessary action can be taken by the MVI and MV rules. Police authority will look after if any law and order situation happens. Now, my lord, unless that is found and unless, my lord, anything specifically said that this is illegally plying this particular vehicle, and lordship kindly come to the annex charts also. My lord, kindly come to, my lord, page third annexure, lordship, 18th October 2022, third annexure.
Yes.
Now, my lord, subject hearing in connection with such and such.
Yes.
Now he was asked to appear, and then, my lord, resolution of hearing, that is the, my lord, the next.
Page 51.
And the last is the, my lord, the annexure is the, my lord, the resolution, that hearing in connection.
Page 51.
Have you lordship got it, my lord? Hearing in connection.
Last application.
Last but one, my lord.
Hearing in connection, yes.
Yes, my lord. Yes. Now, as per letter issued, now petitioner Om Prakash along Gupta with his advocate, Mr. Satyik Bhattacharya, was present. Among the Jharkhand, Bihar bus operators, somebody is also, my lord, was
Page 51 of the content
present.
So, Bhattacharya, please take
The
your seat. Let me hear.
Petitioner and all the concerned parties were asked to brief their statement one after another. Then among 13 buses, the owners of 11 buses were present. Then, my lord, Anand Prakash, owner, informed he is the owner of Jharkhand bus. And this all JH means, my lord, identifies that all Jharkhand.
Obviously, yes.
Now, at present, only JH22A is plying rarely through Purulia as a shortcut route via Purulia from Jamshedpur to Dhanbad. He said that during night time only that buses passes through Purulia with very few passengers. Then Mohammad Azimuddin, owner of Rugby buses, informed out of 4 buses such and such, all Jharkhand registration, only 2 buses of Jharkhand registration are plying through Purulia with valid permit. Rest 2 buses are plying on Tata Pukur Road via Ranchi and not plying through West Bengal. Then
Yes.
Mr. Rahul Kumar informed he is the owner of another bus of Bihar.
Yes.
And that buses, all 3 buses are not plying. Police authority present in the hearing informed they are keeping sharp vigil at their respective PS jurisdiction. Secretary Purulia Bus Owners
Mr.
Association.
Sen, I've seen you have complied. I mean, at least
My
the
lord.
direction has been complied. Let me hear Mr. Bhattacharya. Yes, Jharkhand has not complied, you're saying.
I did complain with and my lord, after the order passed.
Please
on-
come to your representation and annex to the writ petition, Mr.
Yes,
Satyik
my
Bhattacharya. Your representation was to the Purulia authorities. There was no mention of Jharkhand authorities. Page 23 of the writ petition. And you have preferred a contempt application. Where is the representation to Jharkhand? There was no direction on Jharkhand at all. Please see page 23 of your own application, writ petition.
Yes, my lord.
Before
but-
filing, Mr. Bhattacharya, before
my-
filing a contempt application,
No, my lord.
this is a serious step. You don't check up even your own representation.
My lord, I made the.
But I'll impose cost on your client for this.
No,
There
I
has
made-
to be a deterrent
I
for
made
this.
the Jharkhand as a party respondent. my lord.
People go on filing contempt applications just as a matter of course, Mr. Bhattacharya. That has to stop.
I made-
Contempt is not a jurisdiction which can be invoked
lordship-
just like that.
Your lordship kindly consider the
I
cost,
definitely
no,
invoke.
cost title of the writ petition, my lord. I made my lord respondent number
So
4.
Bhattacharya, I can't believe my ears. You were an advocate practicing for so many years. You made certain persons the parties. Now you had given a representation to only Purulia authorities. You have filed a contempt application against Jharkhand for not having considered that application.
Your lordship's order was that the respondent authorities will consider.
He has to be constituted as a reasonable man.
So your lordship kindly consider. Your lordship's order was my lord to consider by all the respondents.
I'll dismiss the contempt.
All the respondents are directed by your lordship to consider. I have made
So
the party-
Bhattacharya, this is a very bad habit. You finish your arguments, I'll start my order, then don't disturb me. Finish your arguments, bosho.
Your
শেষ করে নিন।
lordship, as my lord, I made the Jharkhand as a party respondent, my lord, and your lordship's order was directed to directing all the respondent authorities. My lord. Your lordship kindly have a look at your lordship's order.
I've thrice seen my order. I'll give my reasons.
But that's why I made contempt notice, my lord, to the Jharkhand.
Very
And not Bihar. I did not. In my representation, I did not state Bihar as a party, but state Bihar has complied with, my lord. Pursuant to your lordship's order, my lord, I sent the order along with my representation to all the authorities, my lord. That is my contempt notice, my lord. Your lordship kindly have a look at the contempt notice.
Without looking into the contempt notice, Mr. Bhattacharya, I wouldn't be telling you these things. I've seen whatever is there. What is your argument on Jharkhand? Let me hear your argument, then I'll pass my order. So that you don't say that you don't have any opportunity to argue. But cost I'll impose, that's why I'm hearing you.
Your lordship, page 18 of my contempt application.
Yes. Page 18.
Page 18 of my contempt application. Well, CL number 3 and 4.
Bihar and
Bihar
Jharkhand.
and Jharkhand.
Yes.
I send my representation along with your lordship's order to all the authorities, my respondent authorities, as per your lordship's order. And pursuant to this letter, my lord, STA Bihar has considered.
Right.
And on the illegal plying is going on.
Yes. Learned counsel for the petitioner contends that despite the specific direction of this court on the authorities to consider the representations of the petitioners, the same was not done, particularly by the Jharkhand authorities, although the Bihar authorities have complied. Who's up next para? Learned counsel appearing for the respondent for the alleged contemners contemner numbers 4 to 6 submits that the 3 to 6 submits that the Purulia authorities have duly complied with the direction by considering the representation. Written instructions in that regard is filed in court, which is kept on record. It is clear from the written instruction and its annexures that a hearing was given to the petitioner and all concerned parties in pursuance of the order of this court passed in WPA 11416 of 2022. And, as such, it cannot be said that the Purulia authorities were in any way guilty of contempt. Learned counsel for the petitioner also submits that the Bihar authorities have also complied with the order. Next para. However, it is submitted by the petitioner that respondent numbers 1 and 2, the Jharkhand authorities, did not comply with the order of this court. Learned counsel for the petitioner places reliance on the cause title of the contempt application as well as the addressees in the communication of the order of this court, showing that the order was communicated to the Jharkhand authorities as well. However, it is contended that the Jharkhand authorities deliberately chose not to comply with the said order. Next para. A perusal of the order dated July 5, 2022 shows that this court had directed while disposing of the writ petition, the within double inverted respondent authorities, double inverted close, to consider and decide the representation made by the petitioner on March 3, 2022, within bracket annexure P1 at page 23 of the writ petition, bracket closed. Next para. A perusal of the said annexure to the writ petition, in terms of which the order was passed by this court, shows clearly that all the authorities mentioned therein were of Purulia, West Bengal, and that the Jharkhand authorities were never addressed in the representation, which was directed to be considered by the respondent authorities. Next para. Since the representation was not given to the Jharkhand authorities in the first place, and the order was specifically on the said representation, it cannot be said that there was any non-compliance of the order of this court by the Jharkhand authorities, who were never given any representation, which was the premise of the order of this court. Hence, it cannot be said that the Jharkhand authorities, that is alleged contempt numbers 1 and 2, were guilty of contempt Full stop. Next para. Since the petitioner never gave any representation prior to passing of the order of this court in the writ petition to the Jharkhand authorities, comma, the contempt application cannot succeed against the Jharkhand authorities. Full stop. Accordingly, comma, keeping in on record the written instructions filed by the Purulia authorities, comma, the contempt application is disposed of. Full stop. Hence, CPAN 694 of 2023 is dismissed without any orders to cost. No orders to. Thank you. Next.
However, my lord, this order, my lord, cannot prevent the petitioner to on the
Nothing in this order will prevent anybody. And you can should I make it clear that you can challenge this represent this.
instruction.
Very well, I'll put that. It is comma however comma made clear that nothing in this order shall prevent the petitioner from challenging the decision taken by the Purulia authorities, comma, in terms of the direction of this court passed in the writ petition, comma, since the same furnishes a fresh cause of action. First.
And
Thank
my
you.
lord, only thing, my lord, that the direction, the or written direction which I have, my lord, placed before your lordship already handed over to him, so that he cannot say in future that.
Yes, my lord.
Okay,
আরেকটা
kindly,
একটা লাইন অ্যাড করে দাও
but
a
abandon
copy of the written instructions, right? A copy of the written instructions filed today in court has been handed over to learned counsel for the petitioner.
Mine. Great.
Item 6.
Yes. Salda, what is the content?
This is, I am the writ petitioner respondent. There is a order of my lords to give connection.
আমি তো petitioner.
I appeal
Full?
on behalf of the CAC.
Your
I
lordship.
don't know whether it is anything against us or not. But it is get a copy of the content.
Mr. Bhattacharya, what is the allegation against CSC? also?
Your lordship granted electric connection in a garage, my lord. And earlier honorable court's order was there in second appeal that the character should not be changed. On the basis of that, your lordship also
Bhattacharya,
specifically.
give a copy to the CSC and come back.
And
My
CS
lord,
is
my
not
lord,
a
my lord.
party in
Give a
the
copy to
contempt.
all the parties.
My lord,
CS is not a party in the contempt application.
Acha.
Against the
No.
The allegation is against you.
only.
You
But
are the
the-
culprit, Mr. Haldar. So let us see whether you can be sent to jail.
Meter has been given, thereafter character has been changed, the dwelling house, my lord. Your lordship kindly see order passed, my lord, on page
Mr.
14.
Mukherjee, let us see if it's required at all. If you want, I can add you as an alleged contender. Yes. That option is always open in contempt. And if you want, I can definitely add you. I'll record that it's your submission.
I don't know. At
Acha,
least this jurisdiction.
Page 4 of the order.
Your lordship kindly see page 14.
Internal page 4 of the order.
No, entire page 14, my lord. Continuation of the page 14. Your lordship passes the order. Your lordship kindly see page 15 and 16. Your lordship specifically mentioned that on the basis of the earlier order passed by the Honorable High Court, the character should not be changed at any point of time. But after getting, my lord, connection,
My
they have
lord,
changed the character of the, my lord, garage into a dwelling house, my lord. And my lord, after, my lord, filing this application, we have received letter from the contemnous end that no meter has been, my lord, installed. But my lord, I have annexed the meter number, my lord. That is in, my lord, page 23.
না কিছু নেই।
And after, my lord, giving the, my lord, contempt notice, my lord, and after filing this application, we have received a letter from their end that no meter has been, my lord, installed.
চিঠি দেখাচ্ছে।
What have they done in the garb
They
of
have
taking?
changed the, my lord, dwelling,
In the
garage into a
if they have
dwelling.
changed, otherwise it's a violation of the second appellate court's order. But this court also said that that order has to be complied with.
Yes, my lord.
Now, how did they do? Tell me how they changed the nature and character in the garb of taking the electricity connection. It has to be connected with that.
After, my lord, getting the electric connection, they have changed into garage into a dwelling house, my
After
lord.
the electricity connection, if it is done, Mr. Bhattacharya, it's not a contempt of this court. The order was during subsistence of the injunction order passed by this court in second appeal. Petitioner shall not, in the garb of taking electricity connection or taking advantage thereof, change the nature and character.
After taking the
So I'll
advantage,
give you leave to approach the learned single judge for violation of the
My lord,
second appellate court's order.
my lord.
Because if they have changed the nature and character, definitely tantamount to violation of the second appellate court's order.
we have, my lord, anticipated that they will change the. I have
You
submitted also
specifically said.
before your lordship, also your lordship
I'll
also
rec-
specifically, my lord.
So you say
passed
after taking the connection, they have
after
done it.
taking the
See,
connection.
if that
my
be
lord.
so, it's not in the garb of taking connection. They took the connection, then changed the nature and character.
Yes, my lord.
That's a violation of the second appellate court's order. It's a
Second
specific
appellate
order.
court's order also, this court's order also, my lord. This court's also order
Learned
also. Your
counsel-
lordship specifically
I'll
mentioned.
record. Learned counsel for the petitioner submits that immediately after taking electricity connection, pursuant to the order of this court, comma, the alleged contemners have changed the nature and character of the disputed property, comma, thereby deliberately flouting the order of this court. Full stop, next para. A perusal of the said order indicates that this court had recorded, comma, while disposing of the writ petition, that an eviction decree was obtained by the present petitioner stroke landlords against the alleged contemners, comma, which was reversed in first appeal, comma, against which a second appeal was preferred before this court. Full stop. In the second appeal, comma, an order of injunction, comma, it was recorded, comma, had been passed by this court, restraining the alleged contemner inter alia from changing the nature and character of the suit property. Full stop, next para. The present petitioner had expressed the apprehension that the alleged contemner might change the nature and character of the suit property, comma, in the garb of taking electricity connection. Full stop. Next para. To allay, L-A-Y, to allay such apprehension, comma, it was observed while directing the CSC Limited to give electricity connection to the alleged contemner, comma, that the said order would not confer any right on the alleged contemner, which he does not otherwise have in law, and shall be without prejudice to the rights and contentions of the parties in the second appeal. Full stop. That apart, comma, it was recorded, comma, during subsistence of the injunction order passed by this court in second appeal, comma, the petitioner shall not, in the garb of taking electricity connection, comma, or taking advantage thereof, comma, change the nature and character of the suit property or in any manner violate the injunction order passed by the second appellate court. Full stop, next para. Since the petitioner alleges that the alleged contemner has violated the order of court after taking the electricity connection, comma, the same cannot be strictly said to be a change in the nature and character within double inverted in the garb of taking electricity connection, double inverted close, but was an independent act of alleged violation of the order of the second appellate court. Full stop. Hence, comma, contempt, comma, if any, comma, lies in respect of the order of injunction passed in the second appeal. Full stop. Next para. In such view of the matter, comma, CPAN 738 of 2023 is disposed of by granting liberty to the present petitioner to approach the second appellate court with an appropriate contempt application, comma, with the allegations of violation of the injunction order passed in the second appeal as made herein. Full stop. Next para. This court has not gone into the merits of the allegations between the parties, and it will be open to the parties to agitate all points regarding the alleged contempt before the second appellate court. No orders to cause urgency. Thank you so much. But Mr. Halder, this is only postponed. If you have changed the nature and character, your client may, I mean, whatever.
He will suffer if he has committed any.
Obviously, yes.
He will
My
suffer.
lord, they have sent a letter that no matter has been
No, no,
installed.
the typing mistake.
Typing mistake.
Typing
Typing
mistake.
mistake, my lord.
Then his client is real.
Specifically, my lord, written that no meter.
Mr. Halder, you are lucky. It's not before we have it.
CAC did
You're
not
actually
install
lucky.
any, my
If I
lord,
was a
meter.
second appellate court, your client would be in a soup. But annex, I should not advise you. Mr. Bhattacharya, you know what to do before the second appellate.
My lord.
Yes.
Item 7 and 8.
Yes.
But no, 7 I'm applying for the CSC, my lord.
Right.
My lord, I am for the petitioner, my lord, contempt application. There is a order, my lord, kindly see, page 24. Shall give adequate police assistance at the cost of the for ensuring access to the CSC pass to purpose of installing the block meter. Because of not giving the order of breaking the law, the police has not complied.
So what happened?
That for that we filed.
Therefore, the police is in contempt.
Yes, my lord. Police and the
You have implemented the CSC also.
CSC also.
My lord, we have
Because I also the landlord. I have served all of them.
Landlord also. Very.
My lord, it will be
No, Mr.
it will be
What was the
shortcut.
role? What of the yes? It will be
It will be
shortcut.
shortcut that if the order be directed only to break open the padlock, it will be the purpose will be served.
Did I direct service?
Yes.
Did I direct service of the contempt
Yes.
application?
No.
Yes.
Electricity will be given at
I
the
didn't.
police cost.
Yes, Mr. Ghosh, what are you saying?
My lord, thrice we have attempted, my lord, to install the block meter. The meter room is locked. We have also intimated the petitioner, my lord.
No,
And-
police, you intended the police.
My lord. And since there is no specific order to
We have deposited police cost.
Serve a copy on the state and come back. I'll put that
We have served. The affidavit
on the
service.
state.
State also.
Then
served.
I'll have to send the OC to jail.
Officer in charge, we have served the.
This is contempt.
Officer in charge.
Served the officer in charge.
they are pleased that there is no such specific order.
Please,
to
Mr. Ghosh, you appear for the state also. So engage somebody for the state, come back on next Friday. The grievance of the petitioner is that despite a direction of this court to give electricity connection to the petitioner, comma, when the CSC Limited went to give such connection, comma, there was a padlock, comma, due to which the connection could not be given. Full stop. It is submitted that the landlord deliberately flouted the order of this court by obstructing and the police authorities by not giving adequate assistance for breaking open the padlock. Full stop. Next para. Despite service, comma, none appears for the state. Full stop. As a last chance to the alleged contender number 1, the officer in charge of the Southport police station, comma, the petitioner is directed to serve a notice indicating that the matter shall be listed on September 8, 2023 under the same heading to the alleged contender number 1 personally. Full stop. A notice in that regard shall be filed on the next date of hearing. Stop personally on the respondent number, alleged contender number 1. Mr. Ghosh, please check whether it can be, you can appear for the alleged contender.
I cannot.
No,
appear.
obviously you cannot. I'm sorry. I mean, you can arrange. Yes.
Item 9.
Yes.
I am appealing for the petition. Though I am not the contender, but I am for the WBSCDCL because it's necessary parties. It's relating to the shifting of pole, and there is a specific direction upon the district magistrate. My learned friend highlight whether it has.
What is the alleged content?
Your lordship direction was upon the district magistrate of Purba Midnapur.
I directed shifting of a pole.
No, there is a direction for consideration of representation by the district. Giving opportunity of hearing, calling upon both parties.
What is the content committed?
But kindly say.
Yes.
Orderটা দেখান।
Mr. Halder, what is the content?
Content
It was
by-
not decided. The representation was not decided.
Representation was decided, my lord.
and opportunity of hearing was given. But till now, the order has not been passed. No order has passed, whether assertive or negative. I have made a representation to the concerned EM, my lord, but the case is.
That is
still-
strictly not contempt. I did not direct him to communicate anyway. Virtual contempt. The petitioner
May I get a
alleges,
copy subject to lordship kind of
the
approval?
petitioner alleges that the petitioner communicated the order of this court duly to the district magistrate. However, in violation of the order of this court dated September 8, 2022, the district magistrate, despite having heard the matter, has not communicated any order to the petitioner. Next para. Although there was no specific direction to communicate the order of the district magistrate, the same should be considered to be implicit in the direction on the district magistrate to adjudicate the dispute in accordance with law upon giving hearing to the parties. However, in order to adjudicate the contempt application properly and comprehensively, the petitioner is directed to serve copies of the contempt application on the alleged contemners as well as the learned advocate for the WBACDCL, indicating that the matter shall be listed on September 8, 2023. The petitioner shall file an affidavit of service on the next date of hearing. Should I keep it on September 8 or I'll give you 3 weeks time? Not September 8, September 29th. 29th September. Come back with service, serve Dr. Shahara and the other. Yes.
Item 10.
In item number 10, my lord, I am appearing for the petitioner.
Yes.
My lord, on the very onset, my lord.
Have instructions to appear on behalf of the WBCDL.
Yes.
Copies have not been served, I think.
Yes.
My lord, some typographical error was there. My lord, leave may be given, my lord, to correct that, my lord. As regards was after my lord's name, my lord, it has appeared, my lord, at page 1. My lord, it is Honorable Justice SABYASACHI Bhattacharya, then Sarkar, it has come. Last
Sarkar.
Bhattacharya Sarkar. Sir, I have to delete it. But kindly give me the lead.
You are passing directions against Sarkar regularly, and that is really a contempt. And the title of the surname is also wrongly spelled. That is the contempt which I will consider. Only contempt.
That is against me.
Against you, yes, personally. Very, what is the matter about?
Matter is, my lord was pleased to, my lord, grant us.
Have you given a copy? Did I direct you to give a copy?
Yes, I have given them a copy.
So, Mr. Shukla says he has not got a copy.
But kindly see, my lord, we have filed the affidavit of service, my lord.
So what is the contempt? What is the contempt?
My lord was pleased to give us, my lord, liberty, my lord, to, my lord, pray for, my lord, so, permission for submersible pump.
Right.
Now, my lord, they say, my lord, it is, my lord, it is a particular area where the government of West Bengal has decided it that is a, my lord, water is below the level. So, yes, and that is
for
why
the state.
Critical zone. Suit certificate is required.
what certificate,
We
my
have
lord,
written a
but-
letter to them.
Let me see my order first.
yes, my lord, kindly see the order.
Compliance of
My lord,
all
it is
parties.
The order,
page 37, page 37, my lord. They,
Mr. Shukla, there is no allegation against you actually.
Lordship, yeah, there is. That's why. Because Lordship, this has been declared to be a critical zone. Lordship's order was to provide electricity, give the electricity after compliance of all the requirements. We have
Achha, let-
given notice to them.
Just hear the petitioner, I'll come back to you. Yes.
Yes.
So this is page 37, yes.
yes.
I directed them to give supply, but obviously it has to be
Subject
understood.
to,
This has to be subject to law.
Yes, Lordship.
If a sweet certificate is required, you have to obtain a sweet certificate. Obtain that, and contempt does not lie. I mean,
We are ready and willing to provide, Lordship.
I'll record their submission.
yes,
They're
yes,
ready
yes,
and willing.
that will help.
That is the only thing. Sweet certificate has to be.
Certificate. Yes.
Learned counsel for the petitioner contends that despite the specific direction dated June 9, 2022 passed in WPA 5285 of 2021 on the WBACDCL to give an electricity supply to the petitioner for running her submersible pump, the said connection was not given to the petitioner on the ground that the petitioner has not provided any SWID certificate. Full next para. Learned counsel appearing for the WBACDCL as well as the state submits that.
There is no lordship.
Yes.
There is no one appearing for the state. He's my junior lordship.
Oh, he's a junior. I'm sorry. Learned counsel appearing for the WBACDCL submits that a SWID certificate is required for getting electricity connection in the area, since the same has been marked as a semi-critical or critical?
Critical lordship.
As a critical zone. Full stop. Next para. A perusal of the order dated June 9, 2022 shows that although an unqualified direction was given to the WBACDCL to give new electricity connection to the petitioner, it is implicit in the said direction that such connection is subject to the petitioner being otherwise compliant of the formalities and entitled to the connection in law. Full stop. Since the only sticking point to giving a connection to the petitioner now is production of a SWID certificate of the petition by the petitioner, the petitioner is directed to produce a SWID certificate for the purpose of compliance of the order dated June 9, 2022. Full stop. However, insofar as the contempt application is concerned, no case of deliberate violation of an order of this court has been made out as such. Accordingly, CPAN 942 of 2023 is disposed of by granting liberty to the petitioner to produce a SWID certificate for getting the petitioner's connection. If so produced, the respondent authorities shall comply with the order passed by this court on June 9, 2022 in WPA 5285 of 2021 by giving electricity connection to the petitioner subject to compliance of all formalities.
I'm great.
No rest to question.
Correct that. I'm great.
Yes.
Obliged, lordship.
Thank you. Yes.
Application,
Yes.
item 11.
Yes, Mr.
To
Bhattacharya.
be very frank with your lordship and my learned friend, Lord, this petition I would seek leave to withdraw to file a better one, because many important factors which ultimately require for adjudication have been pleaded. Having found that, I thought not.
Mr. Shamanta, refute. That is also disputed.
No. Why I'm saying this, Lord?
Yes.
Your lordship's order
Right.
was based on certain things which were not brought on record. Subsequently, we have brought that on record. Therefore, the question of filing a fresh petition on the same cause of action, Lord, with great respect, doesn't lie.
How
Lordship
come?
will just see your lordship's
So
own
an
order.
application for addition of party.
Ours was an application for addition of party, and we had brought on record the facts for which your lordship had stayed.
You have
your
valid
lordship's-
suppression by them.
Yes.
No, not
Maybe suppression, maybe they
Not
didn't know about
suppression.
it, but
This
Lord,
was
a
this
new
was lack of.
petition on the same cause of action.
Therefore,
doesn't
my
lie.
lord,
No,
Lordship will just look at your
you are
lordship's
wanting to file a new writ petition or an addition of party application?
no. Lord, I want to take my lord's kind leave to withdraw this writ petition with the liberty to file afresh.
Achha.
That doesn't
Nothing.
lie, my lord, because your lordship will see
Mr.
that
Shamanta, unless you can show that any accrued right has, any right has accrued in your favor,
On the basis of
otherwise you cannot oppose probably. What right has accrued in
Lord,
your favor?
lordship will see your lordship's own order, my lord.
Yes. Well, Mr. Bhattacharya, on that, yes. Yes, Mr. Shamanta, which dated?
My lord, I'll tell you. Dated 27/3.
Mr. Bhattacharya, please take your seat. I'll hear Mr. Shamanta on this point only.
Sure.
For the timing.
I
27/3.
did not place anything. Your lordship will just see.
No, Mr. Shamanta, why not? You are entitled. Yes. If some right has accrued, definitely you are entitled.
Yeah, your lordship has said, my lord.
Yes.
Lordship kindly comes to page 4, my lord.
Page 4. Yes.
Hence, as on date, third paragraph. As on the date when the order under recall was passed by this court at the instance of Abdul Hai, the panel relied on by Abdul Hai was no longer in force. Moreover, Inamul and Mustafa were continuing to function as they are still as Muslim marriage registrars in the said area. We are functioning.
So what?
However, taking undue advantage of the said order of this court, which is under recall, Abdul Hai is seeking to get appointment as a Muslim marriage registrar in the Domkol area. It is argued that such deliberate suppression of facts on the part of Abdul Hai ought to result in the recall of the order as spread. Abdul Hai is the writ petitioner. Learned counsel appearing for the writ petitioner controverts such allegations and submits the question of appointment of Inamul and Mustafa as Muslim marriage registrars for the area in question has never been established by any cogent document. That is there in the documents which I have placed. Unless your lordship hears out the matter, Lord, question of withdrawing the writ petition and filing a fresh writ petition doesn't arise, most humbly, Lord. I would not have opposed if it was a simple case, but it is not that. Now a determination by your lordship, and your lordship is going to hear the matter. They had taken time from March.
Now, what is the application for addition of party has been filed by whom?
That has been allowed, and your lordship has passed this order.
Now the main writ petition is to be heard.
Main writ petition along with the recalling application, where your lordship has stayed the order.
No, the writ petition was initially disposed of.
Yes.
This
It was
is now
disposed of by passing an order.
So now I am hearing a recall application.
Recall application and yes.
Unless the recall is allowed, the writ petition can. There is no question of the writ petition.
That's why, my lord,
So Mr. Bhattacharya wants to refile the recall application.
No, it's our recalling.
Oh, you shorter recall.
Unless your lordship arrives at a finding, the question of withdrawing the writ petition and filing afresh doesn't arise on the same cause of action.
But if by his application, the writ petition stands revived,
Mr. Samuti, even if you win if your recall application is allowed, what will happen? The order of such and such date will be recalled. The writ petition remains still.
We are ready for that.
and
So
that
if I dismiss the writ petition as withdrawn, the recall is automatically allowed, but
That's-
not on this ground.
That's the thing, my lord.
all these facts you have to come to law, it has to be with a challenge.
No, they have.
No,
given-
Mr. Bhattacharya, they have taken out a specific allegation of that you have suppressed something, deliberate suppression on the part of the writ petitioner.
No, that your lordship was kind enough to record that this is not correct. So for my submission is concerned, the council will appear to say this is not correct. And those things are to be brought in a constructive writ petition.
No, suppose if you have really suppressed, the writ petition is really, the writ petitioner is suppressed deliberately.
Then
There
the
is some
cause of
other
action would go. No doubt about it. But the question is, kindly see, Lord, as I find, Lord, this order, Mr. Shamantu placed,
Yes, 27th.
taking undue advantage of this page 4. Orders of this court, which is under recall, Abdullah is seeking to get appointment as a Muslim marriage. But if on their recalling, I am going to seek appointment, it's quite funny. And it's argued that such deliberate suppression of facts on the part of the Abdul Bhai ought to result in the recall of the order as prayed for. Learned counsel appearing for the petitioner had controverted such allegations, submit that the question of appointment in Inamul so registers for the area in question has never been established by any cogent document. That these are all gray areas which have to be brought in.
No, but at this stage, if you are permitted to withdraw the writ petition, Mr. Bhattacharya, then you will rectify these defects which they have pointed
I'm
out.
grateful.
If they are actually there.
Lordship may be pleased, Lord, to keep their liberty open to challenge that in the writ petition.
If the writ petition is now rectified, Mr. Bhattacharya,
I can bring those facts on record.
yes,
But they say these facts are not on record.
not merely that, the
They say
conduct of
deliberate
suppression. Yes,
That suppression point, Lord, they can take when I bring this on record to show that this was not within our knowledge.
once the writ petition is withdrawn, they cannot take that. How can they?
No,
There is no deliberate suppression at all because you take away the deliberate.
These points are not available to them. These points would not be extinguished by allowing my writ petition to withdraw and file afresh.
My lord, already those matters are on record.
No,
because we
point
have
goes.
filed
This
them.
point goes, Mr. Bhattacharya, why not? Why not? Suppose if you withdraw the recall application, the entire premise of this recall application goes. The
Look,
deliberate suppression is not there. Because now we will not suppress
But
once they have
then
disclosed.
they can take this with deepest of respect that these allegations were there when they wanted to withdraw the writ petition. Therefore, they have to establish. and
Court has to smile and say that that has become infractions. You cannot take that point. now.
that
Even if they take this one, what is it? They can definitely take. But that's only history then.
very well, no problem. Then he recalls
I'll-
the order, the writ petition is revived.
I'll hear out the writ petition as well as the recall then
The
together.
writ petition says stand disposed of.
No, but the recall
They
is there.
want below recalling of the disposal of the writ petition.
So where is the question of your withdrawing the writ petition now?
No, Milord, I was wrong, under wrong impression. Milord, I was wrong impression, the writ petitions are
They didn't
survived.
contest.
It was
Why
disposed
run
of.
away?
It was disposed of. Milord, how can an application for recalling of the disposal order be untenable?
How
Why
can
not?
you pray for withdrawal of a
No, that
disposal?
is my mistake. I said that's my mistake because I was under wrong impression of instruction
Yes.
that the writ petition still survives. But when this come to knowledge of mine that this is disposed of, therefore that prayer, Milord, is no prayer at all now.
So your lordship will hear out the main matter, this matter.
Recall
Milord.
application has to be
Yes.
heard out.
Why are they running away from
I
it?
am not running away. I want to place all the facts before the court. This is a situation. You said that we have
He's
delivered
ready,
this
will not
up to
hear it.
If
If
Mr.
he's ready to
Bhattacharya
hear
was aware that it had been already disposed of, definitely wouldn't
I
have
would
made
not
this
have
prayer.
made such
He would
a
have started
such a
differently.
fully.
He would have started. Mr. Bhattacharya is not he's sufficiently senior to
No, no,
do that.
that's right. That's right.
He would have started differently. So, Mr. Bhattacharya, if you are ready on the recall application, I can take up the recall application, or I can take it up next Friday, whichever suits both of you. Mr. Samant is ready.
No, so far, Milord, I was absolutely wrong in Milord,
Yes, that is why.
impression. So far, the proceedings are concerned.
Yes,
He has filed an application for recalling of the disposal of writ petition.
right.
Milord, that application should be Milord, taken up. I shall file affidavit to that application. Fine.
Done. They have filed.
No, they will
Everything is ready.
check. Let me.
Mr.
check.
Bhattacharya, come back next Friday. Let Mr. Alam have a conference with you.
দিয়েছো? recalling of দিয়েছো? বাস, ঠিক আছে। Kindly, Milord, your affidavit is there. Fix it up at any date.
Very well.
Because I start with the wrong notion, therefore I don't want to continue.
So I'll put it on you on an adjournment being sought. Should I?
Yes, no problem.
I'll just put that on.
Don't do.
On an adjournment being sought on behalf of the respondent in the recall application and the original writ petitioner, comma, the matter is
No, no.
At-
Milord, we are the added applicants. They are the writ petitioners.
very well. On the prayer of the original writ petitioners, comma, the matter is adjourned till September 8th, 2023, next Friday.
September 8, just a minute, Lord.
Whichever date I fix, you will be busy, you'll have to make time.
September 8, Milord, the new session begins.
I know that, yes. So that session will continue for quite some time.
Well, just
And
for
there
a-
will be fireworks there for which the court will suffer.
Well,
Both
fortunately,
ways. Court will suffer both ways.
Fortunately, this time the session is fixed for 4 days
4 days.
with other intention. Therefore, if your lordship is so kind enough, Lord,
All right.
may it be after.
So don't disclose state secrets, Mr. Hotel. So then, Mr. Shamanto,
It was
Ready on any day, your lordship.
18th or 19th, subject to.
because it's a recall application, I'll have to hear it. I'll put it on 29th.
29th.
29th because I won't be there for 2 weeks. I'll be having Jalpaiguri. So I'll put it on 29th.
29th of
Recall
September.
application, nobody else can
Nobody
hear.
else can hear.
Very well.
29th, ঠিক আছে।
যা বললাম তাই adjourned till September 29th, 2023.
Thank you.
Please come.
I'm grateful.
Yes, please give it.
Item 12,
Lordship, I appear on behalf of the writ petitioner applicant.
Yes.
Lordship,
What is the
the-
application?
Lordship, the application is for restoration. Lordship, the original service copy was mentioned. That's why, Lordship, I could not prepare the affidavit of service, Lordship.
Recall application এটা? Restoration application was filed within how many days?
Lordship, in time, Lordship, but the till date, Lordship, it has been kept pending and the different orders passed by different benches, including.
Yes.
Lordship, different orders, Lordship, release order, thereafter, my Lord Justice Bosi Chaudhary heard the matter, adjourned the matter, but the restoration is still pending. Lordship, may I tell the facts of the case? Lordship, a
So
certificate.
restoration definitely you have filed it pretty close to the.
Yes, yes.
I'll definitely allow it, but since the state was present, give another notice since it's appearing after a long time.
Yes,
Give a notice, I'll take it up on next Friday and
yes, 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 I can.
I do that.
But this notice was on 3rd of August, just prior to mentioning.
Oh,
3rd of August, Lordship, it was there. The original notice is there with the mentioning. Or Lordship takes my Xerox copy.
No, it should be here. I'll just একটু চেক করে দাও তো এখানে অরিজিনাল নোটিস থাকবে যদি ওটা বার করে যদি সেটা হয়ে থাকে তাহলে I'll allow it.
হ্যাঁ ওইটাই
দাও দেখি
Lordship, since the panel changed, Lordship, I had to serve one
Oh,
second
that.
the government pleader. Lordship, Mr. Mukherjee was appearing but due to the change in panel, Lordship, he requested me to serve afresh. I served afresh the writ petition as well as the application. Lordship, that was done on 3rd of August, Lordship.
So there is, you have served on the GP office?
Yes, once again I had to serve the entire writ petition as well as the.
Why should you serve again? I'll allow that. The prayer made in the restoration application is innocuous. Full stop. Since sufficient grounds have been made out by the.
Paragraph 3.
Since sufficient grounds have been made out by the petitioners in the application for the absence of the petitioners on the relevant date, comma, can 9521 of 2018 is allowed, comma, thereby recalling the order dated October 3, 2018, passed in WP number 8470 within bracket W of 2018 and restoring the said writ petition to its original file and number. Full stop. What does the matter
Motion
relate to? It's a
Lordship, motion stage, Lordship, is
residuary matter,
residuary matter,
not police in action.
not police in action.
The writ petition shall be listed in the monthly list of October 2023.
Lordship,
October.
Monday.
Not this Monday. Next October, next month is.
If it could be, Lordship, a disabled person, 45% disabled person suffered accident while in.
Not October, September, next monthly list, Monday.
DP,
Next monthly list.
DP.
Thank you.
May I also serve a notice and come back so that they appear?
Notice regarding the writ petition.
Yes.
I think that will be easier.
Yes. Can direct me also, or I can serve soon.
I cannot. Won't direct you because the writ petition is not yet ready for the hearing.
Lordship, I will serve.
Do that. Produce it before me.
Lordship.
Yes. Thank you.
Item 13.
13, yes.
And for the state lodge.
State. Yeah, for the
For the
petitioner.
petitioner applicant, my lord, may I file my affidavit in reply?
Opposition has been filed.
Yes.
Yes, lord.
To the
Yes,
can.
yes.
Today I'm a bit handicapped, my lord. My advocate on record, my lord, her father is ill, has not kindly take it up next week, my lord.
I've been handed over a copy of the reply today morning.
Very well. Then in any event, it has. Affidavit in reply filed in court today be kept on record on the prayer of learned counsel for the petitioners. The matter is adjourned till September 8th.
Obliged.
Grateful.
Item 14 to 16.
But item 14 to 16, but I appear for the Digha Shankarpur Development Authority. Now, my lord, these has suddenly come up. I'll tell you, lordship, these three, as far as I can recall, I was going through my notes earlier. I don't have the petitions with me like today.
Yes.
But three separate work orders pursuant to three separate notice inviting tenders. But the writ petitioner challenged these separate work orders by separate writ petitions. Now, my lord, hard on several dates. Now, my lord, written notes, as far as I can recollect, written notes were also prepared by both sides and submitted. 3 appeals were also taken out for against the refusal of the interim order.
Before which court?
My lord, possibly before
Justice Kapoor.
Justice Kapoor, and then, my lord, the refusal of interim order being agreed, 3 appeals
What
taken
are
out.
the applications for?
Applications, I believe, are for filed for urgent hearing.
You are for the petitioner.
No, I'm for the state in one matter.
I'll dismiss the application for urgent hearing. That takes care of everything.
Yes, but that case takes care. But I'll be fair to your lordship, my lord. Yesterday, when the matter, I found the matters in the list, but I asked my junior to call up the petitioner. He was also not aware it has come. I told him, I informed him. He said that
You have
we'll
done
take
more than you should have done.
it. That is what we have learned from your lordships.
Achha, I'll direct the writ petitions to appear in the October monthly list.
No.
I'll dispose of the
After Pujas.
after because no.
But because I have lordship will direct because I tried to also take instructions. Possibly the work is also completed. I don't have written instructions, but possibly from
Then
2020.
what is the difficulty? Take written instructions, come back in October. In any event, it won't be
Very
taken
well,
up.
very well. Lordship put it in.
I'll keep it in the list if necessary.
But because this is ready for hearing, so lordship put it as hearing. Oh, everything is affidavits are complete. So
Yes,
yes, must be.
it will appear in the list for hearing. None appears for the petitioners at the time of call. Although you are for the what development
The
authority?
Digha Shankarpur Development Authority.
Yeah, although the Digha Shankarpur Development Authority as well as the state are represented through council. You're for the state.
My lord, first matter.
First. Next para. However, comma, in view of the innocuous nature of the prayers made, that is for expeditious hearing of the writ petitions, comma, the applications bearing can such and such, je application ache, are disposed of by directing that the writ petitions being WPA number 6122 of 2020, comma WPA 5938 of 2020, and WPA 5939 of 2020 be listed in the monthly combined list of August 2023 for hearing.
October.
October 2023 for hearing.
And only once a prayer, my lord,
No address to
the
question.
application, my lord, I recollected from memory that it was for early hearing. Lordship will have a look because otherwise it will go wrong, wrong order will go down.
অ্যাপ্লিকেশনটা বার করে দাও তো যে কোনো একটা।
Most probably that was for early
check up,
hearing.
Yes, early hearing. Sir.
তোর কাছে আছে?
Yes.
Oh, my learned friend has.
It's early hearing,
Early
application for early hearing.
Early hearing তো?
Yes.
Appropriate order.
রিয়ারটা দেখ না। Needs to list the matter before the appropriate date. As early as possible, very early hearing.
Yes.
I'm deeply obliged.
I am also deeply obliged. Because I did not have to hear out the writ petition on merits.
Well, do we know your lordships? We are deeply obliged.
I mean, there are so many matters. Yes.
Lordship.
Thank you. Call. Application ডাকো।
Item 17.
Item 17, what I have been told, Miss Ankita Khushi appearing for the petitioner due to her illness, he could not attend the court today, my lord. Only not today, my lord.
Very well. On the prayer of the petitioners.
My lord,
On the
petitioner.
prayer of the petitioner, the matter is adjourned till 8th September. Next Friday.
For state lordship.
Yes.
My lord, if it
Yes.
pleases your lordships, I beg to appear for the writ petitioner, my lord. It has come at the instance of an applicant, my lord, the copy of which has not been served upon me, my lord.
Applicant is a third party to the writ.
I don't know, my lord, but it's a can. I am not the advocate on record, my lord.
Application for expeditious hearing. November monthly list, yes.
Grateful.
Can 1 of 2023 is disposed of by directing directing WPA 4953 of 2021 to be listed in the monthly list of November 2020.
Grateful.
Thank you. Petitioner কিন্তু কেউ নেই। Petition মানে অ্যাপ্লিক্যান্টের কেউ নেই। The present application is for recall of the order dated November 22, 2022, passed by a coordinate bench, comma, dismissing the writ petition for default. First up, it is seen from the order sheet that when the present application was taken up for hearing on August 25, 2023, comma, none appeared at the time of call. First up, next para. Even today, comma, at the time of call, comma, none appears to move the application for recall. Full stop. Accordingly, can 1 of 2023 is dismissed for default without any orders to cost. Full stop. Since the writ petition bearing WPA 15690 of 2021 already stood disposed of, comma, no further order need be passed in that regard.
Item 20.
Item 20, my lord, I am for the respondent applicant. My applicant in fact become infractuous because they filed this writ application without disclosing anything, without serving copy to us. They were taking adjournment. We obtained certified copy of the writ petition and come up with this application.
This is my petition.
Subsequently,
Application is there.
My lord, it has already been heard out.
There I am.
And
That
11,
petition has been heard out.
my lord, 11,
He's saying that.
11/8/2022, it has been heard out and the matter was coming under the heading contested application. We have exchanged affidavits, we have done everything and the matter had to be finally heard. But
What is
then,
the application for?
my lord, the part that for dismissal of my writ petition.
That
And
I was
that-
conveying to your lord.
I'm-
Let him move his
lord.
application. Yes.
No, so But
is already
after
been
filing
heard
of my
out.
application, the main writ application was taken up by my Lord Justice Bhattacharya.
The application was for expeditious hearing or what?
At that point of time, that we prayed for dismissal of the writ petition.
Why?
Because my no copy of this was served upon us, whether they were taking action.
So I'll
So,
dismiss the application and it was substantially heard by Justice Bhattacharya, it
My
should go
lord,
there.
my lord.
your lordship can dispose of that
Dispose of what?
at infractuous, my application.
Application right now will dispose of
Yes.
and
but
send the writ petition
no,
to
no,
Justice
but kindly
Bhattacharya.
fix any day because we are not getting back our money. They have
My lord,
deposited
we
a portion of this.
Bhattacharya heard it substantially, so why should I hear it?
That if your lordship should.
My lord, we have only exchanged
That was
affidavits,
not
my
part
lord.
her mark.
My lord, it
Oh,
was
achha,
not part
affidavits
heard.
are-
Only affidavits were exact.
That's not a part
my
heard
lord.
matter.
Let the matter, the writ petition be listed. I'll dismiss the writ petition application, but direct the writ petition to be listed.
My lord.
The application, comma, it is submitted, comma, has become infractuous, comma, since the main writ petition is ready for hearing, comma, affidavits having been exchanged between the parties. Full stop. Hence, can 1 of 2022 is dismissed as infractuous, disposed of as infractuous without any arrest to cost. WPA 22824 of 2019 shall be listed in the next monthly list for hearing. Monday.
Grateful, your lordship.
Great. Madam.
Yes. Monday. Next month is September.
Twenty-one.
21, your lordship, appear for the petitioner, your lordship. This matter I have mentioned for hearing since there was directions for exchange of the pleadings, your lordship. There is no application, your lordship. There was one application when filed at initially during the COVID days for the purpose of filing of the writ petition. Lordship, perhaps
As the usual application.
usual application, and I've mentioned for hearing and it has come up in the application list, your lordship.
Meantime, affidavit has been exchanged.
I'll direct the writ petition to be listed Monday's
Yes.
monthly list.
Lordship, lordship, may I be permitted to file the affidavit in reply?
Opposition has been filed.
Opposition is right.
Yes, I'll take on.
Lordship.
It is submitted by learned counsel for the parties that the writ petition itself is ready for hearing and the application was filed in connection, in usual course to have the writ petition enlisted. Full stop, next para. The affidavit in reply filed in connection with the writ petition today be kept on record. Full stop. The application, that is can 1 of 2020 within bracket old number can 4067 of 2020 bracket close is thus disposed of, comma, directing WPA 5924 of 2020 to be listed for hearing in the next monthly list. Next month means Monday.
Grateful, your lordship.
Item 22.
Item 22, I'm for the petitioner.
I appear for the respondent, bank, your lordship. Lordship, the can, my lord, has become infractuous. My lord, they have challenged the sale notice dated 7/2/2023. Even though, my lord, the learned DRT is the appropriate forum for that, but since for the lack of bidders, my lord, the sale notice has not been given effect to, my lord, this has become infractuous.
Sale notice, why was it not given?
Oh, my lord,
My lord, there was lack of bidders, my
Lack
lord.
of-
my lord, I'm stating sort of word, my lord, that your petitioners are taking a loan in the year of 2000.
That is on the main writ petition. The application has
petition,
become
my lord.
infractuous.
Yes, my lord.
I'm not hearing the writ petition. Today is the application hearing date.
My lord,
If the application has become infractuous, then I'll put the writ
No,
petition.
my
for-
lord, there is no factuous. As such, this is why that loan was taken only 2 loans, house loan.
What is the
And my lord,
application for? What is the application for?
applications for, my lord, against the sale notice, my lord,
My
and it
lord.
has been already challenged before this DRT.
My lord, page
And
number
my lord,
6, my lord.
Priorly, my lord, 2001, it has what happened, my lord, does that your.
No, I'll record their submission that the sale notice has automatically become infractious
No,
because
I
there was
already,
no-
my lord, challenged before this DRT, sale notice. And my lord, the petition come,
you don't
challenging
understand
the-
what I'm telling you. You are not understanding what she is telling us.
Yes, my lord.
You are not understanding what I am telling you. You are not understanding what you are telling the court also.
My lord, my lord.
What are you telling the court? I don't understand.
I'm coming.
I have come already. So please listen to me. She is saying that you have challenged this. I am hearing this application first
My lord.
because today is application hearing date.
Right.
I am not hearing the writ petition. The application is challenging a particular sale notice.
Right.
She says that the sale notice has become infractuous because pursuant to that, there was no bidder. So that sale notice has become infractuous, lost its force. They have to now issue a new sale notice. Therefore, this application has become infructuous. So your entire arguments now will be on a main writ petition, which I'll definitely hear on the date when the writ petition is taken up for hearing. Therefore, I'll dispose of the this application as infructuous, and I'll direct the writ petition to be listed on Monday in the combined list for hearing. Learned counsel for the bank at the outset submits that the present application has become infructuous since the challenge in the application was preferred to a particular sale notice dated February 7, 2023 and notice dated September 2, 2021. Full stop. However, comma, since the sale notice failed to fetch any bidder, comma, the same has in any event lost its force and become infructuous. Full stop. In view of such submissions, comma, can 1 of 2023 is disposed of as infructuous without any orders to costs, full stop. WPA 12624 of 2021 shall be listed for hearing in the next monthly list.
I'm grateful to your lordship.
Please come back when the writ petition is taken. Thanks.
Twenty-three.
23,
I
Lordship.
am
I am
appearing
for
on
the,
behalf of the petitioner, my lord.
I am for the
Uh,
added
my
respondent
lord,
number
it
14,
is
Lordship.
restoration application, can 3. And my lord, can 1 and 2, they have filed the addition of party application. And
Lordship,
my lord, addition of party application, those who have filed the addition of party application, they have filed another writ petition, my lord.
the item number is 27.
Item number 27. And my lord, in that writ petition, my lord, ex parte interim order was.
What have you challenged in the writ petition?
My lord,
What have you challenged in the writ petition?
in my writ petition, my lord, the ingress and egress is totally obstructed by way of constructing the parka structure. And therefore, my lord, he made an application before the, my lord, the PWD authority.
You made an application.
I made an application. And in
You are
terms of
wanting a direction on the authorities to initiate eviction proceedings or
already initiate in eviction proceeding. And my lord, due to this, my lord, interim order, my lord, the initiated, the executive magistrate, my lord, stop the
what
proceeding.
interim order?
My lord, interim order is, my lord, kindly see.
Lordship,
My lord, interim order, my lord,
I'll hear
the
you.
vacating application. Vacating application. My lord,
Vacating application, interim order, what are you saying? What was the interim order which was sought to be vacated?
my lord, interim order was, my lord, passed by the Honorable Justice Mosmi Bhattacharya, ex parte. My lord,
What was the interim order?
not to proceeding further. What the
You challenged the inaction of the authorities in taking out eviction proceedings and
No,
who
no, no.
who is the writ petitioner?
I am the writ petition on my lord, 23. 23. I am the writ petitioner.
I think I'm taking up 23.
Yes, yes.
What have you challenged in the writ petition?
In my writ petition, the ingress and egress is obstructed by way of constructing parka structure. And my lord, I made an application before the authority.
They filed 27. Item
They-
27 has been
yes.
filed by them.
They are
In their writ petition, they have obtained interim order.
interim order
Your vacating application is pending.
pending.
Very
And
good.
my lord, they
You
have
want
also,
to be added in his.
no, they have also filed an addition.
You want to be added in his writ petition.
Yes, no, you have added, they have filed the addition of party application. My lord, in this petition, 23.
What did I say? What did I say?
Yes, yes, ma'am.
No, what did I say?
No, my lord.
No, tell me, just curiosity. What
no,
did
no,
I say?
I am wrongly.
I'll allow the addition of party application. Only can one is addition of party application.
1 and 2, my lord.
Your application, you don't know which are your applications.
I'm not the advocate on record, Lordship. I'm beg your pardon, Lordship. I'm led
It's
by
all
Mr. Nilanjan Bhattacharya, Lordship. Kindly keep the matter on next week, Lordship.
Any
Item two-
difficulty if I allow your addition of party applications and take up all the 3 petitions together
Great.
on a different day? I'll allow the addition of party application because of the reason that these people are in any event, they are respondents in your writ petition, you are respondents in their writ petition.
Yes, yes.
So let them be added in your writ petition. If you want, I can also add you to their writ petition. It's all the same. I'll hear out the 3 writ petitions together.
And my
Which
lord,
is the other item? Item 27.
27.
27, Lordship.
There, my lord, I have filed the vacating application.
Oh, there you have filed the vacating.
Ah.
I'll fix all the applications along with both the writ petitions together. I'll dispose of lock, stock, barrel.
Yes, yes.
The present application has been filed for addition in the writ petition, comma, of persons who have independently filed writ petitions, comma, having direct nexus with the subject matter of the present writ. Full stop. Next para. Upon hearing learned counsel, comma, it transpires that this writ petition, that is WPA 11356 of 2022 and WPA 26087 of 2022, comma, which is also appearing in today's list, comma, are on the self-same subject matter. Full stop. Accordingly, the two ought to be heard together. Full stop. Hence, comma, WPA 26087 of 2022 along with WPA 11356 of 2022 shall be listed together for hearing in the next monthly list, comma, along with the connected applications. Come back with the applications. Applications will get automatically disposed of. I'll decide the main writ petition.
Grateful, Lordship.
You have come up against challenging that proceeding against you. Or you don't know, sir. Yes. Very well. Come back. But you have to be prepared on the next date.
Obviously, Lordship.
Twenty-four.
24, my lord, I appear for the respondent opposite party.
Yes.
My lord, this is my application, my lord. However, my lord, I'm being led by Mr. Tanay Chakraborty. My lord, he is on his legs, my lord, in courtroom number 1, my lord.
What is the application for?
My lord, this is with regard to the summary statement, my lord, of September 2021, my
So
lord.
what is the prayer? This is an interlocutory application.
Yes, my lord.
It is for
My lord, for
restraint order.
my lord, that the DVC, my lord. My
Very
lord,
well,
that
Mr. Mukherjee, then they are not enjoying any.
there is a writ petition pending before your lordship, lord, challenging, lord, about the contract load variation and, lord, also, lord, the bill for a particular period.
Oh, that was not taken up for hearing as a motion even.
No, your lordship passed an interim order, lord, restraining us, lord, from appropriating, lord, the delayed payment surcharge portion
Right.
of that particular bill.
Yes.
Now, lord, thereafter, lord, they, lord, delayed payment and we raised bill.
Hmm.
Now, lord, after we raised the bill, lord, at the last page of, lord, the application, your lordship will find that they are, lord, page 47.
Hmm.
They are raking up, lord, a question that because of my lord's order, I should not be asking for the delayed payment surcharge for the period beyond, my lord, what your lordship had stated. Your lordship had stated, my lord, the realization for a particular bill, for a particular period.
Hmm.
Now that they are delaying payment, and when they are making delayed payment, and I, my lord, put them to surcharge according to the contract,
Hmm.
they say that because of the order and because of, lord,
No, these are subsequent delayed payment.
yes. Yes.
You are also in the matter.
My lord, I am.
I mean, how can that have a bearing? I mean,
Kindly have a
a
look at
particular
their
period
letter.
of delayed payment surcharge was challenged by you.
Yes.
Regarding that, I have passed an order of stay. On the base premise of that, you can. Subsequently, if you delay in payments, I mean, they are entitled. This is a new cause of action for them.
My lord, I am being led by Mr.
Very well, well, keep it next Friday.
As your lordship, please. My
An
lord, please.
adjournment is sought on the ground of learned counsel for the writ petitioner, although the respondents are represented through counsel. Push up next para. Learned senior advocate for the respondent submits that the cause of action for the application has no connection with the interim order passed initially. So be that as it may, comma, since an adjournment is sought, comma, let the matter stand over till September 8, 2023.
My lord,
8
the
September.
affidavit of service, my lord.
Affidavit of service filed today be kept on.
But made him, lord, Friday week.
Friday week, yes, very well. Adjourn till September 8 na kore, September 15th করে দিন তাহলে।
Grateful. Grateful.
15th.
Hmm.
25.
Please, your lordship. This is my application
Yes,
for
Mr.
addition of party.
Right.
Your lordship, I'm being represented by Devdutt Mukherjee. I'm praying for short pass over.
Bhai, Mr.
Devdutt
May I
Mukherjee.
just indicate what the matter is all about?
Sir, what Mukherjee?
Devdutt Mukherjee.
Devdutt Mukherjee. Madam, may I just indicate? This is my application for addition of party in the writ petition.
Yes.
The disputes between the writ petitioner and my client, my lord, my client had entered into an agreement for sale with the writ petitioner for sale of certain properties. Disputes arose, matters referred to arbitration. Their contention is that the properties value is 5 crores.
You are for the respondent.
I have made this application to be added as a respondent.
Oh, acha, very
Yes. So agreement between the to be added as a party and the main writ petitioner for sale of certain properties at a consideration. Disputes arose, referred to arbitration of 3 arbitrators presided over by Justice Ganguly. This agreement for sale were impounded and it was sent to the registry and they have found a valuation. That valuation is being challenged. My lord, I am a necessary party, my lord, because the valuation will affect my rights in the arbitral proceedings. And I am a party to this agreement for sale.
It's a revenue matter between the state and them.
My lord, but it will affect because 13
They have
crores.
to put in the amount.
They have
They are relying on that.
Yes.
You have no business to.
No,
bear.
on my property.
What, whichever.
My lord,
whoever's
I'll
property.
tell your lordship the reason why, my lord, because now the writ petitions are uploaded, we have found it.
Yes.
They had filled in a query by giving in a false information that the property is abutted by a road which is 4 feet wide. A 4 feet wide, my lord, hardly a cycle can get it. But if your lordship looks at the agreement for sale, it is actually abutting a road which is 40 feet wide. And they have suppressed those in the writ petition as well. My valuation will go down and my right in the arbitral proceedings, my lord, will be hampered. If I am added, nobody will be prejudiced. But if this valuation is set aside, I will be prejudiced.
Still, it remains an impounding matter.
Yes, yes.
Ultimately, they have challenged an order of
But
impoundment.
over my land, they say it's worth
You're
5
right.
crores. I say it's 13 crores because that's the government valuation.
You say whatever the valuation has been put, that is the correct valuation.
That is the correct valuation.
State has to represent themselves in that.
Yes, but I should be heard, my lord. I should be heard. I am a party to the agreement. Because
you're a party to the agreement, definitely. This is not something regarding the agreement. It's about the revenue payable to the state only.
On the basis of the agreement, my lord, my rights in the arbitration will be affected.
No rights. What right will be affected?
My lord, if it is set aside,
It will only be affected by an unforced error in tennis.
If it is set aside.
Yes, either way, because it will be an unforced error, because you can only gain advantage from the outcome of this or get no disadvantage as such. You are not affected. The only advantage you will get is that they will be put in a predicament because they have to put in higher stamp.
No. Not
only
that.
that.
Not that.
For impoundment,
I'll just show straight away one document.
No, your disputes in the arbitration.
No. Even here in the writ petition, my lord, kindly comes. I had filed an RTI to file the query which they have filed. My lord, kindly comes to page 427. Of this application. Page 427. What is the information which they have given? At the top, your lordship will find road name. I'm sorry. 427.
Right.
Green Park, 4 feet wide. My lord, and I'll just show, my lord. Just gives me a moment, my lord.
Yes.
My lord, 431. Green Park. Your lordship has found, my lord, 431.
Yes.
Green Park, 4 feet wide.
Right.
Now, my lord, again. 433. Green Park, 4 feet wide. And my lord, this document, this query, which is the basis of their writ petition, my lord, one document could have been missing. I could have understood. This is missing in each and every page. And who will indicate this? My lord, kindly is a writ petition with your lordship. My lord, I will show all these pages where they had put in. Just, my lord, bears with me for 2 minutes. My lord, kindly straight away comes to page 559. My lord, may I just trouble your lordship once again? My lord, just keeps this, my application, side by side. 427 with page 559.
Right.
My lord will kindly see, your lordship takes 426 of my application, partition such and such. Then at 427, your lordship will find Green Park, 4 feet wide.
Yes.
But in your lordship's writ petition, your lordship looks at 559. That particular information is missing. Green Park 4 feet wide. I will show the agreement why. Your lordship has seen this query?
Different document.
No, it's the same document. My lord will kindly see 466 Millennium Projects. Millennium Projects, my lord, everything. 11 Crooked Lane, everything. It's the same document. This I obtained under a right to information. It's the same document. My lord, that would be evident from the fact. My lord kindly comes to page 425. This is a reply to my RTI information. In inviting your attention to the above mentioned, the copies of requisition form. This is their requisition form. The lordship sees for
this tallies with 426.
426. Your lordship will compare. These are the documents, my lord, from 426.
426 and 559 exactly tally.
Yes, no, my lord, that's where the catch is. Now, my lord kindly turns to 560.
Yes.
427, your lordship has seen Green Park.
Right.
Well, this is missing in 559. There should have been that page. That is missing. First, one, I would have understood it's an error. My lord kindly takes page 560.
You say the premise, very premise that it is 4 feet. That is entirely wrong. So the valuation will be.
Yes, and they have, my lord, concealed this from your lordships in the writ petition. This page, this particular tally is missing. My lord, there were 3 agreements. One I would have understood was a mistake. 3 cannot be. Your lordship now.
So I'm only considering whether you are a necessary party. So on that, your allegation has to be the premise.
Yes.
That this is the allegation
Yes.
you are making. On that, whether you can be necessary party.
Yes.
Yes. Why should you? Why do you say that this shall not affect the valuation?
My lord.
And they may be
My
correct.
lord,
They may be incorrect.
I will be submitting only with respect to my lord.
Why should we add them as parties?
Add them as parties.
Yes.
Prayer A and B is for leave to file with short cause title, and prayer B is for us to furnish a copy of the writ petition to them. They have already pointed out various pages of the writ petition
Yes,
to my
it's
lord.
available online.
So
No, addition of party there.
now, second of all, my lord will see that their application, the only paragraph on the basis of which they have sought for addition of parties, paragraph 18 at page 12. My lord will restrict, my lord, their application to the contents of this paragraph. Page 12 at paragraph 18.
Yes.
The applicant states that the applicant is the co-owner in some plots and absolute owner in majority of the plots of the premises in respect of which the stamp duty has been assessed. The subject matter of the present writ petition is the said assessment done by the Office of the Collector of Kolkata, Government of West Bengal. In such circumstances, the applicant is materially interested in the present proceedings. Arbitral proceedings are also pending between the writ petitioners and the applicant concerning the said plots of land, the market value of the said plots of land, and misrepresentation by the writ petitioners, largely the issue in the said arbitration. My lord, this particular phrase, materially interested in the present proceeding, in my humble submission, cannot be a ground for addition as a party. The issue is whether the assessment has been done correctly or incorrectly. The state government the state representatives are there to make their submission. Whether I have given incomplete document or complete. If I have given incomplete document in the writ petition, the state authorities will point that out to my lord. Today, how can the petitioner in the application for addition of party be added as a party in the writ petition when the issue is between the writ petitioners and the state authorities? Today, even if it is affecting the rights of the petitioner, there are judgments which say that it has to be a necessary party. Has to be a necessary party, or otherwise has to show that the order if may be passed.
If they are a necessary party or proper party, that is only for the reason of pointing out the
that can be done for this
alleged suppressions.
Yes.
Only on that.
Yes.
Otherwise, I am not convinced.
Yes. Now, even if it was my submission that the document that I have annexed to the writ petition is an incomplete document, certain pages are missing. On the basis of the documents which we have submitted, the state authorities have assessed the stamp duty, my lord. If any document is missing, the state authorities will point that out. There is no allegation of collusion between me and the state authorities. In fact, I have filed the writ petition challenging the assessment of stamp duty by the respondent authority, by the state authorities. Where does my learned friend come into the picture here?
My lord, I have shown your lordship. My lord, I have shown your lordship. My lord, one second.
My lord will kindly decide this application on the touchstone of Order 1, Rule 10, my lord. May I just rely on a judgment on this respect, my lord?
We will continue after 10 minutes. Mr. Bhattacharya will continue.
My
পড়তে পারছি না এখানে এখান থেকে schedule of properties.
Yes. Yes. My lord, I was relying on a judgment reported in AIR 1974 Calcutta, page 358. My lord, will kindly look at the facts. I'm just placing the facts from paragraph 2 just once. The case made out by the petitioner is, as would appear from the affidavit of one Sudhanshu Kumar Sheel, affirmed on the 14th of September, such and such, in support of the petition, that she is a widow and a housewife residing at Calcutta. On 17th of May, 1969, she entered into an agreement with one Sanatan Kumar Do, the defendant number 2 in the suit, to purchase the property of the defendant number 2, a two-storied building at such and such place for a price of such and such. She paid a sum of rupees 2,000 by way of earnest money. The transaction was to be completed within 6 months from date. The petitioner was to advance further sums to the vendor from time to time if the latter would be in need of the same. It is further alleged that the petitioner up to 1st of August 1967 advanced rupees 13,000 by various installments. It is also stated that the defendant number 2 deposited the title deeds of the property at Calcutta and stated that by 2 letters dated such and such, corresponding to such and such, the mortgaged the properties to the petitioner. The defendant number 2 failed and neglected to convey the property to the petitioner. She claims that she is entitled to a charge on the said property. On 23rd of June 1973, for the first time, she came to know from the said defendant number 2 that the Honorable Court, by an order dated such and such, restrained the defendant from dealing with the said property till disposal of the present suit. Thereafter, on enquiry, she came to know about the present suit and the aforesaid order dated 9 September. The case of the petitioner is that she is a mortgagee or a holder of the charge on the property, and as such, she is an interested party in these proceedings. She claims to be a proper and necessary party as the transaction with the purchase of the property cannot be completed. Her interest is in jeopardy. So this is the factual basis on the basis of which, my lord, an application was made. And he turns over the page and comes to paragraph number 5. The two main questions involved in this petition are, firstly, whether the petitioner is to be added as a party defendant in the suit, and secondly, well, the second question is not relevant for our purpose. Now, my lord, paragraph 6 kindly comes to 11th line from the top of paragraph 6, where the quotation starts, it would appear, therefore. It would appear, therefore, that persons may be added as a party only in 2 cases, viz., when he or she ought to have been joined as a defendant and is not so joined. Number 2, when without her presence, the question in the suit cannot be completely decided. It is not even contended that the petitioner ought to have been joined as a defendant or that her presence is in any way necessary to adjudicate effectually and completely the questions involved in this suit. She is neither a proper nor a necessary party. Apparently, a person is not to be added as a defendant merely because he or she would be incidentally affected by the judgment. Reference may be made to the case of such and such reported in 1892, 1 Chancery Division 487. The test, as was laid down by Lord Justice Lindley at page 489, is whether the question at issue between the plaintiff and the defendants can be worked out without anyone else being brought in to take part in the action. Mr. R.P. Sinha, the learned counsel for the petitioner, however, cited 2 cases. One is Srimati Dhai versus Bhadarmal Hargo, reported in 1936, volume 40, Calcutta Weekly Note 677. In a suit brought against the firm and the firm name, a person who was not served with a writ of summons as a partner apprehended that the plaintiff would eventually seek to hold him liable in execution proceedings on the basis of partnership. He was held to be eligible to be added as a defendant. The facts of that case, however, are clearly distinguishable from the present case, as in the case of the person concerned was admittedly interested in the defendant firm. Moreover, the provisions with regard to partnership firm are different. Now, my lord, will kindly come to paragraph 8. The main consideration seems to be whether or not the presence of the petitioner is necessary to enable the court to effectually and completely adjudicate upon and settle the question involved in this suit. If the question at issue between the parties can be worked out without anyone else being brought in, the stranger should not be added as a party. As already stated before, the petitioner cannot be considered to be a proper or a necessary party. That she may eventually be affected by the judgment or in the execution decree against the defendant number 2 is not a cogent ground to make her a party, as was pointed out by the Supreme Court in the case of Deputy Commissioner Hardoi versus Ramakrishna, as reported in AIR 1953 SC 521 at page 526. The eventual interest of a party in the fruits of litigation cannot be held to be a true test of impleading parties according to the Code of Civil Procedure. A compulsion other than one based on positive rule of law upon the plaintiff to litigate against a person not of his own choice must be unfair. Reference may be made in such and such. So, my lord, on the basis of this judgment, I am humbly submitting, as I have understood from the submission made by my learned friend, that she is interested in the outcome.
it has been clearly held that even if one is interested in the outcome, that is not a cogent ground for being added as a party. One must see the test is whether without the presence of my learned friend, this writ petition can be disposed of or not. In the writ petition, I have challenged the assessment of a stamp duty. The respondent authorities are there. They will make their submission and the matter will end there. My learned friend's presence is not at all required. And these are my
Suppose if they want to point out any discrepancy in your contention before the authorities, what is the forum for them? Is there any scope of appeal?
Yes, it's an appellable order under 47A.
And I would
Under
humbly,
47A of the Stamp Act, it's an appellable order.
my lord, if they want to point out anything, they have already written the letters to them. They have received the information through RTI. If they want to point out, they have already, whatever correspondence they are required to issue, they have issued it. On that basis, this has started. But my lord, the pure question here is whether the stamp assessment has been made correctly or incorrectly. Today, if it is found that I have perpetrated some fraud or I have suppressed some document or anything, that my lord, the respondent authorities will themselves consider. They can, the statute provides that they can visit the site, whether it is 4 feet or 6 feet, whether it is near to one road or other road, and the inspections will be carried out. For that, the presence of my learned friend is not required. Otherwise, every assessment, my lord, every party can come in. And the litigant here, my lord, the party who's trying to add themselves as party, there's the arbitration. What is the arbitration? In the arbitration, I have sought for specific performance of an agreement for sale. My learned friend has agreed, has executed 4 agreements for sale with me, has taken 25 lakhs, and then outrightly refused to do the conveyance, my lord. For that purpose, I've initiated the arbitration. So, my lord, this is just trying to put a spanner in my assessment of the stamp duty. I am willing to do it. The document has been impounded. I will be paying but I want to see the correctness of the assessment, my lord. Now, whether the party will have anything to say in that or not. And this is my humble submission.
One other question to you. 47B is the scope of appeal, as Mr.
47B, my lord, I would humbly submit.
47B is any concerned person aggrieved by an order passed under subsection 5 or subsection 8 of section 47A may prefer an appeal to such appellate authority. Now, any person, if within the broader purview, they also come in because they are incidentally affected, suppose. If they come in, then where is the scope of appeal? I mean, first of all, you could have preferred an appeal. That is a point which I'll ask you when I take up the writ petition. That appears to be an apparent bar. And if you are not barred, then if I decide something, whichever way, where is their scope of further appeal? They won't get that opportunity of appeal.
My lord.
Now, this any concerned person argue on this also.
Whether the appeal will at all lie or not. 47B says, my lord, any concerned person aggrieved by an order passed under subsection 5 or subsection 8 of section 47A. My lord, I stop here for the moment. Kindly turn over the page to section 47A.
Yes.
Instruments of conveyance, etc., undervalued, how to be dealt with. Where the registering officer appointed under the Registration Act 1908 has, while registering any instrument. So when the document is presented for registration, here, my lord, we have not presented the document for registration, my lord. It is insufficiently stamped. So, my lord, at the time of presenting the document, now my lord will kindly look at subsection 3 and subsection 5, from where, my lord, appeal can be preferred under section 47B, subsection 1. Subsection 5 is, on receipt of a reference under subsection 3, we go back to subsection 3, where the concerned person does not make payment of the stamp duty as required under subsection 2. This subsection 2 assesses the stamp duty when the document is presented for registration. The document not having been presented for registration, my appeal will not lie at all, my lord. Today, that date has not yet come. Had they agreed and they had paid we would have paid the entire conveyance amount, the consideration amount to them, and we had presented the document for registration, and then the registering authority assessed the stamp duty. From there, my lord, I could have preferred an appeal. That stage has not yet come, my lord. That's why I have preferred this writ petition.
Great. Let me. Yes, yes, sir.
2 factual aspects, my lord, I just want to take your lordship through. You know, the entire dispute in the arbitration is with regard to valuation. They say 5 crores, I say 13 crores. How do they arrive at the valuation of 5 crores? I have shown on the basis of the information provided to the authorities that the road abutting the properties are 4 feet, which is incorrect. And this is what they have suppressed in the writ petition. My lord, kindly comes to page 73 of my application. My lord, will kindly see this is the scheduled property.
Yes.
My lord, will kindly come down on the west by NSC Bose Road. It is a 40 feet road. It is not Green Park, which is a 4 feet road. The valuation changes considerably. This is the entire bone of contention before the arbitration. Now, my lord, kindly take section 47A. We had raised this point before the learned arbitrators and filed an application under 32(2)(c) for termination of the mandate because the proceedings have not continued after December 2021. Now, my lord, kindly takes 47A. My lord, first take subsection 2. My lord, it's clearly an appellable order where the market value of the property, which is the subject matter of the instrument, has been ascertained. Here, the authorities have ascertained that the market value is 13 crores and the proper duty chargeable thereon has been computed under subsection 1. The registering authority shall, in the manner prescribed to the concerned person, a notice calling upon him to make payment of the deficit amount of stamp duty within such time as may be prescribed. And if such person makes payments of such deficit, the registering authorities shall register the instrument. When the concerned person, my lord, here, subsection 3, does not make payment of the stamp duty as required, he is not making payment. Unless he makes payment, that document cannot be looked into.
For the purpose of registration.
Not just for the purpose of registration. My lord, registration has a different aspect. Stamping has a different aspect.
Section 1 starts with that.
Yes, but
my lord, starting point for 47A.
My lord, that is for purpose of registration. But my lord, here it also.
So thereby I mean to say, Mr. Bhattacharya, why
my
not?
lord will kindly
Why
see the
not?
heading.
Why not? You will have another opportunity when the document is sought to be registered, if at all.
My lord, now the question is, my lord, there are two aspects. There are two aspects. One is Registration Act. One is the Stamp Act. Both are related somewhere intrinsically. Both are related to each other.
Yes.
My lord, unless the document is impounded and my lord, the stamp duty thereon is paid, the document cannot be admitted in evidence under section 33 and 35 of the Stamp Act.
Yes.
So, my lord, that's the purpose the arbitrator impounded them and sent it to the collectorate for the purpose of assessment of the stamp duty and for payment of the stamp duty. These powers have been exercised under 33 and 35, which the arbitrators were within their jurisdiction to do so. My lord, kindly
35, where is the scope of a third party interfering in either 33 or 35?
33, 35, third party need not. The court so motu. Even if a party does not take the point, your lordship kindly takes 33.
That is the point against you in your addition of party application.
That has to be
Which you could
impounded.
write.
No, where my rights are affected, as your lordship pointed out under 47B.
That comes incidentally once the duty is assessed.
Yes, my lord, here the duty has been assessed.
Yes, therefore, what is your right to? They are challenging that assessment.
So they should have preferred an appeal. They should have preferred an appeal. My lord, had the.
We are hearing your addition of party application. Where is the question of your interfering?
My lord, I'll tell your lordship. Had today the assessment authority held that the property is valued at 5 crores, not 13 crores. How would I have gone? How would I have been aggrieved? I would have been aggrieved by that assessment order because that would have had a bearing on my arbitral proceedings. I would have had to file an appeal under 47B. The valuation would have changed. My rights would have come under 47B. That's why it says any person. It is not restricting to any aggrieved party. Any concerned person aggrieved by. It is not saying the assessee. It is not saying the assessee. I'm sorry, my lord, it's not aggrieved. Any assessee. It says any concerned person aggrieved.
Yes.
Had the collectorate assessed it at 5 crores, I would have been aggrieved because I say it's 13 crores. You go on the basis of the schedule of the property. He had given you a wrong information. So the stamp duty would have changed. On the stamp duty is payable on the valuation of the property. My lord, if not anything, I am at least a proper party. My lord, may I rely on a decision of the Supreme Court report?
Not in reply.
My lord. Only thing, my lord, 76 Calcutta, my lord, I will show one thing. So this was a suit for mortgage.
That is also in reply.
No, he showed it. I need to distinguish it.
Distinguish it, distinguish his judgment.
Yes.
Don't show another judgment.
No, I'm distinguishing his judgment.
His judgment. Oh, very well. Yes.
Paragraph 6, it is clear
Yes.
from the, I'm sorry.
No, please.
Paragraph 6.
Paragraph 6, yes.
It is clear from the petition and the affidavits noted above that the petitioner wants to be added as a party only because she has agreed to purchase a property.
Facts were different.
Facts were completely different.
They're completely different. He relies on the ratio.
Here, my lord, I am the owner of the property. Admittedly.
You are the owner of the property.
Yes.
And he is the
He is a intending purchaser.
I'm the agreement holder, my lord.
Oh,
He is the
exactly.
intending
Right.
purchaser.
This is the agreement, right? Yes, very well. Yes. I refuse. Learned counsel for the applicant, at addition of party application to Learned counsel for the applicant contends that the applicant is the owner of the property, comma, the assessment of stamp duty regarding which has been assailed in the main writ petition, and comma, as such, comma, is a necessary party, full stop. It is argued that the document in question is a purported agreement for sale, comma, against the assessment of stamp duty of which the present writ petition has been preferred, full stop. However, comma, learned counsel, by placing reliance on certain annexures to the application, comma, argues that the writ petitioner has suppressed several relevant facts relating to the subject matter of dispute, comma, before the collector. First up, it is contended that the document was sent for impoundment in connection with an arbitral proceeding, full stop, next para, before the collector, comma, at the time of assessment, comma, an impression was given by the writ petitioner that the property was bounded by a 4 feet wide passage, comma, whereas it is actually bordered by a 40 feet wide passage, full stop. That apart, comma, several other suppressions of material facts have been perpetrated by the writ petitioner, comma, it is argued. Full stop, next para. In any event, comma, apart from being the owner of the property, comma, it is argued that the present applicants have a right to be impleaded as respondents in the present writ petition, comma, since the contentions of the applicants in the arbitral proceeding has a direct nexus with the subject matter of the present writ petition. Push up, it is contended that the crux of the dispute before the arbitrator is the valuation of the property, comma, of which the assessment of stamp duty is an essential component. First up, it is argued that the outcome of the writ petition, comma, either way, comma, shall directly affect the applicants, and, comma, as such, comma, the applicants are necessary parties. First up, next para. Controverting such arguments, comma, learned counsel for the writ petitioner cites judgment of a learned coordinate bench of this court in Narayan Chandra Gorai and others versus Matri Bhandar Private Limited and another, reported at AIR 1974 Cal 358, comma, where the learned single judge expounded the propositions of law with regard to necessary and proper parties, comma, vis-a-vis Order 1, Rule 10 of the Code of Civil Procedure. Push up, next para. Learned counsel for the writ petitioner further contends that the present applicants are neither necessary nor proper parties for the purpose of the present writ petition. Push up, next para. Insofar as the appeal under section 47 capital A of the Indian Stamp Act within bracket as amended in West Bengal bracket close is concerned, comma, it is argued that it is premature to apply the said provision, comma, since the same arises only where the document is presented for registration. Full stop, next para. Learned counsel appearing for the applicants, comma, in reply, comma, contents that the applicants are concerned persons within the contemplation of section 47 capital B of the Stamp Act, full stop, hence, comma, in the event the writ petition is allowed, comma, the applicants shall have no forum to ventilate their grievances, comma, since there is no further appellate authority if the order of the uh, collector is reversed by this court. Full stop, next para, in any event, comma, it is contended that an appeal lay under section 47 capital A of the Stamp Act for the petitioners, comma, which debars the maintainability of the writ petition itself. Full stop, next para. Upon hearing learned counsel for the parties, comma, the essential consideration is whether the applicants are necessary or proper parties herein. Full stop, the proposition as laid down in Narayan Chandra Gorai Supra is well settled, comma, insofar as the fact that a person may be eventually affected by judgment or in execution of a decree is not a cogent ground to make her a party. Full stop, as held in the said judgment, comma, the eventual interest of a party in the fruits of litigation cannot be held to be a true test of impleading parties according to the Code of Civil Procedure. Full stop, a compulsion other than one based on positive rule of law upon the plaintiff to litigate against a person not of his own choice must be unfair. Full stop, next para. There is no dispute with the proposition as laid down in the said judgment. Full stop, next para. The question is whether the same tests are satisfied by the present applicants. Full stop, next para. It is well settled that the assessment of stamp duty is a matter of revenue, comma, between the authorities and the person who deposits the stamp duty. Full stop, next para. No third party has any right of being heard in such assessment procedure. Full stop, next para. Although learned counsel for the applicants has placed reliance on sections 47 capital A and 47 capital B of the Stamp Act within bracket as amended in West Bengal, bracket closed, comma, the writ petitioner is justified in arguing that the said stage has not yet come. Full stop, there is a clear distinction between an appeal under section 47 capital A and the stage of adjudication under sections 33 and 35 of the Stamp Act. Full stop, section 47 capital A clearly stipulates that where the registering officer appointed under the Registration Act 1908 has, while registering any instrument as specified therein, comma, reason to believe that the market value of the property has not been truly set forth, comma, the entire provision comes into play. Full stop, section 47 capital B again, comma, refers back to an adjudication under section 47 capital A, comma, thereby circumscribing the right of appeal to the provisions of section 47 capital A, comma, which arises only upon the registering officer being in bona fide doubt, comma, within the contemplation of the Registration Act 1908. Full stop, next para. However, comma, as opposed to the said stage, comma, the present adjudication was within the contemplation of section 33 of the Stamp Act. Full stop, nothing in section 33 of the Stamp Act confers any right on a third person to be heard before such assessment being made. Full stop, the clear language of section 33 elucidates that every person having by law consent or authority, having by law or consent of parties authority to receive evidence, etc., before whom any instrument chargeable in his opinion with duty is produced, comma, shall, comma, if it appears to him that such instrument is not duly stamped, comma, impound the same. Full stop, next para. Going a bit back, comma, Section 31 of the Stamp Act contemplates adjudication as to proper stamp and provides that where any instrument, comma, whether executed or not, and whether previously stamped or not, comma, is brought to the collector and the person bringing it applies to have the opinion of that officer as to the duty which is chargeable and complies with formalities, comma, the collector shall determine the duty, if any, with which in his judgment the instrument is chargeable. Full stop. For such purpose, comma, the collector may require to be furnished with an abstract of the instrument and other documents as indicated in subsection 2 of section 31. Full stop. Next para. Thereafter, comma, the collector shall issue a certificate under section 32 of the said act. Full stop. Next para. On the other hand, comma, section 35 provides that no instrument chargeable with duty shall be admitted in evidence for any purpose, comma, without being duly stamped. Full stop. Next para. Section
38, if your lordship. kindly-
Yes, thank you very much. Section 38 of the Stamp Act provides that when the person impounding an instrument under section 33 has by law or consent of parties authority to receive evidence and admits such instrument in evidence upon payment of a penalty as provided by section 35 or of duty as provided by section 37, comma, he shall send to the collector an authenticated copy of such instrument together with a certificate in writing, comma, stating the amount of duty and penalty levied in respect thereof, comma, and shall send such amount to the collector or to such person as he may appoint in this behalf. Full stop. Next para. In every other case, comma, subsection 2 of section 38 provides, comma, the person so impounding an instrument shall send it in original to the collector. Full stop. Next para. The collector also has a power to refund the penalty paid under section 38, comma, within the contemplation of section 39. Full stop. Section 40 provides that when the collector impounds an instrument under section 33 or receives an instrument sent to him under section 38, not being a 40 take it in. Next para. Thus, comma, a conjunctive reading of the entire provisions pertaining to assessment of stamp duty by the collector clearly shows that there is no scope of giving any hearing to any third party at any stage. Full stop. Next para. The present writ petition concerns the assessment of stamp duty upon a document being impounded, comma, and as such does not leave any scope of any third party interference at this stage. Full stop. Next para. Although the applicants herein may be incidentally or collaterally affected by the stamp duty being assessed either way, comma, since if the document is since the evidentiary value of the document depends on it being properly impounded, comma, nothing in the assessment shall prevent the respondent, the applicants herein from raising the question of admissibility before the arbitral tribunal. Full stop. Be that as it may, comma, whatever may be the rights of the applicants herein, comma, they are neither necessary nor proper parties in the present writ petition, comma, since the same pertains merely to assessment of stamp duty, comma, which is a matter of revenue between the state and the person depositing the duty. Full stop. In such view of the matter, comma, there is no scope of adding the applicants as parties to the writ petition. Accordingly, Can 1 of 2022 is dismissed on contest without any orders to cost.
Would it be a lordship's pleasure to at least hold that the applicant can be at least heard?
Mr. Bhattacharya, I've obliquely referred to that in my order that you have a right of taking an objection as to evidentiary value and all these things. but I won't go beyond that. Whatever I say would operate against either you or him. In fact.
Grateful to
Thank রিট পিটিশনটা আর কিছু তো দরকার নেই, অ্যাপ্লিকেশনটা মেনশন করলে তখন পেজ
26.
I beg to appear for the petitioner, my lord. Applicant, my lord.
For the added respondent, not bank.
Two applications are there, my lord. Application 1, my lord, is for expeditious hearing of the writ petition, my lord. And application number 2 is, my lord, for extension of interim order, my lord. Kindly take, my lord, application number 2, my lord. Can number 2, my lord. My lord, here, my lord, the petitioner, my lord, is a, my lord, trader, my lord, of textile, my lord. He is an importer and exporter, my lord.
Interim order. It's on a LOC issue, my lord. Your lordships have decided that, my lord. We'll,
LOC?
Yes, my lord.
Yes, my
We'll use an affidavit in opposition to that, my lord, because we have something to say.
What is the interim order?
Lord, the interim order is that will be.
I can go to foreign country. I can go travel for abroad, my lord. I can travel abroad. That is the interim order, my lord. Kindly.
If you're agreed by that, I'll terminate that.
My lord, my lord,
But it's a question of extension. I mean, what was the order? Let us
extension
see.
is there, my lord, because, my lord, I have been restrained, my lord, by the immigrants, my lord. Again, my lord.
Show me
After
that
this
order. What is the date of that interim?
Yes, my lord. Page, my lord, 13, my lord. Passed by Honorable Justice Lopita Banerjee, my lord. From, my lord, third line, my lord, your lordship, third paragraph, my lord, this is the relevant, my lord. From there, my lord, your lordship, find, my lord.
The written instructions.
No, my lord, for interim order, my lord, it is recorded, my lord. They came, my lord, and said.
Third paragraph starts with from the written instructions.
From the, yes, yes, that's right. Kindly see, my lord, there is no impediment, my lord, in my traveling, my lord. It's their instruction.
It has been observed. They have stated that they
Yes, my
don't
lord.
want to prevent you.
But even then, thereafter, my lord, my lord, when, my lord, on view of that order, my lord, I was allowed to go, my lord, on 30 November. I returned on 4th December. Thereafter, but again, my lord, I intimated the SPI, my lord, on 7th February that I will go to Laos, my lord. My lord, the immigrant, my lord, had restrained me, my lord, on 16th February 2023. They did said, my lord, this is.
So where is a question of extension? You can file a contempt before Justice Banerjee.
We filed that contempt, my lord. There, my lord, they argue, my lord, that this was an interim order and it was only for the purpose of first time on that time. But it was accepted, my lord. The
Contempt was dismissed.
Dismissed. But that order is also there, my lord.
So then what remains?
So, my lord, I have to come before you, lord.
Sarafin, there is a question of extension of the interim order. It is a question of extension.
But
The interim order is there till there is no time limit to that interim order.
But kindly see, my lord, how it has been interpreted, my lord. But kindly see, my lord, that
The contempt application has been dismissed. I cannot reinterpret that.
But what we were told, my lord, that we have to come before your lordship, my lord, and this interim order is required to be extended, my lord. Then only we can go out, my lord.
Who told you? Who told you that?
My lord,
You are told me
by my lord, the Honorable Justice, my lord, the judge, my lord, where the contempt was pending, my lord. And my lord, kindly see, my lord, I have also annexed that order, my lord. That
Sir Rai was the architect of this or Mr. Vajpayee?
Mr. Vajpayee.
Was the architect of that order? This impatient?
My lord. No, my lord, kindly see, my lord, thereafter, my lord, to page 17, my lord, I have, my lord, business opportunities, my lord, where, my lord, I required to go out, my lord.
Mr. Arfin, let us be very clear. I'll dispose of the extension application by saying there is no scope of extension because it is there. It's not a limited order at all.
My lord, kindly may observe that, my lord, that will do, my lord.
I definitely will. And what about can one? Early hearing?
My
Lord, affidavits have to be directed, Lord, because I am the.
I'll direct affidavits. Let the matter come up. I'll fix some date. I mean, I'll give some date.
Only protect us to that effect, my lord. We can go out, my lord, because your lordship had seen, my lord, there is no impediment, my lord, in going out, my lord.
Can 2 of 2023 is taken up first? Full stop.
My lord, only they see that wherever I will go, my lord, I have to be informed.
He has taken loan from the bank. Bank is directing us and there is LOC. And now the bank will decide whether the loan has been repaid or not, and there is no interim order.
Although the application has been captioned as one within double inverted for appropriate order, double inverted close, comma. At the time of moving the same, comma, learned counsel for the writ petitioner submits that the same is for extension of the interim order granted earlier in the writ petition. Full stop, next para. It is alleged that despite the clear observations of the coordinate bench in order dated October 20, 2022, that there was no fetter on the petitioner leaving the country, comma, the petitioner has subsequently been prevented from doing so. Full stop, next para. It is now heard learned counsel for the parties. Full stop, it is seen from the order dated October 20, 2022, comma, that the learned single judge had observed that since the foreigners regional registration office and the legal bureau of immigration have no issues with regard to the petitioner traveling abroad, comma, once the intimation of his arrival is given to the originator stroke SBI, comma, the court found no impediment in allowing the petitioner to travel abroad. Full stop. However, comma, as a measure of abundant caution, comma, the originator is to be informed as to the dates of travel as well as the places of travel that the petitioner wishes to undertake. Full stop. Next para. Subsequently, a contempt application was moved, comma, which was dismissed with the order dated July 28, 2023. Full stop. Next para. It has been submitted by the petitioner that the impression was that the petitioner was to obtain an extension of the interim order. Full stop. Next para. But Mr. Rai and Mr. Bajpayee, your specific instruction was the impression given by you was on your behalf was that
I was not a party there, my lord. I have been added as a party.
You are?
Subsequent to this.
State Bank of India.
My lord. I was added as a party, my lord, subsequent to this order, my lord, and by dint of this order, my lord.
But this order has not been challenged.
No, no.
So this order remains.
No.
Yes, yes. This order
Yes.
remains, my lord, but
So there is no bar if they inform the originator. There is no bar still now.
But that was restricted to only for Laos.
No,
For travel.
not only that. These findings are also there.
No, in the writ
Every
petition-
time he has to give information to you.
Yes, that is true.
To them.
That will
But
do.
the writ petition was only
Next para.
for Laos.
Although learned counsel for the respondent authorities, that is the Union of India, although learned counsel for the Union of India submits that the leave granted to the petitioner to travel abroad was only on the occasion as dealt with in the order dated October 20, 2022, comma,
My lord.
it transpires from the findings of the same that the Foreigners Regional Registration Office and the Bureau of Immigration themselves intimated the court that they have no issues with regard to the petitioner traveling abroad, comma, once the intimation of his arrival is given to the original stroke SBI within bracket the added respondent, bracket closed. Full stop. In such context only, comma, the court had observed that it found no impediment in allowing the petitioner to travel abroad. Full stop. Next para. Only, comma, as a measure of abundant caution, comma, the originator was to be informed as to the dates of travel as well as the places of travel that the petitioner wished to undertake. Full stop. Next para. Although a specific observation was made granting the petitioner leave to travel to Laos subject to the riders as indicated above, comma, the tenor of the order itself indicates that there is no bar to the petitioner traveling abroad even on other occasions, comma, subject of course to compliance of the instructions as intimated by the Bureau of Immigration. Full stop. Hence, comma, it is found from the order dated October 20, 2022, comma, that the same clearly permitted the petitioner to travel abroad, comma, not restricted to a particular occasion, but till disposal of the writ petition, comma, subject to the petitioner giving intimation of his arrival, to the originator stroke SBI and that the originator is to be informed as to the dates of travel as well as the places of travel that the petitioner wishes to undertake. Full stop, next para. Upon a proper construction of the said order, comma, the petitioner is entitled to travel abroad till disposal of the writ petition, comma, subject, however, to the petitioner, comma, on each such occasion of the petitioner leaving the country, comma, to intimate the originator stroke SBI ahead of sufficiently ahead of such leaving, comma, as to the date of traveling and the exact places of travel that the petitioner wishes to undertake. First, moreover, comma, the petitioner, comma, upon returning from abroad, comma, shall also intimate the SBI on each such occasion as to his return. Full stop, next para. In such view of the matter, comma, no further order of extension is required. Full stop. Can 2 of 2023 is disposed of accordingly. Full stop. Next para. Can 1 of 2023 has been filed for early hearing of the writ petition. Full stop. The said application is allowed, comma, directing the writ petition to be listed for hearing in the next monthly list. That is the monthly list of September 2020. Monday.
Have not been directed.
Achana, sorry. By directing, disposal by directing the writ petition to be listed on September 25, 2023. Full stop. The respondents shall file their affidavits in opposition by September 18, 2023. Full stop. Reply, if any, shall be filed on the next returnable date.
Grateful.
I am grateful.
Deeply.
Thank you.
28. I appear for the respondent numbers 1 to 3, Malud.
I'm here for the petitioner. Writ petitioner.
Whose application for
recalling, because
you are for
I'm for
in the writ petition?
Private respondent number 4 in the writ petition. The writ petition was disposed of ex parte. I should not say ex parte. It's upon notice, but the learned advocate could not appear on the day when the writ petition was being disposed of.
Yes, you are going to say something, Mr.
Yes, because I generally do not oppose recallings if it's ex parte.
No, this was on merit.
Recent order, the learned junior of the senior engage was there. My lord, she did not come forward, and my lord, several other subsequent events have happened.
So let them move the application.
Only one thing, since I have been wrongly briefed in the matter, because the company matter, being an appellate side advocate, I should not open my mouth.
Don't tell that in this court. Wrong code.
No, the Mr. Banerjee is leading me in this matter.
Which
if your
Mr.
lordship is about to
Which Mr. Banerjee?
Shuddha Banerjee is leading me. But if your lordship wants to hear out the main matter on merits, then your lordship keeps it on the next week.
After
Otherwise,
that
on
submission
request
of yours, Mr. Mukherjee, both you and I will be embarrassed after the So let us wait for Mr. Banerjee. I'll take it up next Friday.
Next Friday.
Next Friday. Every Friday I take up this app.
Great.
I'm so great.
On the prayer of the applicant, the matter is adjourned till September 8, 2023. Affidavit service filed today be kept on record.
My lord, I have only one submission.
Yes,
my lord.
you are seeing the fun of it. I mean.
No, I have only one submission which is very serious, my lord. Mr. Tiwari has been aggrieved by the last order of my lord. Ekbadin order.
What did I say?
My lord, kindly sees the spelling of Mr. Tiwari, my lord. And for he will not be, my lord, enjoying the fruits of this order, my lord. That needs
Ask him to get another PAN card.
Nah. তুই বুঝবি না এই ব্যথাটা ওর। We are aggrieved to this extent, my lord, for my junior, my lord.
Grateful. Yes, Mr. Tiwari, you have to pronounce that for me to change that order.
Whatever is written.
Whatever it is. I don't know how this happened. And Mr. Tiwari, take some advice from me. Don't get influenced by Mr. Banerjee's these things. I mean, he tries to. I mean, he's influencing you, manipulating you to be depressed.
Great. 29.
29, yes.
For the applicant, respondent applicant. This is an application for my lord vacating of interim order.
Mr. Mukherjee obtained the order.
No, my lord, I am for the, I know, my lord, I am
Vacated.
not.
Yes.
But in fact, this
I
order
am
was,
for the WBACDCL, writ petitioner has to be present. before.
your lordship's order was passed on May 12th, 2023. That was till 30th of June, 2023. In between, I filed this application for vacating of interim order. Now that expired. That has not yet been extended. I am not getting my electricity due to this writ application.
Not extended, not extended. That is not there.
Nobody is not taking any step.
No, I'll take the
Your
chance. I'll
lordship-
say
your
the vacating
lordship-
has become infractuous.
Your lordship was pleased to pass an order in my favor, in my writ application. Accordingly, they were going to effect connection. At that juncture,
this was your writ?
No, in my writ petition order was passed.
Different writ.
Yes, subsequent that matter they came before your lordship.
If the interim order has expired, it has expired. Why do you want a seal of court? And the vacating has also been
That's
rendered
become-
infractuous.
Yes.
Why have you annexed these photographs?
Because what they said, this is the first connection which is being made of 11 kV. Now there cannot be without permission. But I annexed this document to show that there were two existing lines. One is of 30 kV, 33 kV, and there is 440 watt. So there cannot be any new permission. They cannot impress this court showing that or making that argument. That there is a mosque of 100 persons are there in a masjid or mosque. So nothing can be done without permission. But already existing two connections are there. And those are, one of them is higher than us.
The mosque was the writ petitioner.
No, the local people who are claiming something from me, which I couldn't satisfy.
What happened, my lord, pursuant to your lordship's direction, when the date has been fixed for giving connection, they moved the unlisted motion. Now, my lord, your lordship asked me to appear, and your lordship found, my lord, your lordship kindly see your lordship's own order, my lord, 12th May 2023. Your lordship recorded the reason for which, my lord, that my lordship grant stay, so that, and also restrain us not to provide the connection. And if your lordship wants see the order of your lordship, my lord.
Oh, prior approval has not been taken and all these things.
But when there is existing two connections, my lord, no further approval is required. For the first time, my lord, affecting service.
No, I'll just record. I'll not go into the merits of
Yes,
it. It a can one. The vacating application bearing can 1 of 2023 has been filed with a prayer for vacating the interim order dated May 12, 2023, passed in WPA 11810 of 2023. Full stop. However, comma, it transpires that the said order itself has expired on June 30, 2023, or until further order, comma, whichever is earlier. Full stop. Next para. Hence, comma, the vacating application has automatically been rendered infructuous since the interim order dated May 12, 2023 was not extended further. Full stop. Accordingly, can 1 of 2023 is disposed of as infructuous in the light of the above observations. The writ petition shall be listed in the monthly list of October 2023. I put in these observations. In the light of that observation, it has become infructuous. Therefore, obviously, the order is no longer there. You can take steps.
I have to come with a contempt application in my petition.
Yes, but better inform them that this has happened today.
Yes, yes.
Keep something on record.
Yes, ma'am.
Because otherwise, my lord, if we file contempt, we will face contempt. Now, my lord, in view of this order, my lord, we are also not providing connection.
To save your skin, Mr. Mukherjee, you can also communicate this order.
Great, ma'am.
Communicate for this order.
But affidavit service will kept on record.
It is signed today.
Grateful, lord.
Top item 30.
I appear for the repetition.
Yes.
Milord, in this matter, Milord, I have questioned, Milord, the propriety of a Milord, the tender notice, more particularly the amendment thereof, Milord, that has been brought about on 30th August, Milord, 2023. That is at page, Milord. It's the paragraph, Milord, I have said, Milord, in paragraph.
You're for the other side, the authority.
And for the respondent numbers 2 and 3, my lord, the authority, and
yes,
and I'm led by Mr. Chaudhary, my lord. My learned friend may begin. I'll make my submission.
Yes, yes.
Yes, Milord. Yes. Oh, Amar Victor.
Yes.
Milord, I request your lordship, Milord, that to kindly, Milord, come to Milord, page, Milord, 106.
Yes.
Milord, 37, Milord, sorry, Milord, 37, it gives a, my lord, 3 dates. 14/8/2023, that is the bid submission commencement date.
Mr.
28th
Das,
of-
please take your seat. Yes. Page 37, Mr. Basu.
Yes, my lord.
Yes. Page 37, right?
Yes. Page 37, my lord, it gives, my lord, 3 dates. 14th August 2023, that is the commencement of bid submission. 28th August 2023, bid submission, that is the last date of bid submission. And 31st August 2023, my lord, that is the opening date of the bid. Now, my lord, when the matter was last taken up by your lordship, Mr. Chaudhary, my lord, said that the time was extended. Now, my lord, the tender document, my lord, that was floated on, my lord, the May 2023, I was not agreed by that. Now, my lord, on August 2023, 3rd August, my lord, a particular clause 6C and 6C, which is at in the pleading, my lord, I have stated at, my lord, page 9. Page 9, para 9.
What are
My
the
lord,
clauses?
my lord, it starts from, my lord, page 8. May I read from, my lord? My lord, the first tender, my lord, that is the original the document, 23rd May 2023. It says, my lord, only 2 clauses, my lord. Technical capacity 6C or I, the bidder should have experience of handling similar comprehensive maintenance of biomedical equipment project in any state of India during the last 3 financial years, 2019, 20, 2021, 21, 22, 21, 22, 22, 23, certified by the opening authority, competent authority, respective of the competent authority of the respective facility, wherein the project value should be at least 240 crores, 240 crore cumulative for 3 years.
What is the
The
difference?
amendment, my lord,
What is the difference?
amendment same, my lord.
What
No,
is
my
the
lord,
difference
which one?
between the original and the
No.
amended?
This is, my lord, huh? These clause and 38 and 23rd May, these are same. It starts from, my lord, difference starts from, my lord, page 9. The bidder should have experience of handling similar comprehensive maintenance of biomedical equipment.
Page 8, 6C1 is same.
Same.
Why did you read it out?
No, my lord, because I have said so, my lord, because this is
You have not read your brief at home.
no.
Why did you read out this?
My lord, read out this, my lord, in the pleading, my lord, I have said, my lord.
That these are different.
No, these are not different, my lord. I have said, my lord, because
They exactly same, and I
my lord,
followed the
29, my lord, 9, my lord, I have said the bidder should have experience of handling any single biomedical equipment maintenance project.
Only the handling remains the same.
Yes.
Yes. What else? Yes. You're laughing, Mr. Basu.
The bidder should have experience of handling similar comprehensive maintenance of biomedical equipment project in at least 10 health facilities, each having minimum capacity of 500 beds during the last. But the question, my lord, is here, the bidder should have experience of handling any single biomedical equipment maintenance project, rupees 100 or crore. Kindly says, my lord, this particular aspect, bidder should have experience, and this part and this part is quite, my lord, there is starking difference. Now, my lord,
Previously, it was comprehensive maintenance of handling similar
Yes.
comprehensive maintenance
Yes.
of biomedical
Yes.
equipment project.
yes,
Now it's single biomedical equipment.
yes,
Where it has to be
yes,
clear.
and my lord, kindly, my lord,
Yes.
of 100, instead
what-
of in a rules, 180 crores year for 3 years.
this valuation was not
Is
there.
not there. Now, my lord,
Acha, very well. Yes.
my lord, in subclause, kindly, my lord, takes pain to turn, my lord, page 10.
No, the capacity was given 1,000
Yes.
beds instead of that.
That is,
20,000.
but the valuation, my lord, from
Correct,
this is,
right.
my lord, the 180 crores.
Different yardsticks.
Yes, different yardsticks. Now,
Yes.
my lord, this was, my lord, my respectful submission
Yes.
in clause 10, page 10, my lord, paragraph 10,
Right.
in subclause E of subclause 6, which deals with the financial capacity of the bidder, it is mentioned in the tender document as follows. The bidder, this is the first tender. The bidder should have robust financial capacity and have an average annual turnover, gross receipt of a minimum rupees 60 crores for the last 3 financial years, which I've mentioned. All should be certified by chartered accountant. My lord, this part I mentioned, my lord, that 60 crores, my lord, is the initial capacity. That was the criteria. May I read, my lord? The
Now it
bidder
becomes
should
180 crores.
now, my lord, yes, 180 crores.
Acha.
Now, my lord, the change, my lord. Now, my lord, in paragraph 13 and 14, my lord,
Change is 180 crores.
180 crores only, my lord.
Yes.
Now, my lord, the paragraph 13 and 14, my lord, is my lord, that in these 2 pleadings, my lord, my legal grievance, my lord, I have sought to depict, my lord, The petitioner says that the annual turnover of the petitioner company is around 90 crores.
Yes.
And the quarterly billing of the project of the respondent is expected to be more or less 16 crores. And for that, the petitioner will be able to execute the project without any financial constraint. The following table will clear the scenario and arbitrariness of the tender. The total asset value of the tender, Millard, 1.400 crore. Now, Millard, maintenance charges 5%, estimated revenue per annum 70 crores, expected maintenance cost for applicant, assuming 10%, met again 64 crores, required working capital 16 crores. Assuming quarterly billing for this project, the petitioner would need only 16 crores working capital to execute the project, and for that ideal working capital, turnover ratio of 1.5 to 2 is generally considered good. By this logic, a turnover 24 to 34 crore per annum itself is sufficient. Keeping annual turnover capacity of 180 crore is absolute, unreasonable, and arbitrary. Petitioner
Also,
states,
can we go into the
no,
reasoning?
Millard, question is, Millard, only two, Millard. Question is, there must be an object, Millard, sought to be achieved. Millard, question is, Millard, this is, Millard, a tender of maintenance. What is the element of public interest, Millard, that would be solved, Millard, by bringing these changes? Now, Millard, I have one difficult, Millard, I have to.
This is maintenance of the equipment in the hospitals.
Millard, accepting, Millard, the super specialty hospital in the all districts. Now, Millard, for which, Millard, it is not the case of the respondent, but I have one defect, Millard, which I have not pleaded.
You
Millard,
are your matter.
in my matter, Millard.
Yes.
Millard, that is, Millard, in the tender clauses, Millard, clause 28, page 53 of your Lordship's brief,
Yes.
it clearly says, Millard, that if I am aggrieved by and dissatisfied with any of the clauses, Millard, mentioned in the, Millard, my duty, no, my duty is to, Millard, report them. I have to ventilate my grievance.
Please
I
show me
did
that.
not.
Please show me. Clause
20,
page 53. Which
page 50, 28.
page?
Just a minute, Millard. Sorry, Millard. 28. 28, yes. Clarification, sorry, Millard, 59, not 58.
Yes, yes.
A prospective bidder, a clarifications in pre-bid conference, a prospective bidder requiring any clarification on the ENIT documents may submit their queries and suggestions prior to the last date of receiving queries. The authority shall schedule a pre-bid conference to discuss the issues related to the project with all the prospective bidders. The prospective bidders may raise any queries during the pre-bid conference in addition to those submitted earlier. The authority on its discretion may also hold further discussion with the prospective bidders to finalize any other related issues to the project before final submission of the proposals. I did not do this, Millard.
Participated in the tender.
Millard, tender, Millard, I was excluded from
you
this.
are
Yes,
excluded.
excluded. Now, Millard, 32 says that is also a clause, Millard, which might be argued by my learned friend. The bidding, no, my instruction that I did not approach.
He had approached, refused. I mean,
No, in the pre-bid meeting.
No,
went there.
no, 28 clause that I have to raise my objection.
You did raise.
He said, Millard, my instruction is not.
Ask.
But when he says, Millard,
But it not be sacrosanct.
no, Millard, 32, Millard.
Just because Mr. Chaudhary says he's sacrosanct.
No, amendment পরে আমরা করিনি।
না, amendment-এর আগেই করেছো।
Amendment, Millard, before amendment, Millard, I did not have any grievance to that.
But before amendment, that is.
No, but after amendment, 3rd August, I said.
Oh, no, very well. Then it's
Then, Millard, now 32, Millard,
Yes.
the bidding process shall be governed by and constitute in accordance with the laws of India and the courts of the state of Tamil Nadu. The authority, upon its sole discretion and without incurring any obligation or liability, reserves the right at any time cancel the bidding process, amend or supplement the bidding process. The amendment also within their power, and they are not, Millard, required to assign reasons. Millard, if it is a question of sole discretion, if it is a state, Millard, then, Millard, discretion must be informed by reason. Now, Millard, number one. Number two, the court should not, judicial review court, Millard, should not interfere with the tender process, Millard, unless and until, Millard, there is a gross arbitrariness. Now, Millard, the question is the tender, Millard, they have to show that by reason of this amendment, there is an element of public interest and this cannot be interfered with by this court. And, Millard, there is a reasonable nexus with the object sought to be achieved. Now, Millard, my question is that my page 54, clause 6, Millard, 16, I'm sorry, Millard. Now, my lord, it my lord, defines my contour, my lord, that what are my duties under the tender, my lord, if I am at all successful, my lord, the equipment management systems, EMI system. The service provider in consultation with such and such shall design, print and stick durable unique barcode sticker on all equipment under contract at the hospital and healthcare units within 1 month from the award of contract. The service provider will develop a deploy a web-based application with the option of web-based call logging, application-based call logging, and IVRS and HW management, WBMSCL hospital and health
This is
service.
relevant?
These are their duties and my duties have been assigned. My respectful submission before your lordship that none of the duties, my lord, envisage that it requires, my lord, the authority to make such amendment for the interest for the public interest.
Which is the page number again, where the submission date and all those are there?
My lord, 37, my lord, is the date, my lord. The date has been extended on till, my lord, 8 September. So, my lord, my grievance on the date when I mentioned.
When was the amendment effected?
3rd August 2023. And the tender was issued on, my lord,
Basu, this was not changing the goalpost as such.
not goalpost, but my lord, there is a hurdle, my lord, that has been, my lord, but because it's a tailor-made contract. Kindly ask, my lord, among these, my lord, I am not required. I'll be out of the court, my lord. If Mr. Chaudhury's client says that there are other bidders, my lord, who, my lord, who are armed with, my lord, this qualification and who can compete.
Are they required to do that?
No, they are not. They are not. My lord, if your lordship asks me, they are not. But the question is, my lord, whether it is all necessary.
Will continue after this.
Yes, I'm extremely grateful.
For?
For lending me your lordship's ears.
They're mine still. I'll come.
Deeply.
CPM clause তুমি চ্যালেঞ্জ করছো?
CPM clause. CPM clause.
Continuing matter.
Yes, Mr. Vasu.
Yes, Millard.
Yes.
The eligibility criteria, Millard, as that was fixed by Mr. Chaudhury's client, Millard, page 39
Yes.
of your lordship's brief.
Right.
Clause 6C. Millard, the first part that the bidder should have experience of handling similar comprehensive maintenance of biomedical equipment project in any state of India during the last 3 financial years. Millard, I'm not reading, certified by the ordering authority stroke competent authority of the respective facility, wherein the project value should be at least 240 crores cumulatively for 3 years. The bidder or Millard, the bidder should have experience of handling similar comprehensive maintenance of biomedical project in at least 5 health facilities, each having minimum capacity of 1,000 beds during the last 3 financial years. Or, Millard, same 500 beds, 10, 5 into 10, 5,000, 1,000 into 5, 5,000. Any of the conditions. Now, Millard, page 40, E, this is the original tender, Millard. E,
yes.
The bidder should have robust financial capacity and have an average annual turnover gross receipt in minimum income of 60 crores for the last 3 financial years. All should be verified, certified, Millard. This is also, Millard, satisfying my criteria because in paragraph 13, 14, I have said that my turnover is 90 crores. Now, Millard, the 107. This kindly takes pain, Millard, to turn 6C or clause. The first one, Millard, 6C1 remains same, Millard.
Yes.
Or clause, Millard, the bidder should have experience of handling in any single biomedical equipment maintenance. Millard, it comes to, Millard, change into, Millard, single biomedical equipment and 5 bed, 5,000 bed, Millard, 500 patient, these all gone. Or the page 39, the other 2 clauses, these 2 clauses, Millard, have gone, Millard, by reason of this amendment. Or now, Millard, new clause has been inserted. The bidder should have experience of handling single biomedical equipment maintenance project in any state of India worth rupees 100 crore / year for 3 years. Now, Millard, I, Millard, gave your lordship's trouble, Millard, in looking at, Millard, page 54 of your lordship's brief, Millard, 16, Millard. These are the, Millard, the criteria or the works, Millard, that are to be assigned, Millard, to any successful bidder. Millard, these criterions, Millard, remain unchanged. Clause 16, Millard, these are the jobs to be assigned, Millard, to the successful bidder in the event, Millard, anyone, Millard, succeeds in the process. And, Millard, these criteria remain same. So, Millard, the cost escalation and the exclusion of other clauses, Millard, from the amended tender notice, Millard, on 3rd August 2023, this has no rational nexus because either the government has to satisfy that by reason of such change, the government will enhance or augment, Millard, the public revenue for the public interest, then, Millard, I am out of the court, or the government has to show that by reason of this amendment, the service, quality of the service will be enhanced by reason of inserting this clause. Otherwise, Millard, the analysis of the court, while I'm inviting the court, Millard, look into the arbitrariness, this is not in vacuum. It says, Millard, that what is the, Millard, the mindful response of the authority in, Millard, dealing with the system, because the equipment management information system, the jobs that are unchanged. The only thing, when the government, Millard, changes the criterions, the government must say that these are the 2 criteria. That otherwise, the petitioner has no right to seek, Millard, any redressal from this judicial review court for which, and 125.
Mr. Vasu, this amendment was carried out sufficiently prior to the submission of the bid. Now, here, suppose then we have to proceed on the premise that this was the initial tender clause because it has been amended sufficiently prior. Now, suppose if this was the initial tender clause, we are comparing and saying that yes, this may be somewhat completely different from the previous one. But this amendment took place sufficiently prior to the beginning of the bidding process. Now, as of today, I mean, this is the original tender term. Let us proceed on that premise because the amendment has been carried out. If this was in the original tender, how could I have challenged? I mean, isn't it the
No, my lord,
employers?
I then, my lord, I
I mean,
cannot.
they say yes, 100 crore.
No, your lordship is absolutely right. Had this
We
been-
cannot be on a comparison drive with the previous
No,
original.
my lord, I was on the premise, my lord, that in law is everything is with reference to context. Had this not been said.
You're right
my lord,
on that.
my lord, on the
As per the
3rd May,
context,
the context is, my lord, that comparison has come, my lord, that after May, the August, after 3 months, without changing the criterion, my lord, the jobs specific assignment.
As it is, Mr. Basu, why do you say this does not have any context, any reference to the
Because
any
my lord,
proximity
no,
with the object?
Yes, my lord, because
Why do you say that?
yes, my lord, my reason being, my lord, that I am to, my lord, the maintain, my lord, the biomedical equipments, my lord, that is the maintenances.
Yes.
I have to render service. My lord, for service, that, my lord, the only criteria, my lord, the number wise bed and the patients. Because I am serving the patients, because these instruments, my lord, are essentially, my lord, required for the patients. Now, my lord, so my experience must be relatable to, my lord, the number of patients.
The entire biomedical equipment maintenance project, that may not have nexus to the number of patients directly.
That is what, my lord, they have said, my lord, in the first criteria at page 39, in the 2 clauses. That is what, my lord, that is my disturb.
There the comparison
Then
comes.
the comparison comes.
Yes.
My lord, that is why, my lord, because when
Without
they,
those being there,
yeah,
I mean, you want to look after the entire hospital, the biomedical equipment, whatever is there, you have to look after the maintenance of the entire thing.
entire thing, excepting, my lord, the super specialty
May
hospital,
not pertain to the number of beds also.
number of
We
beds.
have
are
an
given.
access with that.
That is the
Apart from that also, there may be certain equipment in the
Now,
diagnostic part. and all.
my lord, that is why I'm grateful, my lord, the government, my lord, has consciously decided not to change the other criterion. Had it been so that this with the terms of, my lord, the other changes,
The
that
other criteria, do they militate against this?
then the other criteria, my lord, the government has to show to your lordship, subject to correction, that these changes have been brought about only in order to enhance the quality of service, and those criteria we have made, that was not sufficient.
Mr. Basu, please clarify me on that. I am not with you when you say that they have to show
No,
a reasonable
I have to,
a reason for the alteration. I mean, we cannot compare with the original clauses at all. They may do it as they like. I mean, without having any nexus. The amended thing may not have any connection with the previous one. Maybe. But they have brought this as of today per se. Why do you say these are shocking or
no,
arbitrary? or-
yes, my lord, I am only because of this reason, my lord, that while 39, my lord, the eligibility for quoting, the government, my lord, the clause 1, my lord, these or 2 parts, the bidder should have experience and or the bidder should have 5 health facilities having minimum capacity of 1,000
Forget
beds.
this, Mr. Mukherjee, Mr. Post, please forget this, because these cannot be taken into consideration. They have changed this.
They have changed this.
Now, on the face of it,
On the
whether this
face of it,
clause,
the
the amended clause, whether that militates against the
no,
object.
that
or-
militates the object, will not, the object lays down in clause 16, page 54. These are the, my lord, the works that is to be assigned. Now it must be relatable to the works.
Yes.
This must be that for this execution of these works, this escalation of the cost is essential. That is where, my lord, the object lies. Otherwise, my lord, my entire submission, premise of entire submission with regard to, my lord, the reasonableness in action, my lord, it has no legs to stand. The clause 16, my lord, because government, my lord, possibly, my lord, subject to correction, Mr. Chaudhury's client cannot say that while, my lord, fixing this criteria, the government was oblivious of this clause 16 of this your lordship's brief. While government, my lord, fixing or determining, my lord, these general terms of bidding, instruction of the bidders, what are the scope of works, the government has consciously also chosen, my lord, the other criteria that is laid down in 6C. Now the changes that have been brought about, my lord, keeping constant of this clause 13 to 16, my lord, the government cannot say that these are not relatable. It is true, my lord, I cannot ask the government because it is my case. I have to stand on my own footing. I am only confined to my submission only on the clauses that the quality of service and public augmentation of public revenue. These are two absent. If these are absent, my lord, there are no other criteria, my lord, subject to correction, my lord, which can, my lord, attract the principles of the doctrine of reasonableness in the context of public interest, public element. My lord, I am when approaching your lordship, my lord, it essentially has to be a public law element or within the public law domain. So state action, my lord, has to be adjudged in the context of these two. The context, my lord, that means that the materials they have considered is the relevant consideration. Suppose, my lord, I want a mathematics teacher. I will not ask the teacher whether you are armed with Bengali honors, how much marks you secured in Bengali in mathematics. So this,
Is that so gross? I
this
mean,
is not
here
to
it
the
says
unreserved.
you have to have experience in teaching mathematics in one particular school and earned suppose such income. Or that the school generates such and such revenue.
But
So
here,
that also gives an idea of the school
Yes.
where you are working.
yes, my lord.
If the school does not generate any profit, but it incurs losses always, then it must be such a standard
But
school.
my lord, here, my
So
lord,
that also has a nexus with
next,
the,
but my lord, kindly sees, my lord, that the really
whether you are
no,
teaching
my-
mathematics
no,
in a single
no,
school
no, no.
or you are
There
roaming
are-
around different schools. That is what they've asked.
My lord, only, my lord, my lord, the exclusion of these clauses, my lord. Question is that how much, my lord, they have sole discretion. My lord, your lordship knows, my lord, that every discussion must be informed by reason. That is your lordship, what your lordship has taught us. Now, my lord. Ashish, now.
Yes.
Now, my lord, Mr. Chaudhury's client, my lord, I'm only saying this 100 crores is absolutely unreasonable, no nexus.
Hmm.
If that is so, my lord, then what is the
So this
the
valuation,
criteria?
I mean,
These are the, and I am relying on, my lord, I think I should not trouble your lordship with the
no, no, please
judgments.
trouble me. I'm waiting here to be troubled. From the morning, I'm waiting for being troubled.
No, no. আজ বলে judgment হবে দেখাস না, ওই judgment হবে না, my lord, one judgment is against me, NG Realtors, which says even if there is an element of
NG?
NG Realtors, NG projects, paragraph 3023 stands against me. First, I want to see the place this.
You can cite only that also. No, no, please.
This is NG Realtors. NG টা চাইছি না, NG টা দেনা। এটা paragraph 23, my lord.
Has any court told you that you are very fair in your submissions? No, has any court told you? I mean,
No, my lord, because I relied on this judgment in one court and I lost, my lord. So, my lord, this is on
it's
record.
unfortunate you rely on this judgment in every court and you. Which
No.
paragraph?
Paragraph 23, my lord. আমার জন্য রাখিস নি?
NG projects. No, they thought that since I taught you, Mr. Basu, so
No, my lord. Mr. Chou,
yes.
এই তুই চুপ কর, ওসব উল্টোপাল্টা কথা বলিস না এখন। 23 টা কোথায় গেল?
It's settled law, Mr. Basu, probably
Yes,
that we
yes,
cannot
yes.
impose our
No,
will on the
no,
employer. One.
But this court,
Secondly, your inconvenience cannot be a relevant factor.
yes, or that it's no, it says, my lord, that is, my lord,
Yes.
if the court finds that there is total arbitrariness or
Where
that
is
the
that?
tender has been
Para?
para 23. This is completely against me.
Oh,
Para
actually,
23.
yes.
Even if the court finds that there is a total arbitrariness or that the tender has been granted in a malafide manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract. The injunction interference in the tender leads to additional cost on the state, and it is also against public interest. Therefore, the state and this is against me, and I relied on another court, Willard. That is why I'm relying it, Willard, in where I appear for the respondent. But this is recorded, Willard.
You
And
do this in all courts, Mr. Basu. Whatever you rely on in connection with the.
No, Willard, because
different
otherwise,
matters.
if they show it that I made this submission to another court, Willard, then it can, Willard, I'll be cutting a very sorry figure, Willard. And I also relied this judgment before your lordship's court, Willard, in other matter, Willard.
Right.
And this is, Willard, but this does not, Willard, take into account Ramanna, Willard, 1979.
Ramanna?
Ramanna International, Willard.
Oh. I thought you were in.
Please.
Cordial.
I know. No, Willard, no.
Sometimes cordiality exceeds law. Maybe.
Willard, it would be presumptuous of me if I do so, Willard.
It would be?
Presumptuous of me.
So, Chaudhary, please go on translating whenever he says something like this. Because
2020,
you don't have anything else to do. He's citing your judgment, so you just go on translating.
I am also Millard helping the cause.
No, Millard, he says, Millard, the earlier government which I supported, these are the clauses, Millard, he said.
Mr. Basu, you should be thankful to me for using the correct color code. These are your pages, and his pages will be green.
I am showing him some, while he is arguing, I am disturbing him.
Millard, this is the judgment, Millard, reported in 2022 SCC online, SC 1334, Millard, Airport Authority of India versus Center of Aviation Policy, Safety and Research. 2022 দেখা 2022 এটাই তো
Yes.
Milord, paragraph Milord, it's 99.
Ramanna or something you said, this is something
No,
else.
no, the Ramanna Milord 1979, I am just quoting Milord that this is the principle, this still holds the field. Paragraph 133.
Any particular para?
Yes, Milord.
133.
28, Milord.
Yes. 20.
While considering the scope and ambit of the High Court under Article 226 of the Constitution of India with respect to judicial scrutiny of the eligibility criteria tender conditions, few decisions of the court are required to be referred to, which are as under. Milord, first it says the Binda Express carrier in paragraph 8, the scope of judicial review in matters relating to award of contracts by state administrative instrumentalities is settled by a long line of decisions of this court. While this decision clearly recognizes that the power exercised by the government and its instrumentality in regard to allotment of contract is subject to judicial review at the instance of an aggrieved party. Submission of a tender in response to a notice inviting tenders is no more than making an offer which states or its agencies are under no obligation to accept. The bidders participating in the tender process cannot therefore insist that their tenders should be accepted simply because a given tender is the highest or lowest depending upon the whether contract is a sale for a sale of public property or execution of works on behalf of the government. All that participating bidders are entitled to is fair, equal, and non-discriminatory treatment in the matter of evaluation of their tenders. It is also fairly well stated that award of a contract, but we have not reached this state.
Participate.
I did not because I was not allowed to participate. Today, Milord, if I'm allowed to participate, and then Milord, they will say that after participating,
Both sides there are
both
judgments
sides also. So
if you
Milord,
participate or
now,
if you
yes,
don't participate.
but here, Milord, I'm saying that Milord level playing field, that the minimum criteria, whether Milord this criteria which lays down Milord, I am saying Milord, the government while Milord not changing the other clauses of the contract and only change this particular Milord, this Milord absolutely unreasonable because it does not relate Milord to the other clauses, and that is why Milord Article 14 is the arbitrariness and which is Milord anathema to the rule of law. That is my only premise. If I am not allowed to enter Milord, the quality of service Milord, public service, what is the element Milord? That is not there. তুই কোনো জায়গায় দেখা দিয়েছিস বল পরে বলবি দেখালি না কোনটা দেখালে তাড়াতাড়ি বল এটা কেন দেখাচ্ছিস এটা তাড়াতাড়ি ওটা দেখানো Milord, this is Milord 2011 5 SCC page 430 ওটা দে yes এটা জজ সাহেবকে একটু দেবেন এটা কোনটা Milord, only paragraph 21 Milord, as far as the decision in Ramanna Dayaram Shetty case is concerned, the same does not inherit the petitioner case, and on the other hand has clearly laid down where the tenderers are invited for grant of government contract. The standard of eligibility laid down in the notice for tenders could not be changed arbitrarily as it would be hit by provisions of Article 14 of the Constitution. It is also observed by this court that an executive authority has to be rigorously held to the standards by which it professes its action to be judged, and it must scrupulously observe those standards on pain of invalidation. It has been repeatedly stated by this court that every action of the executive government must be informed with reason and should be free from arbitrariness, the same being the very essence of the rule of law. The said decision in fact supports the case of the respondent. Therefore, Milord, the only Milord, that is whether the government is under obligation to make sense, Milord, or to give reasons in every stage of its action, and that must be Milord and tested on the anvil of Milord reasonableness, and reasonableness includes Milord my right to participate Milord, and I must get equal treatment, and he has to show Milord. Your Lordship says he cannot, he will not show. I have specific case that is a tailor-made contract. There is the only one tenderer who will be favored or blessed Milord with Mr. Chaudhary's client.
Milord, there are three changes. In fact, two sets of changes. I'm sorry, I should have said two. Milord, kindly look at page 8 of the petition. It's very properly summarized. Page 8 and 9 is the first set. Page 10 and 11 is the second set. Now, please see page 8 now.
Mr. Bose, please. Page 8. Yes.
6C, technical capacity 6C1.
Right.
Came with Milord 3 clauses. Or. Lord, the first one remains unchanged. That's at page 8. Page 9, second and third gets replaced by one clause. Lord, now kindly take the pre-bid meeting minutes. এটা কবে হয়েছে? 20th of July.
Please give a copy to them also.
Yes, yes, I've given a copy.
20th July to?
Oh, I'm sorry, my lord. Pre-bid meeting was held on 7th June. And then there were further meetings held on 12th June, 23rd June, and 20th July with the technical expert committee. And then, my lord, these minutes were published. So what, my lord, transpired at the pre-bid meeting was, my lord, discussed there. So 7th of June is the relevant date for, my lord, the bidders. Now kindly, my lord, come to serial number 30, which is at page, there's no page number, unfortunately. Oh, page, yes, 14 of 23.
Yes.
Lord, first is third column, name of the company whose my lord requested. That's my lord the petitioner, Cyrix Healthcare. Now, what is the change? Second column. Please change this clause to below. The bidder should have experience of handling similar comprehensive maintenance of medical equipment project in any state during the last 3 financial years of 100 crores, cumulative for 3 years. This would enable more bidders with required experience to be qualified for this bid, and authorities can get more competitive bid rates, thereby having best utilization. Now kindly see this last column. It's, my lord, made 240 crores was there, and, my lord, 100 crores.
It is as per their suggestion.
This part of partially as per their, my lord, suggestion, this clause. Yes. So, my lord, the change is 100 crores. So, my lord, now kindly compare with, my lord, paragraph 8. With paragraph 8, the first part which remains unchanged is, my lord, the 240 crores, 3 years. That is unchanged, that's there. Now, part 2 is bidder should have experience of handling similar comprehensive maintenance of biomedical medical equipment in the last 5 health facilities, each having 1,000 beds for the last 3 financial years, or 10 health facilities of 500 beds for the last 3 financial years. According to them, the clause should be with a particular figure.
At least to be 100.
Yes, that's, my lord, their suggestion, which is paragraph 30. And, my lord, that is, my lord, accepted. Kindly see page 9 of the writ petition. So all these bed, etc., we remove, and
This meeting was not held in their presence,
yes,
but they had suggested on 7th of June.
they suggested on 7th June. This is the kindly see the top of the document, my lord.
Yes. On those suggestions, you said.
Yes. Pre-bid meeting was held on 7th June, where various prospective bidders submitted suggestions for modification and amendments in various clauses of the tender documents. All the prospective bidders were asked to mail their suggestions for modification and amendments to such and such within 2 p.m. of 9th June. Meetings held on 12th June, 23rd June, and 20th July in presence of technical expert committee, where their suggestions for amendments, modifications in tender clauses submitted by all the prospective bidders were reviewed. A threadbare discussion about all the suggestions received held, modifications were done accordingly. And we have, my lord, recorded that this is their suggestion. So I am certain there would be an email also. Otherwise, it would be seriously malorded.
Yes, my lord, if that is so, my lord, well, I need to take instruction. I want to call my client.
My lord,
because
that's number one.
If that is so, my lord, there is no you point in wasting your lordship's time.
No,
Because if I have said something there, but this is not within my knowledge, my lord.
Of course not within your knowledge. We have no doubt. Now, my lord, page 10 and 11. This is, my lord, not as per their suggestion. This is, my lord, a situation where the bid was, my lord, the earlier clause was 60 crores. they came and said that it should be reduced. But well,
Make
other
a phone call,
bidders
asking
said,
him to make a phone call to your instructing person and because I've heard it substantially, Mr. Bose, instead of relegating the matter, I am hard pressed for time in taking up these motions. So since it is already in the upgraded list, let me decide it today whichever way.
Yes.
Let them take instruction.
Yes.
In the meantime,
Give me 10 minutes time. He's in Kochi, Kerala. Give 10 minutes time.
Kochi as in Kerala. Yes. So very well, yes.
যা দৌড়ে যা কি বল যেগুলো আপনি সই করে এই সাজেশন গুলো দিয়েছিলেন সেগুলো বলছে
I can hear you, Mr.
you know, the second Millard is kindly see serial number 22 of at page 10 of this of the pre-bid meeting.
Yes.
Here, Millard, your lordship will find Sodexo India Private Services Private Limited and Kirloskar had requested that instead of 60 crores in 3 years, to make it more competitive, make it 40 crores or 55 crores. We went into the question threadbare and made it 180 crores. Because, and this is why I, Millard, took an adjournment. I wanted to know, why have you increased? This is absurd. Somebody asked you to reduce. Why have you increased? There must be solid reason for it. The reason is, which the tender committee has given. Number one is, this is the CVC guidelines, the office memorandum of the government, which has been followed. Lord, it's at page 3. I'll hand up the copy. Lord, please see page 3. For civil or electrical work, this is the clause. They say we have modeled it on this, and it's fair. Because this is electrical equipments, etc. So average annual financial turnover during the last 3 years, ending 31st March of the previous financial year, should be at least 30% of the estimated cost. This is what is, according to them, central government usually follows. This is the fair way of doing it, at least for electrical contracts. Next question to them was that how do you decide estimated cost? For which they've also come back with a CVC manual. এটা কি দিচ্ছ? Oh, I'm sorry, this is Government of West Bengal, man. So they've looked at this and they say that for first call, it should be 40% of the estimated amount put to tender during 5 years prior to the date of issuance. So here, my lord, they have taken out, they made a calculation. This is a contract being performed. So they have made a calculation. And I have copies of it. Huh? Set kora. So this is, my lord, every year. You know. Khule phella. So bill-wise calculation detail, financial year-wise from 19 to 20, then is 2021, 21, 22, 22, 23. So every year it's been above 100, I think over 100 crores is the average. So they have taken 40% of 100, which comes to, it comes to 600. And then, my lord, they've done 40% of 600, come to 180. 240, I'm sorry. Yes. I'm missing it up, messing it up. My learned friend, my lord, is better.
Mr. Das is very thorough on fact.
Yes. He keeps attacking, my lord. Morning, evening, afternoon, he keeps attacking. So this is, my lord, the situation. This is why we've done it. So there is a reason for the change, which is based on some intelligible criteria. It's not enough for a tendering authority to come and say that I have done it. Please don't look at it. That's not the right approach. Court always retains jurisdiction to look at it. Now, the reason, if you can you have to at least show that there is some rational reason for your actions. So this is the rational reason. So therefore, my lord, and we have also, because of the challenge, we advise them that please extend the date for submission so that matter can be heard and disposed of in court, which is why we've extended the date. Now, my lord, after your lordship decides, if your lordship permits it to go forward, we'll proceed.
Milord, is it possible, Milord, because these are the voluminous documents, I need only 1 day time, Milord. Only, or if it is, Milord, if he has made this suggestion, Milord, I will stop there, Milord, at once and dismiss this.
No, the first part is your suggestion, not the second one.
No, even whatever it may, if the stand I have taken today, Milord, if it is contrary,
Any reply regarding the other part, 180 crores?
180 crores, Milord, because he has given this suggestion, Milord, this document, Milord, I need to look into it because initial, Milord, to 2015, Milord, the policy decision was to encourage more participation in tendering, thereby lowering rates in the long run. It has been felt necessary to amend the existing credential policy as there is a credential policy. Now, but Milord, this particular criterion,
Mr. Bose, if you want, I can direct affidavits to be sir, but they'll go on with the tender.
Yes, Milord, but kindly takes the decision on Monday at first, Milord. Only
it will be over. I mean,
5 minutes time, Milord. Otherwise, Milord, if it is there, Milord, I will not utter a single.
Also get a copy of his email if there is one.
Yes, Milord, there is no point.
right. Learned counsel for the petitioner contends that certain amendments were effected to the original tender terms, comma, necessitating the present writ petition, full stop. In such context, comma, learned counsel for the petitioner cites certain judgments as well. Full stop. Next para at this juncture, comma, learned counsel appearing for the respondent authorities seeks to place reliance on certain documents, comma, copies of which are handed over in court today. Full stop. Learned counsel for the petitioner, comma, in order to enable him to come prepared on the said documents, comma, seeks a day's adjournment, full stop. Accordingly, let the matter be listed under heading top on September 5, 2023 for passing orders. 5th September, Tuesday. So we avoid the combined list and come back. I'll keep all these on record.
Deeply obliged. I'm extremely grateful.
I didn't argue the estoppel point.
No, I'll hear you if Mr. Bose comes prepared with this. If he has anything to say otherwise, then I'll hear you on the other points also.
No, my lord.
I did told
Yes. The other estoppel point which I was pointing out. This clause is borrowed from a certain era. How can you challenge? This is not done.
This is that era. This is from that era.
This clause is coming from that era.
Clause is coming, yes.
So how can he challenge? He must.
Electricity matter, item 31.
51 minute, I am for the petitioner.
My lord, I am appearing for the license.
My lord,
What is the matter? Yes.
my lord, in this matter.
Mr. Chakraborty, take the microphone. Yes.
Sorry. My lord.
Yes.
Lord, in this matter, my lord, on last occasion, the private respondent appeared and they.
Certain documents were fraud and all this.
Yes, my lord, they have filed their opposition, my lord, but due to some personal difficulty of mine, my lord, I have not been able to file my reply, my lord. Though I have not agitated the allegations as they have stated.
No, I'll
in
extend your time for reply. I'll keep it October monthly list then.
October monthly as well.
The time for filing reply is extended for a fortnight from date, full stop. Not October, I'll give it before.
Mine.
For a fortnight from date, I'm sorry. The matter shall next be listed on September 18, 2023 for hearing.
September 18, my lord.
Pardon?
18.
September
18.
18 September. But under the normal heading, or it's a normal heading actually.
As hearing,
As hearing, yes.
I'm deeply obliged.
অরিত্র এগুলো কিন্তু না হলে আজকে তাহলে কিন্তু নরমাল জায়গায় চলে যাবে ইয়েস
32.
I am for the petitioner, lordship.
I am for the licensing.
Lordship petitioner applied for new connection
Thereafter regretted for
Service.
splitting of lordship.
Service.
No landlord. No private respondent, only CSC.
Yes, what happened then?
They have rejected on the ground of splitting of load. We have approached the grievance redressal officer, but they have not taken any steps since February 2023. The matter is
When
pending.
the petitioner sought for an electricity connection, comma, the CSC Limited refused to give the same on the ground that there would be apprehended splitting of load. Full stop. The petitioner, comma, being aggrieved by such refusal, comma, approached the grievance redressal officer, but the matter is pending since last February before the said authority.
Lordship, I have annexed the
Full
representative.
stop. Learned counsel for the petitioner seeks an early disposal before the said officer. Full stop. Accordingly, WPA 13138 of 2022 is disposed of by directing the respondent number 3, that is the grievance redressal officer, comma, CSC Limited, comma, Southwest Regional Office, to decide the dispute raised by the petitioner as indicated above, comma, as expeditiously as possible in accordance with law, comma, preferably within 4 weeks from the date of communication of this order to the GRO. No address to cause urgency. Thank you. Thank you.
33.
May please, Lordship. As for the petition.
Yes.
Now, this is my affidavit of service.
Right.
Petitioner paid the,
You're for the CSC music. Yes.
and I have served the private respondent also. My the earlier petitioner approached.
Yes.
And there is a order passed by coordinate bench of cost we paid, and WBS CSC authority has installed the meter in the other premises, though I paid the security bill, service charge, everything. So, my lord, I am paying that meter be in my premises because that is our case, service connection.
What happened before the coordinate bench?
There is a order passed by the coordinate bench to pay cost, just tender.
Cost for what?
For suppression of suit pending, that we paid the cost. Next page is the, can you see the order passed by Justice Tandon, page 15, annexure P3.
So you paid the cost and washed your hands now.
Yes, and we paid the cost of installing meter to the CSC also.
So what now? They have to install.
They have installed in other premises. That
Have you given a representation to them on that score? You were not
No.
present when it was being installed.
Yes,
Why didn't you point out? Why didn't you point out to the CSC personnel when they...
not
This is not.
my
Yes, what is your...
My lord will kindly take the cause title. My lord will see the address. This is the last bill that I have of May 2023. My lord will kindly check. This is the same address. It's not been installed at any other at any different premises. My lord will kindly see the address at the top. This was done on the 2nd of February 2023. She failed to pay thereafter.
The Uttar Kadwala Dakkhinas, that was not, that is not there.
Not pretty.
That is not there.
Late.
Uttar Chottakallikapur is the entire area.
Yes, but my lord, why probably it's not written, my lord. It's at the same premises, installed on 2nd of February 2023. She paid initially, thereafter she failed paying, thereafter we disconnected. If my lord will also with the
Disconnected?
Yes, supply has now been disconnected. My lord will kindly take the petition once.
Because of other premises, they have installed.
My lord will kindly take the petition
So
once.
we
My lord
cannot
will the petition. My lord will kindly see paragraph 13, 1-3 at page number 6. In fact, the petition is also vague as to when the disconnection was made. And now, my lord, she says.
When did you give the connection?
2nd February 2023.
If any outstanding dues.
20th February.
2 February.
2 February 2017?
23.
23. Oh, achha, this.
If there is a dues, we will pay that amount.
Not a question of dues, my lord, and therefore it is the meter has been installed at a common suitable position along with other meters. This is not with regard to one particular meter. The tenements, it's a tenement. So, my lord, there's a suitable place that there it has been installed. My lord, consumption bill has been given.
You are getting connection from that.
No, my lord, they are obstructing. That is not my premises. That is the question. All right, my lord, we will approach them to.
Then you apply for a shifting.
My lord, I'll pay for shifting before that.
You have to apply for shifting also. I'll give you that liberty.
Give in, my lord, it will be served.
Well, affidavit of service filed today be kept on record. Full stop learned counsel for the petitioner contents that the petitioner has paid all dues and the CSC Limited also installed electricity connection at the behest of the petitioner, but at different premises than that of the petitioner. Full stop next para. As such, the instant writ petition has been necessitated. Full stop next para. Learned counsel appearing for the CSC Limited hands over a copy of an electricity bill and submits that the address at which the bill was raised and, obviously the connection was given, is the same as that of the petitioner disclosed in the writ petition. Full stop, it is submitted that the petitioner failed to pay the electricity charges subsequently and, as a result, the supply has been disconnected. Full stop next para. As such, the present writ petition ought to be dismissed. Full stop next para. A perusal of the bill handed over in court today and the cause title in the writ petition indicates that there is a subtle difference between the two addresses insofar as the bill discloses the address of the petitioner as within double inverted Chotta CHATTA Kalikapur within bracket Maheshtala bracket closed LP-9/59, Kolkata 7,140,000, whereas the cause title in the present writ petition describes the address as within double inverted Uttor Karbala within bracket Dakshin ANSH bracket closed, তারপর বাকিটা এক চট্টা কালিকাপুর থেকে 140 double inverted close. Full stop next para. However, it is seen in the present case that whereas the electricity connection was given in February 2, 2023, the petitioner filed the writ petition only in the month of May 2023. Full stop, that too, after disconnection of such supply. Full stop next para. Even without going into the allegation of the petitioner that the meter has been installed somewhere else, since the petitioner paid for the electricity charges for some time, it cannot be said that the electricity that the CSC Limited installed the same at a different address than that applied for by the petitioner. Be that as it may, learned counsel for the petitioner submits on instruction that the petitioner is agreeable to apply for a new for shifting of the electricity
May
meter.
I interrupt here once, my lord? I am told by the officer, then they have to apply for a fresh connection, a new connection totally.
I'll make that alternative. Alternatively, a fresh connection for electricity supply to her premises, and shall also pay all the due charges to the CSC Limited. Full stop next para. In view of such fair stand having been taken by the petitioner, WPA 13257 of 2023 is disposed of by granting liberty to the petitioner to apply for a fresh electricity connection at the proper place as sought by the petitioner, and upon such application being made and all arrear charges being paid regarding the previous connection of the petitioner, as well as payment of all charges for such new connection being given, and compliance of formalities by the petitioner, the CSC Limited shall give such new connection to the petitioner, at the earliest, preferably within 3 weeks from the date of compliance of all formalities by the petitioners in that regard.
My lord, police help at the cost of the.
For what?
Private respondent is there.
No, that will be premature because that will be a new cause of action, Mr. Haldar.
Otherwise, well,
In any event, he will be coming. If it's an easier case, your son will be coming. No arrest to cause, sir. Yes.
An earlier security project.
And earlier we have paid the security dues, everything that will be adjusted.
That cannot be adjusted, my lord, because it's a fresh connection.
That will be adjusted with something else, your fees.
34.
Yes.
I'm for the CS.
Lordship, petitioner is a tenant applied for domestic connection.
Service.
No private.
Splitting of load, my lord.
Petitioner is a tenant, Lordship.
Supply.
GRO pending
No.
GRO, he can approach the GRO. Because my
with
lord,
costs because you know. Yes.
Lordship, petitioner is a tenant.
So
an extra P2,
So
you
what?
conveyed the thing to him also.
tenant is supposed to strike some sympathetic chord.
Lordship, 3-bench judgment is there in settled possession. They
No,
have,
I'm not disputing that.
they have to give connection.
Oh, splitting of load, you are saying
Tenant, Lordship.
not even if you're a tenant, if you're enjoying through your landlord, there is no strained relationship.
He's not enjoying at present.
Moreover, one unit cannot have multiple service connections. That is.
So one unit you'll have to treat it as a different unit. Justice Tandon's judgment is there and there
Justice
are some
Tandon's
other.
judgment is also there and also the 3-bench judgment.
Any eviction suit has been filed?
No.
Then- No, I'll give you liberty. Learned counsel for the petitioner argues that the petitioner is a tenant in respect of the disputed property where the petitioner sought for an independent electricity connection. Full stop. Learned counsel for the petitioner further argues that the respondents, that is the CSC Limited, has taken a plea of apprehended splitting of load, which is not justified in view of the fact that the petitioner, as a tenant, is entitled to independent electricity connection, by treating the petitioner to be an independent consumer. So next parallel, counsel for the CSC Limited submits that the petitioner is already enjoying electricity at the premises and, as such, multiple connections cannot be given to the same unit. Next para. In the present case, there is nothing on record to indicate that the relation between the petitioner and the and his landlord is strained. In fact, the landlord of the petitioner, landlord is also not a party here. In fact, the landlord is not even included in the present writ petition, nor has any allegation been made against the landlord to indicate any such strained relationship. Hence, since the petitioner is already enjoying electricity connection and in the absence of any resistance or threat from the landlord, the petitioner cannot be treated to pay a separate unit for the purpose of getting a new electricity connection. In any event, since an apprehension of splitting of load has been expressed by the CSC Limited, the same has to be adjudicated by a grievance redressal officer as contemplated in law. So accordingly, WPA 13437 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer for deciding the dispute raised in the present writ petition by the petitioner. If so approached, the grievance redressal officer shall decide the same as expeditiously as possible and in accordance with law, upon giving opportunity of hearing to all concerned, preferably within 6 weeks from the date of such approach being made by the petition. No rest to go, sir.
Grateful.
35.
Lordship, this matter, my lord, I am appearing for the distribution company. I may be excused, my lord. Kindly take the matter on Tuesday, my lord. Because due to, as per my lord's order, there was direction upon distribution company.
You are not ready with the report?
That report is not with me at this
On
moment.
the prayer of learned counsel for the WBACDCL, the matter is adjourned till September 5, 2023, when it will be listed at the top of the list. Top of the list, Mr. Halda, please come.
Yes, my lord, my lord, henceforth, my lord, on Friday, electricity matter will be taken up.
No, not necessarily. Because Mr. Haldar is in 99% of the matters. So if those matters are decided, probably I won't be facing any trouble from anybody.
But my lord, electricity matter to be taken like some time.
Yes, I will definitely think about it. Electricity matters also take very little time.
My lord, kindly let the matter be on the top of the list.
Top of the list on Tuesday.
Down.
No. Now up only.
5th September, my lord.
5th September, next Tuesday at the top.
Of that.
তার আগে রিপোর্টটা একটু দিন
বন্দনা বসু আর দুই মিস্টার হালদার।
Bandana Bashu Distribution Company.
Yes.
36.
May please the lordship.
No, you are.
My new connection, my lord, submersible pump, we are ready to comply
No.
all the formalities. Agriculture is going on.
Why not given?
Well, they have not taken twicely.
No. You are sufficiently senior now, not every occasion. I'll give you 5 minutes time. I'll pass it over for just 5 minutes. Take instruction why not being given. 55 I'll call it because from 3 I'll be taking up original statement.
এরপরে কি?
Pass over.
37.
None appears for the parties at the time of call. Let the matter be listed in the monthly list of October 2023.
May please lordship. I am for the petitioner. Yes. My lord applied for new electric connection, my lord annexure page P2, page 10. My lord, there is no meter in the said premises and the applicant is the only petitioner in the said premises and my lord, can you see annexure P2, page 10.
Already enjoys the benefit of an existing supply. There
is no supply.
The REIT could decide then. So who has to do this? GRO this also?
My lord, no. My lord, this is a different situation. It's an illegal construction. The KMC authorities have pointed out that this is an illegal construction, 4-storied building.
Yes.
So we refused. Similar applications were also made.
You have stated in your reply, in any event or site.
In any inadvertence on our part.
All right.
That has been rectified and communicated to him also that it was an inadvertence.
Illegal construction, there any demolition order is there?
No, but it has been declared illegal and the other inmates, police case is pending. The other inmates, they have also applied. We have rejected on similar grounds. We've rejected their application as well.
My lord.
Till that there in the premises there electricity.
I am staying there before the illegal construction started.
These cases are pending, illegal construction, whatever.
Complied all formalities.
We shall carry out whatever your lordship decides.
I'll direct electricity to be given. I'll record your submission definitely. Learned counsel for the petitioner submits that the petitioner applied for new electricity connection, which was refused on the ground that the petitioner is already enjoying the benefit of an existing supply. So it is submitted that the same is not correct, comma, since there is no other electricity meter at the premises. Next para. Learned counsel appearing for the CSC Limited submits on instruction that the building where the electricity connection has been sought has been declared to be an illegal construction by the concerned authorities. Police case is also pending with regard to the said building on such score. As such, comma, the CSC Limited did not give such connection to the petitioner. Next para. Although it is further submitted that the reasons cited in the refusal, which has been annexed to the writ petition, was a bona fide inadvertence on the part of the CSC Limited. Next para. The sole ground on which electricity connection is refused by the CSC Limited is that the building has been declared to be an illegal one. However, comma, irrespective of the illegality of the same, comma, until and unless a demolition order is specifically passed, comma, the petitioner apostrophe settled occupation cannot be disputed. Since it is well settled that a person in such occupation is entitled to electricity, comma, irrespective of the lawfulness of the possession, comma, WPA 15731 of 2023 is disposed of by directing the CSC Limited to give electricity connection to the petitioner, subject to the petitioner complying with all formalities in that regard within a fortnight from the date of compliance of formalities by the petitioner. It is, comma, however, comma, made clear that the electricity connection as and when given shall not create any special equity in favor of the petitioner and or right which the petitioner does not have in law and shall be subject to any order, comma, including a demolition order, comma, which may be passed with regard to the premises where the connection is given, comma, passed by a competent court stroke forum. No address to cause urgency.
My lord, the feasibility also has to be ascertained.
As a subject to compliance of for formalities, একটা জায়গায় বলছি WPA dispose of directing to give electricity connection, subject to compliance of formalities and subject to feasibility of doing so.
My lord, deeply okay.
But within feasibility, don't say that it's illegal. That's why.
That is all right.
Please instruct your client. Yes.
Some inspection.
Don't be like Mr. Mukherjee.
Earlier matter, my name be recorded.
No, definitely not. I recorded something. You are not there. Did I? Again, what matter key?
Matter was directed to appear next month.
Record করেছি? None appears.
Petition did not appear.
So, huh? No, no, no. You are sufficiently rich for that. Yes. 5 মিনিট বাদে যেটা সেটা ডাকো। Sorry, Mr. Kole. Another
36.
Me, please, lordship.
Yes.
কোনটা পাঁচটা
Passover matter, 36.
সেটা পাঁচটা করেছে।
But
Tuesday at the top. None appears for the distribution licensee at the time of call. Let the matter be listed at the top of the list on September 5, 2023. Because your other matter has also been fixed. This is a short matter also, so I'll take. Yes.
পিটিশনটা করি অরিজিনাল পিটিশন নিয়ে বসে আছি
নামগুলো কোন ম্যাটারে কিছু করতে হবে ওয়েটিং রুমেই থাক ইয়েস
39.
My lord, in this matter, my lord, the petitioner is a bulk consumer and he has given bank guarantee of huge amount. In spite of that, every month they are coming and disconnecting, though we are paying without any notice, my lord. That notice part be,
every month they're disconnecting.
yes, coming and disconnecting, I will pay.
You are paying and they're reconnecting.
Reconnecting.
Kindly
So,
see the agreement go on.
what I am saying at
prayer,
this-
my lord. Kindly see the
that
prayer.
what I am paying, they will disconnect, no problem. But with the notice, my lord, come and
Of
disconnect.
course, notice, my lord.
This is a peculiar petition, Mr.
My lord,
Kindly see the
Peculiar
prayer.
petition. You are
Kindly
saying
see the
that-
prayer, my lord.
and there is a huge
There
amount
should
of
not be
back guarantee
disconnection in
to the
future without any notice.
Without any notice, that is the
Yes,
question.
no, that's all right. Without notice, we can I?
Yes,
Can we?
you are doing.
The limited grievance of the petitioner, বসেও নিতে পারো। Limited grievance of the petitioner is that the petitioner, despite being a bulk consumer of electricity, comma, is suffering since regularly the WBACTCL is disconnecting the electricity supply of the petitioner and subsequently restoring the same upon payments being made by the petitioner.
My lord, kindly record that he is a habitual default. My lord, kindly.
On each such occasion, comma, the disconnections are being effected without prior notice, comma, it is alleged. Full stop. Learned counsel for the petitioner insists that the WBACTCL be restrained from disconnecting the petitioner's electricity supply in future without giving prior notice. Full stop. Learned counsel for the WBACTCL submits that the petitioner is a habitual defaulter, comma, for which repeated disconnections have been effected. Full stop. It is further, it is denied by the WBACTCL that on any of the occasions, comma, the disconnection was effected without prior notice. Full stop. Be that as it may, comma, since the law stipulates that prior notice is required to be given before a disconnection, comma, WPA 15736 of 2023 is disposed of with the rider that the WBACTCL, comma, on each occasion of future disconnection, comma, shall give a prior notice to the petitioner.
My lord, develop.
Nor has to cause.
But his direction is required at all.
Yes, yes,
It's a
yes.
statutory provision.
You are
my lord.
doing that.
This is preparation for puja vacation for
Yes,
Mr. Hal.
My lord, grateful.
আরেকটা হয়ে যাবে, রেখে দাও, রেখে দাও।
কপি
ছোট ছোট matter।
দু জায়গায় কপি সার্ভ
40.
40 minute, I have got instruction to appear on behalf of CSC minute, but the copy minute.
I have served lordship
Service?
service, only CSC is there, that's why.
My instruction is that we have not managed. Keep it
I'm
on.
not recording any order, let it will be where it is.
My lord, keep it on Monday, my lord, or later?
Wherever it is, I mean, may not be on Monday.
Tuesday.
Tuesday আমার একটু সকালে অসুবিধা।
Let us see whenever, I mean, maybe on Monday.
Later copy piece of.
Give a copy, Mr. Halder.
আমি দিয়ে দেবো আজকে।
Orange আছে।
ওখানে ভালো করে এবার আমাকে দেখা যাচ্ছে কিনা ভালো
Original side matters.
কোনো দেখুন
Any mentioning? Listed matter item number 1. Urban Association of Apartment Owners.
Kolkata Municipal Corporation.
Right. Please take your seat, Mr. Ghoshal. Yes. All have been served, Miss.
Served.
Yes.
May it please your lordship.
Please, yes.
My lord, the petitioners are 34 persons, those who have purchased flat during in the year 2020. My lord will take judicial notice of it that during the lockdown. And only 12 out of 34 have shifted on account of non-supply of water, which was a clause stipulated, and your lordship knows it is for civilized survival. The water is not being supplied. There are too many clauses which were apparent in the contract between the parties, between WBHB, West Bengal Board of Housing, West Bengal Housing Board, and the petitioners. But right now, I am pressing only for supply of water, at least temporary. Now, it is not a fact, I must admit, that WBHB, the principal respondent, is not supplying the water, but they are prevented by the adjacent flat owners, Purbasha. Ours is Purbanno. It is actually Purbasha phase 2. The nomenclature appears Purbanno. It is smaller. Purbasha residents are influential, mostly high officials of government. Now they are preventing the Calcutta Municipal Corporation in execution of the work. Police was also informed even that they do not have any title over the property where they are disputing and preventing that no, this water line will not be, excavation will not be allowed. Even the title has been mentioned and cleared by the authorities that they have no title, no right title interest over the particular places where from the lines are being constructed, but still they are not manageable. It is apparent between the in exchange of letters of the officials of KMC, WBHB, and the president of the Purbasha Housing Estate. Your lordship, kindly, for your lordship's convenience, your lordship kindly come at page 77. I come right on the point.
Yes, thank you. Yes, please.
This is a communication between the executive engineer, Central Water Supply of Kolkata Municipal Corporation and Deputy Director, Purbanno Housing Estate. Your lordship, kindly come to the bottom, third paragraph. For your lordship's convenience, I am coming right to the point.
Thank you. Yes.
Not wasting time. Also to inform that only user right of common area has been provided to AOA, Apartment Association of Purbasha. Since no ownership of common area was ever given, AOA of said housing cannot interfere in carrying out your work. Next page, officer in charge Maniktola Police Station has also been informed accordingly by this office order memo. Now, your lordship, this is of 24th August 2023. Again, on last occasion, your lordship kindly come to
22nd September.
September.
Yes.
This was aborted. The attempt of KMC, in good faith, they are acting. I have no complaint against KMC. Even WBHB is trying.
but they are prevented. How? Now your lordship will kindly come page 79. Page 79 is not legible. 79A, the next
It is
page
already
for
in
your
my copy.
lordship's convenience.
Yes, yes.
It is the notice of 6th December.
Right.
Which I assume has been aborted again by other means of the residents of Purvasha. Because after this result,
This excavation has to be undertaken within Purvasha.
within Purvasha also. But Purvasha has no right. I have explained, I have
Is there any scope of any amicable settlement? I mean,
no, your lordship kindly see, Purvasha is also one of the similar units like
Yes.
me, like us.
right.
But they have an issue, I can show. They have an issue. They are complaining that they are also falling short of water supply.
All right,
But,
there is
but the KMC has clarified. I have letters, the communication between them.
your pipeline is the Brahmaputra.
Yes, that please take up the issue with the appropriate authority, it will be solved. They are not doing that. They are preventing that we will not allow you to carry out such work so that water can be carried.
So what sort of a relief are you expecting?
I am expecting, my lord, actually to direct the WBHB, mainly WBHB, because KMC is always attending and very eager to know, eager to complete the work, so that police help is taken. The point is that Purvasha people are playing covertly. They are not acting overtly.
This should you should
My-
approach before a civil court, Mr.
No, I mean, then I will not go to the Purvasha. I withdraw that. I submit before your lordship. It is the bounden duty, obligation of WBHB to give us water. Your lordship then come to page finally. I need not do that. I was just explaining because all the matters have come out.
All right, yes, all the options should be.
Your lordship kindly come to page 82. Our representation. It is a second representation. Yes.
Right.
Though both are complexes of under the housing board.
Yes.
It is the question of influence. What they are not doing directly, they are doing it indirectly. Your lordship kindly come to page 82, which is for your lordship's convenience, annexure 17, our representation, detailed representation. We have not been delivered with all the reliefs which are contained in the contract, to which they are obliged to. But still now, right now, as an interim measure, I am praying before your lordship for the water supply. Your lordship kindly see the position of water supply. At para 5, page 82. I am reading it for your
You are saying
lordship's convenience. It
reinstate
is
why-
pertinent to mention that
Why reinstate? Why reinstate?
which one, my lord?
Please come to the bold line. I've read that paragraph. That's a bold line. Underline. Urge the housing board to immediately reinstate the
Because,
facility.
my lord, when such is,
Yes.
when such incident took place at first, 12 families have shifted.
Yes.
Now, how they are surviving? They are surviving by private supply and on a discussion with KMC that please provide us water. So KMC, out of grace and good gesture, delivered for some time some water, 4 tankers. They used to. But this was an arrangement, my lord, I can say out of grace, that these people cannot live. It was during lockdown. So the KMC used to provide certain tankers. It is pertinent to mention that the water supply by KMC water tankers to meet the water shortage and cleaning of Purbanno campus, which had been arranged by WBHB, had been abruptly stopped by the Housing Board since January 2022 without any prior intimation of the residents. We urge the Housing Board to immediately reinstate the facilities to provide water to the residents. Kindly arrange for 4 water tankers daily as the residents are facing tremendous problem. My lord, there is no water. I can personally say that there is no water. I know some of my known persons, those who have purchased, are not in a position to move. Because the present residents are asking them not to come. Milord, it is WBHB, they are supposed to carry out the order. And they are supposed to carry out the work. They will do it. Since it has come apparent that the Purvasa people are obstructing, we have mentioned that.
You have annexed that contract.
Yes, Milord.
Can you show me the relevant clause regarding water?
Water, yes.
Was
At
any
page
modality?
46.
Yes.
At page 46, third schedule.
No,
Second-
right to get water obviously is there. Was there any modality prescribed that
Yes,
it
yes.
will be through
Yes,
such?
yes. Source of water at page 46. Source of water is from KMC through GI inlet pipe, ferrule connection, connection to the semi-underground water reservoir of capacity 22,000 liters and thereafter lifted to OH reservoir by centrifugal pump. These they have to do. They are doing. I have a right, Milord. I have a good case that I am entitled to get water.
Ultimately, what you are arguing, I mean, what you are canvassing. before
My
the
lord,
court is
my lord.
KMC is willing to give you the water.
My lord. I will
WBHC
not, because I will
Yes.
not make it inconvenient for
Yes.
anyone.
Right. And WBHC is also, I mean, cooperating. But the difficulty is Purvasha, from Purvasha. So why is this not a I appreciate fully that your basic right, amenity, right to life, these are being hampered.
Why this is
Undoubtedly.
not a suit? Now, my lord, let me explain.
Maybe
I
this
shall-
is the civil lawyer speaking in me.
I shall
But
convince
this
Milord.
is clearly, I
I
mean,
shall convince Milord.
your relief is against
It
Purvasha.
should, no, my,
Why not?
no. My relief is against WBHB. I have sought a declaration that following the contract, I must get everything which is contained in the contract. Radhakrishnan's case, 77 Supreme Court, 3 bench. Clause 1. There are 3 clauses that in government contracts, 1, 2, 3. Third one is the meager one, that while the bank is out letting out the premises, then their deed does not lie. But in 1, 2 clause, they are supposed to fulfill it. WBHB has to provide water to me, to us. Let that be. Since we know that what has happened, I did not suppress that. That cannot be taken as my weakness, my lord. That Purvasha people are the original parties against whom I am seeking relief. I am seeking relief against WBHB. And I have admitted that KMC is acting in good faith because I know it. I have not made out any frivolous case that KMC is not doing. I have annexed every communication between the parties, between the officials. I have not suppressed. This cleanliness before your lordship are not my weaknesses. I am clean. I could have said that KMC is not doing. If I would have suppressed 1 or 2 annexers.
Would it serve a purpose if I direct the WBHC, because tomorrow Purvasha will be coming up and
But the WBHB will take the issue with Purvasha because it is under them. The police will do for them, not for us. The police will do for them.
will it suffice if I direct the WBHC to give the water connection to you pursuant to that contract, and in the meantime continue to supply you water through tankers?
Exactly, my lord.
Through
That
tankers.
is why. That is why.
4 tankers for the time being.
4 tankers.
You asked for 4 tankers.
Yes, my lord. I cannot.
Subject to hearing them. Yes.
Subject to hearing. Yes, my lord.
So let us
Because
see.
because my lord, your lordship, if your lordship sees the prayer, there are so many flaws, but I am not raising those today.
Yes.
Let there be affidavit in opposition. Let them come.
Yes, very well.
It is a writ for declaration. It's a huge writ, my lord.
Who are appearing for the other side? Mr. Ghosh, you are for the KMC. No allegation against you.
No allegations regarding the laying down of the pipes and for the supply of water. But so far as one of the tanker supply of water through
Oh, you have
tankers,
to supply that.
no, well, that my lord used to supply my lord out of grace, my lord, in some occasions.
I
we
admit it.
supplied But now, my lord, if you have to supply my lord the water
Yes.
to the tankers, then we have to my lord, charge for the water fee. Therefore, that is to be borne by the society.
Is the housing board represented? State?
Today,
No, housing board, though I have served in time and at a call করেছিল না housing board থেকে? Okay. My lord, let housing board be directed to supply water. I have admitted, my lord, with open heart that KMC is acting in good faith. The communications reveal so.
But then I'll remain silent on the interregnum supply of water. They will have to buy
You
water.
know, it is not.
Because KMC cannot be directed for
No,
to comply with.
I am not seeking. I have.
Then I'll not give anything.
I have
and
not sought any relief against KMC.
Then I can
Rather, I have admitted that they are acting in good faith. My lord, you will not see petitioners stating like this.
Then I can just direct the
WBHB
to give you water supply.
water as yes, water as
But that will would that give you any relief? I mean, effective relief. Then let's see.
effective release in the meantime. Then they will file the affidavit in opposition.
In
Then
the
it will
meantime, there cannot be. Then I'll have to dispose of the writ petition. Without disposing of, if I give that relief, that is the main relief.
Yes, my lord. What is your lordship's suggestion? I failed to hear.
No, I have to dispose of the writ petition then by directing the WBHC, but that will not give you any effective relief. By directing the WBHC to give you
WHB.
HB to honor the contract with you and give you water supply. But that will be extremely vague because that is already there. They are not saying.
No, there is no such direction. Actually, my lord, WBHB has taken it with an easy manner. They are
very interim order then. That is a difficulty.
your lordship. Whatever. My lord, I will not argue with your lordship. I argue with my case.
No, definitely argue your case.
No, I have understood. So your lordship's suggestion is your lordship want to dispose of the writ petition.
That
By
is one of
directing the WBHB to supply
Simpliciter, yes.
this clause 22.
Yes.
Sorry. At page clause 5.
Yes.
82. At page 82. 4 tankers. Whatever we have paid. 4 tankers. I cannot cross that limit now.
No, 82 who is paying now? The KMC is giving out of grace, as you said.
No, yes. That has been stopped, my lord. This also I have admitted. WBHB. It is the duty of the WBHB to supply us water. KMC is the executor.
Let me see the contract first.
At page 46.
Yes. No, it starts prior to that.
No, specifically the water is appearing at page 46. It will be sufficient.
KMC is not a party at all to
No,
this.
no.
They have no liability actually.
No liability. I have never said that. I have said that though they are acting in good faith, they were prevented. And WBHB is not taking any serious step. WBHB has to arrange for the police authorities or otherwise for execution. KMC is interested. KMC, the communication between KMC and WBHB reveals that KMC is acting in good faith, but WBHB is relaxed.
Very well, pass. An arguable case has been made out by the petitioners, the petitioner, which is an association of apartment owners in respect of a housing society by the name of Purbanho. Full stop. Next para. Learned counsel for the petitioner places reliance on an agreement between the members of the petitioner association and the West Bengal Housing Board, bracket, respondent number 2, bracket closed, to the effect that the members of the petitioner were to be allotted flats and to be given ancillary facilities. Full stop. By placing special reliance on page 46 of the writ petition, which carries the third schedule to the contract between the respondent number 2 and the members of the petitioner, it is argued that the respondent number 2 was duty bound as per the agreement to make water supply arrangement, with source of water being from the KMC through a GI inlet pipe / ferrule connection connected to the semi-underground water reservoir of capacity 22,000 liters and thereafter lifted to the overhead reservoir by centrifugal pump. Full stop. It is contended that till date such water supply has not been given, compelling 12 out of the original 34 allottees to shift residence. Full stop. Next para. insofar as the remaining residents are concerned, comma, they are going without water supply, comma, being compelled to purchase water. Full stop. The KMC, comma, for some time out of grace, comma, it is contended, comma, supplied water through tankers to the residents. Full stop. However, comma, it is submitted that the respondent number 2 is required to be directed to comply with its part of the agreement by immediately giving water supply to the petitioner, to the members of the petitioner. Which of next para. It transpires from the documents annexed to the writ petition that the petitioner is justified in arguing that the respondent number 2 is duty bound to give water supply to the residents of the Purbanho housing. Full stop. Next para. Since for the time being, comma, the petitioners are without water supply, comma, it would only be prudent if the respondent number 2 is directed to arrange for supply of 4 water tankers filled with water daily to meet the regular needs of the residents of the said housing. Full stop. Next para. Accordingly, the respondent number 2 is directed to provide 4 water tankers daily to the Purbanho housing estate situated at 160 by 1 capital B, comma, Maniktala Main Road, comma, Kolkata 7,54,000, comma, to meet the present needs of the residents there, comma, till November 30, 2023 or until further order, comma, whichever is earlier. Full stop. The respondents shall file their affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within 1 week thereafter. Full stop. It is made clear that nothing in this order shall prevent the respondent number 2 to arrange for permanent water connection to the residents of the to the members of the petitioner association in the meantime, comma, in which case the parties will be at liberty to mention the matter for early hearing. Full stop. This much. Thank you.
For the time being, respondent number 2 will supply the tankers.
Respondent 2 will arrange for supply. They'll pay you if necessary. 46.
Availability in opposition by
Opposition 3 weeks, reply 1 week.
deeply obliged.
Acha, the matter will next be listed, sorry. Next be listed in the monthly list of October 2023. October.
Obliged. Deeply obliged.
Thank you. Thank you.
In নামটা দিয়েছে
30th November or until further order, whichever is early. আর অক্টোবরের মান্থলি লিস্টে আসবে।
For hearing, item number 2, Messrs. WPIL Limited versus State Bank of India and others.
Well, today
hopefully it will be over.
The prayer, that's all. Then I will wind up. My prayer, first prayer is a direction on SBI to refund the 50 lakhs along with interest. Second prayer is to direction on Reserve Bank to investigate as to what SBI and Yes Bank has done. These are the two main prayers. Another prayer interim that has already been taken care of. My 19 lakhs is kept secured with Yes Bank Dalhousie branch. So at this juncture, my lord, I'm only confined with two prayers. Refund of 50 lakhs with interest and a direction on Reserve Bank to investigate to the acts and actions perpetrated by SBI and Yes Bank, Dalhousie branch. These two.
Yes, you are for the RBI?
Yes, ma'am.
Yes.
On the first day, if I remember, it fell from your lordship that this is a dispute between a bank and its constituent regarding service, and it involves analysis of evidence, as I'll show your lordship. So Reserve Bank does not have the infrastructure to go into such disputes. Otherwise, Reserve Bank will be flooded with such disputes. For that, Reserve Bank has formed, your lordships, which are not adversarial disputes. Reserve Bank has, under the scheme, has formed an ombudsman scheme. Now, lordship, I take your lordship straight to the complaint made by my learned friend, which
he has not perhaps placed, is the first complaint is at page 42 of the writ. Subject in furtherance to a written complaint on 23rd March submitted before you, we further bring your kind notice about the flagrant bank fraud to the extent of rupees 50 lakhs perpetrated by the bank officials of State Bank. So fraud committed by officials, commercial branch. Has your lordship got that? Page 42 of the report. Yes. By committing breach of trust as a banker and forging our letter dated 17 March 2022 addressed to them regarding transfer of fund using RIGS facility. I, Amitav Edhikari, such and such, Assistant General Manager, Accounts of WPIL, having registered office at Trinity Plaza, 84-1A, Topsia Road, in furtherance to a written complaint dated 23rd March 22, submitted before you, do hereby bring you kindly notice the rampant bank fraud with commission of offences in the nature of breach of trust as banker and forging the valuable document enshrined herein below for effective evasive steps. Then WPI Limited dedicates itself, etc., etc. Then the kindly skip over the page 44. 44, my lord, second paragraph, by letter dated 17 March 2022, WPI Limited had requested the Chief Manager, State Bank of India Commercial Branch, Magma House, Kolkata, transfer of fund using RIGS facility, wherein we requested the Chief Manager to arrange transfer of fund pertaining to rupees 50 lakhs by debiting our cash credit account number 31116315533 maintained with the State Bank of India. And we categorically provide the details of transferring bank with Yes Bank Limited having its office at Connaught Tower, ground floor, etc. 7 Russell Street. Beneficiary WPIL Limited, beneficiary account such and such, amount rupees 50 lakh. WPIL was completely baffled to know that State Bank of India Commercial Branch had deducted said rupees 50 lakhs from our account on 17th March 2022 itself. But we were shocked to unearth that the said transfer of 50 lakhs had never been credited to the beneficiary account number and maintained with Yes Bank Limited. I completely sympathize with my learned friend, but kindly see the allegations which he has made in his complaint. Now, by a letter dated 21/3/2022, WPIL brought to the notice of the Chief Manager, State Bank of India Commercial Branch about such mischief, but upon hearing the entire factum along with the documentary proof, Chief Manager, namely Kanchan Chakraborty, RTGS handlers, namely Shubham Majumdar and Mr. Rajkumar Mahato, started to act indifferently to all queries. We came to know that these 3 persons, along with the henchmen, have been able to forge our letter of transfer of funds using RIGS facility, and you incorporated Yes Bank Dalhousie branches instead of Yes Bank Connaught Tower branch. These fraudsters have also changed the RTGS references along with the beneficiary account. These fraudsters, etc., being State Bank of India and their henchmen, now kindly see, my lord, have in unison committed offences of criminal breach of trust, bankers under section 409 of Indian Penal Code by forging on letter dated 17/3/2022, section 467 of Indian Penal Code, and committed the act of cheating as enshrined in 468 along with section 471 of the Indian Penal Code in furtherance of common intention and with the astute act of conspiracy in order to cause sheer wrongful loss to WPI Limited. The SBI Commercial Branch is Assistant Manager, its Chief Manager and their officers are named herein, who have been responsible for day-to-day affairs of the bank, cannot in any matter escape their liability from the instant rampant fraud perpetrated. So specific allegations against the officers involving violation of sections of Indian Penal Code, which requires, as your prima facie requires evidence, it cannot be adjudicated. So Reserve Bank scope, this complaint, if your lordship kindly come to 67, sorry, this complaint was addressed to, kindly see 47, sorry, 47, addressed to the last copy to If your lordship got that three, the Ombudsman, Reserve Bank of India.
Right.
Now, Reserve Bank of India Ombudsman formed under the scheme passed an order on this. That order, my lord will lordship see. No, আমার affidavit in opposite. Wait, just a second.
My lord is having the supplementary affidavit.
No,
Can you see
No, wherever it is.
no, I have in my
Probably Mr. Sen says in his opposition.
yes, I have made an.
Option page.
My lord, give me a minute, my lord.
Yes.
Affidavit. কত 14 অক্টোবর কার সাপ্লিমেন্টারি affidavit? My lord, yes, that order is that in the supplementary affidavit. I'm sorry, it's supposed, I thought it's. No, আমি দিয়েছি just a second. 14th.
And in the supplementary affidavit of the writ petition, page 9. Page 9.
My lord, Reserve Bank Ombudsman disposed of this application by referring to a particular provision of the scheme.
Requiring consideration of elaborate documentary note.
Evidence, yes. That clause, your lordship will find.
Page 3. Page
There.
22.
This clause can be borrowed in Article 226 also
Yes.
for the present purpose.
So this elaborate.
So that avenue has been already explored by them.
Explored.
So RBI has nothing else to do. That
Nothing
is
else. No. I'll now refer to the order of the after this was disposed of. My learned friend had filed the application under 156 section of CRPC before the magistrate. Now that order is at page 52 of the writ. Magistrate's order.
Yes.
Yes. Sorry, it's 663, page 63 of the writ. Kindly see.
Yes.
It's important. Date was fixed for hearing the preliminary inquiry report by OC Shakespeare or in EPS. The same has been submitted by learned advocate for complainant is present, heard, perused the preliminary inquiry reported submitted by OC concerned along with the petition of complaint and annex documents considered. It appears from the police report that there are sufficient ground for directing an investigation by the police in the matter for unearthing the truth, and it would require specialized technique of investigation for collection of evidence and for production of the same before this court, for enabling this court to adjudicate the same effectively. Accordingly, on the basis of the police report, it calls for a direction for police investigation under 156.3 of the CRPC. In this view of the matter, the application under section 156.3 CRPC is allowed. The OC Shakespeare Sarani Police Station is hereby directed to start an investigation upon receipt, a copy of the application with the accompanying document, etc. So this case is pending. Magistrate also, the ombudsman found that it requires elaborate evidence, and the same is the finding of the magistrate. So it is, and now the Supreme Court has held, I'll come to that. Now this, after this magistrate passed the order, he made a second complaint before the Reserve Bank of India. That is at page
Page 16.
page 73. same complaint before Reserve Bank. Reserve Bank of that was again forwarded to Ombudsman. Ombudsman said, I have already, there's a provision if one application is already disposed of, then that stands, it cannot be reopened. That is number one ground. The number two ground, which the Ombudsman didn't take in his second order, Ombudsman's second order, I have annexed, is confused. Is in my affidavit in opposition of RBI. The second order is at page 42 of Reserve Bank's affidavit.
Yes.
Your letter complaint regarding the same matter was dealt with by and closed under clause 16(2)(e) of the Reserve Bank Integrated Ombudsman 2021. Complaint is not maintainable under clause 16(1)(a) read with clause 10(2)(b)(1) of the Reserve Bank of India Integrated Ombudsman Scheme 2021. So this says, if your lordship, I'm not troubling your lordship, this says once the complaint is considered, then it cannot be reopened again. And my third submission is that Supreme Court has held, construed the Ombudsman and referred to the judgment. He said Ombudsman is a forum where there is no non-adversarial forum of dispute resolution. As immediately as soon as the matter is referred to any superior forum of adversarial dispute resolution forum like a court or tribunal, then Ombudsman loses its jurisdiction. So this point Ombudsman did not specifically mention. He said, I am already considered and have said Ombudsman doesn't have the power. So that judgment, may I just refer to my lord? Reported in 2007, 5 SCC 120. My lord, I draw your lordship's attention to para 14 of this judgment. There is a more, your lordship has got that para 14.
Yes.
There is a more fundamental aspect. The Ombudsman at best is an authority or tribunal of limited jurisdiction constituted under the scheme. It is a jurisdiction conferred by the scheme. The exercise of jurisdiction of power by the Ombudsman would depend on his having jurisdiction not only to entertain a claim, but also to bring it to an end. The continued exercise of power by him would depend on his continuing to have jurisdiction. Once he is deprived of his jurisdiction or gets deprived of his jurisdiction over the subject matter, he could no more proceed with a complaint which was filed earlier. In other words, to render an award valid in terms of the scheme, the Ombudsman must continue to retain jurisdiction over the subject matter of the complaint. A complaint goes out of his purview when the subject matter of it is taken to a court or arbitrator, tribunal, or forum. The relief that can be granted by Ombudsman is limited and confined to the matters coming within clause 13 of the scheme. The intention being incorporated, clause 16(3)(d) appears to be ensured that the relief an Ombudsman may not conflict with a more comprehensive adjudication by a court, arbitrator, tribunal, or forum with wider powers. When there is conferment of a power on an authority or tribunal with limited jurisdiction, that conferred power must continue to exist when the decision is rendered by that authority or tribunal. Once the conferred authority or power is taken away or impeded, the authority or tribunal can no more exercise it. This will be the position when one of the parties in a complaint before the Ombudsman takes the subject matter to a court, arbitrator, tribunal, or forum. In other words, when the subject matter will ultimately is about to pronounce his award, the Ombudsman finds that the subject matter of the dispute has been taken to a debt recovery tribunal or a civil court or an arbitrator or to any other competent forum, he gets divested of his jurisdiction. So this is the limited power.
And the
Reserve
next
Bank
paragraph also only a
and the next
non-adversarial.
part,
Only a non-adversarial.
or not that. So my submission, I am not referring to I can refer, but your lordship will find the scheme. I have annexed the scheme. The provisions are quoted in the orders, saying that firstly, it doesn't have jurisdiction when it has to consider elaborate evidence. And his finding is supported by the order of the magistrate, which magistrate also found it requires expert evidence, which can't be done by Reserve Bank. Reserve Bank does not have the power. But after saying all this, I will not stand in the way of your lordship's vast power to grant relief. If I am not once saying that my learned friend, some injustice has not been done. It may have been done, and your lordship has got wide powers under the Supreme Court decision. In fact, I had the opportunity to cite this Supreme Court decision when I first I was enrolled and appeared with one of the courts. So in fact, I told my learned friend that you will find this decision. There's a decision of this honorable court. I was opposed by Tilak Bose's father, Tarun Bose, and I showed this judgment, and my senior was very happy. You could find this. Is there such a judgment? I said, yes, court has vast powers to transfer money, prevent illegality being carried out. So I am not standing the way. Your lordship will pass appropriate orders. If your lordship finds that injustice has been done, and any order can be passed by your lordship. Those are my submissions.
SBI who is appearing, yes. Answer. What is my lord?
Actually, Lordship, from the first day the matter appeared, I had said that many documents have not been produced by them. So I had brought these things before Honorable Justice Moushumi Bhattacharya, and she was pleased to pass an order on September 13, 2022. I said that the RBI ombudsman orders have not been placed. First order is not there. So, and the present condition of the criminal matter status. So these things, Lordship had directed that they must be produced. They have produced it by way of a supplementary affidavit, Lordship. Along with that, they have also produced a RBI circular, Lordship, which I had produced before the court. So they have annexed that also. I will be referring to that, Lordship. Now, regarding the writ petition, firstly, there are disputed questions of fact. There is also an alternative remedy which they have also availed. As the ombudsman has told them, they go before the court which can deal with the evidence. They have gone there. Now, Lordship,
which
let me place from the
court?
beginning.
Which court? The criminal
court, Lordship, which will, the tribal issue is there, and they are proceeding, Lordship. Now, Lordship, regarding, firstly, I'll start with the facts. Page 26, that is the first annexure, Lordship, P1. And on page 30 is P3. Lordship will just flip over these for a few times because I'll show certain aspects, Lordship. From the top, Lordship will find WPI Limited, that is the logo. Then the name. In page 30 also, Lordship will see the same thing is there. Then Lordship will find to the chief manager exactly the same thing is there. Then the difference, Lordship, will come, though 50 lakhs, that has to be transferred to debiting this account. That number is also the same. Then the name of the bank, Yes Bank Limited. Now Lordship will find that the branch is different. That is Connaught Towers, ground floor. That is in page 26, and page 30 is Dalhousie. This is different.
Yes.
And then again, Lordship will find RTGS reference number 2. The RTGS reference is different. It is not the same.
because every branch has a different reference number. Then the beneficiary lordship will find it is WPIL. That is not different lordship. That is the same. And then number 4 lordship will find the account number. Account number lordship is different. The rest of the page lordship will find the signature is there on the left hand side. Lordship will kindly compare on page 30. It is absolutely the same. No one can see in 1 minute, as we see in the newspapers, from 2 pictures it is stated there are 5 differences. Find out. Lordship, in a minute a person will not be able to find out that the difference is regarding the RTGS and the beneficiary is the same and the branch is the different. This is the first thing, lordship. Then lordship, when this comes in, this goes to another bank. This is Yes Bank. It has been deposited before the State Bank. Now State Bank does its operations on a specific platform that is called the CBS. The lordship, in my opposition, lordship will take up my opposition. In page 6, lordship will find at the top of my opposition, that is D. As the money has been transferred through RTGS was real-time gross settlement to another bank in the private bank like Yes, it goes through this CBS is core banking solution. Now Yes Bank does not use CBS. It uses some other software.
Yes Bank does not use core banking.
It does not use CBS.
Different
It uses
software.
core banking, but not CBS. Why am I distinguishing this, lordship? Because when it is in the same bank, lordship, any person working in the bank on the computer can check the name and the number. But for a person sitting in State Bank, being an employee of State Bank, he cannot check the name and number of Yes Bank. That is what I showed in 26 and 30, lordship, the difference. That difference, employee working with the software of State Bank will not be able to see. Now, who will be able to see? The Yes Bank people will be able to see. So when the check will go to travel to Yes Bank, or the data will travel there they will be able to check.
What is the exact system, Mr. Rai? They give the letters.
Yes.
You transfer the money to the bank, to the concerned
No,
bank. Yes.
They give, along with the this letter, they give also a check.
Yes.
Everything was sent before the forensic experts.
There was only one check. Could have been only one check.
Yes,
Check
one
must
check
have been
and the
only one.
and the
50.
signature of in this letter. For the comparison of that and the letter given by them.
So what did you do after that? After getting the 2 letters?
Going stepwise also.
No, what do you do exactly? I'm asking.
I'm saying. So these are then sent. Oh, if he wants to say very.
Once they get the money, there is a transfer of figure from one bank to the other. It's not like the check is coming to Yes Bank.
Yes, cannot be. Yes.
No. So they get the money and they feed in the details.
They communicate to that particular branch of the Yes Bank.
So what they do is they feed in the details in their computer.
Yes.
Which account, which beneficiary name, etc., etc.
Yes.
This money paid. They send that. It is like an SMS. I am a recipient of the SMS. I don't control whether I receive the SMS or not. What my learned friend is perhaps trying to suggest, that I have a check and control on what SMS I receive and what I not receive.
It's from their end. Going from their end.
Not at all.
Going from their end. How can you have a control? Yes.
I don't have.
I'm not coming.
Anyway, let us see. Yes.
Please allow me to complete.
You get 2 letters, Mr. Rai, in your own way.
Yes. So, lordship, this is what I was saying. So this goes, how it goes, who is to check, who is responsible to do what responsibility until what end, that is in the circular, lordship. That has been annexed by them in the supplementary affidavit, which I had for the first time shown before Justice Moshumi Bhattacharya. So after I had shown, they had annexed it. Lordship, I'll come to that also. Now what has happened, lordship? Lordship, kindly comes to the supplementary affidavit, lordship. Lordship will find in the last annexure, that is page 16, annexure P16, Lordship.
Yes.
Now there is responsibility of two sets of banks. One is by the bank which is sending, that is the originating bank, and the bank which is getting the information, as my learned friend has said, that is the destination bank. Now, whose responsibility is till what extent? That is stated in the circular, Lordship.
You are the originator.
I am the originator
they are
and
the
they are the
recipient.
destination bank. Yes Bank is the destination bank.
Obviously. Dalhousie. Yes Bank Dalhousie is the destination.
Yes.
In this case.
Yes.
Right.
Now, what was the responsibility of Dalhousie branch? Lordship will find in the first page, paragraph 4. Paragraph 3, it starts, Lordship. That is from the third line, banks are generally expected to match the name. Lordship will kindly see. That is page P16, clause 3. Clause 3 starts with, in the CBS environment, customers of a bank can be uniquely identified by their account number across branches. Now I explain why, Lordship, I am not able to see through CBS and match their accounts. In terms of the extent procedural guidelines of the RTGS, NEFT, NECS, ECS credit, however, banks are generally expected to match the name and account number, which I just said, Lordship. Information of the beneficiary before affording credit to the account. Now, this is the usual procedure. Now, Lordship will kindly come to clause 4. Clause 4 speaks about the responsibility, because this is credit push, as Lordship, he has said that information is supplied and credit push, the money comes in. Credit push in nature is responsibility for accurate input and successful credit lies with the remitting customers. So the customer has to give the correct information. If information is wrong, as in the letter, Lordship is seeing that information is differing in the two letters.
Obviously,
so
yes.
Information is wrong. And the originating banks.
Which is you.
Yes, which is me.
Yes, yes.
The role of the destination banks is limited to affording credit to the beneficiary's account based on the details furnished by the remitter of the originating bank. Now, in order to handle surging volumes, Lordship as understands in this case, there are volumes in a limited time window, some banks use matching software, while in a few employ risk-based approach based on the nature and value of the transfer. Actually, this has happened. Risk-based, they have not actually matched. That was the problem. Now, Lordship will kindly turn over to the next page.
What should they match?
They should match the name and the number. With the WPIL, the number will not match. It is matching with Arindam Mitro. It's a different person. So risk perception is coming in. Now, kindly come to 5. This is the role of the destination bank. Destination banks may afford credit to the beneficiary account based on the account number as furnished by the remitter, originating bank in the message data file. The beneficiary's name details may be used for verification used in the risk perception, value, transfer, nature, and transaction. So Lordship finds that this matching is required, Lordship. For the destination bank also, this is a responsibility. So had they matched, they could have easily found out that WPIL beneficiary and the account number and IFS code are not matching. This was not done. Now, because of the bulk or volume of work, this is possible that person has missed. This is possible, Lordship. It can happen. It's a human error. Now, Lordship, regarding that particular account. That particular account, Lordship, already 3 frauds have happened prior to this particular fraud, which Yes Bank has also admitted. Now, because of that, there was an order of the court to hold a certain amount, and it has been taken out from that account. Now, Lordship, I do not know whether Lordship, he has supplied the statement of accounts, where it will be showing that in that particular account, 50,000 rupees has come in from State Bank. And it has been taken out on the order of a court, pursuant to another fraud. That is why 19,000 rupees is left now. The rest is not there. Now, in this situation, when there is a fraud, what happens? There is a provision of the Reserve Bank of India to make it a red flag account. So that caution is...
Which account are you speaking of? The recipient, ultimate recipient of the account?
Yes, Lordship.
At Dalhousie.
Yes, because already three frauds have happened, so it should have been red flag. So caution should have been exercised whenever another amount is going in to match the account number with the beneficiary name. So there, this person, this
All the
transaction
amounts,
could have been
all the
stopped.
amounts went from SBI.
The amount went from
All the alleged accounts were
no,
amounts
from three
different
other
banks.
banks,
Very good.
and those matters also going on in the criminal court, Lordship.
Yes.
They're also going on in different police stations. This is Shakespeare already, and those are, one is Bodobazar, another is Posta. The other branches are branches and banks are also involved, Lordship.
But in the first place, the originating banks must have sent those.
They are also, the same thing has happened. That the letters were given and it was not matching. What the state bank is apprehending, that when the representative of a petitioner went, he went with two letters, two different types of letters, where everything was same except the beneficiary name, IFS code, and the branch
Then
code.
the same must have happened for all the customers in all the three
Absolutely
banks.
same. Yes, Lordship.
So all these persons committed the same fraud.
Same, and has gone to the same person. This is Arindam Mitra. He is the beneficiary. He has
This
got
is
all
one
the-
person, X person. This
Yes.
petitioner is one person. Messrs. WPIL is one person.
Yes, those
From
are
state,
another three persons.
from State Bank, yes. From State Bank, he gives two letters.
Yes, Lordship.
All the other persons are also doing it from different banks.
Different banks,
So
and
that it goes to this
same person on
magnetic account.
same account, Lordship. He was
What is his
arrested also.
purpose?
He has been left on bail.
But what can be their purpose? The customer's purpose. What purpose will be served to them?
Customer's purpose, Lordship, the person who
Give
is,
me one motive.
I'm saying, Lordship, whenever
Yes,
a
yes.
person is going to a window and delivering a letter,
Why
if
should
the
I give
letter
two
that
letters? Yes.
a person is not being able to match this immediately and
Why
say,
should a person give two letters? If I want to credit it to some particular account, I'll give that account. Why should I make it so confusing so that I suffer? Why should they give two letters in the first place? Where is the
person
question?
is gaining, he's getting the money. He has taken out the money in the first instance.
But he's
now
losing.
there's a freeze. He is suffering, and two other persons also suffering. Three other persons are suffering.
The sufferer will go there and put him under the guillotine by giving two letters. Isn't it ridiculous?
Lordship, because of this, the money has been transferred to this particular account because of this fraud.
Why should he in the first place give two letters? I mean, what is the motive?
The representative should be caught. Who this representative who is going to the
That
bank.
same representative represented all the other customers in the other banks.
Whether they are same or not, I do not know, Lordship. Because they have serviced officers in one place.
All right. Yes.
One thing is left, Lordship. Yes, regarding the, we have sent it to the forensics, Lordship. Actually, because it has not been produced before any court, I have brought it in a closed envelope.
No, what is this?
This is the report from the forensic laboratory saying that the signatures are the same. Their letter which we had sent is not, is a photocopy. Ours was the copy which we had got in original, we had sent that.
So since
Along
that
with
is not a part of
text-
the pleadings, don't produce it.
No, this has come during the pendency of this writ petition, Lordship.
It's not a part of the pleadings. At the hearing stage, don't produce it.
Lordship is wants to see, I have brought it, Lordship.
Even if I want to see Mr. Rai, since hearing is almost concluded at this juncture, I cannot take it. You did not use any
because what
supplementary.
will the criminal court do then? They will be deciding this only.
Whatever. So you, in any event, who has to return the account? How does he get back the amount?
19 lakhs is with him till now because there was a freeze by this High Court. Before that,
Him means Dalhousie.
Dalhousie, and there was a order by Bankshal Court, I think, to return some money to the other person. That money has actually from 50,000 it has gone. The rest, Arindam Mitra has himself taken away. The rest money, 30 lakhs, which is not there, it has gone
Arindam Mitra
by
is
the
the
order
fraud-
of the court.
Is a fraud account holder. Arindam Mitra.
Arindam Mitra is a fraud account holder. I have stated it in my affidavit, Lordship. The rest money which has been taken away, it is not taken by Arindam Mitra. It has been taken off by the order of the court.
This
And
is a
red
huge-
flag was not put in.
This is nothing less than a scam, Mr. Rai. But if that be so, I mean, I was wondering how far the writ court can interfere. I mean, we can interfere definitely. We can direct authorities.
That is
But
up
which
to the
authority
Lordship.
can interfere? I am.
That
This
up
is
to
the
the-
reason in every matter CBI comes in.
I think the state of West Bengal should be made a party and all these four cases should be clubbed together
State of West Bengal.
because they are the PP.
They are
public
busy with
prosecutor.
other matters. Other more serious matters. Yes, let us hear the yes. You're.
I
you're
think I
done.
have one thing left to say, Lordship. I have just, I'll take a minute, Lordship. Yes, that is regarding the red flag which we stated in, I stated in page 9 of my opposition,
Yes.
that they should have taken caution. When already 3 frauds had happened, so according to the Reserve Bank circulars, there should have been, it should have been marked by a red flag before putting money inside again. Grateful.
Yes. Here for Yes Bank must be. Cannot be Yes Bank Dalhousie or Yes Bank Russell. Has to be. Thank God. I mean,
From what I,
the main allegation against you, you will go in your own way. But one of the allegations made by SBI, I'm trying to cut short on the starting point, that you did not match properly.
yes, I'll come to that.
That is one of the allegations. You have to
By
deal with
the
that.
respondent, not by the petitioner.
Yes. No, by the bank, by State
Yes,
Bank.
the State Bank. I did not know.
Now
there
it's a passing the buck game.
Yes, well, I did not. There was a mud throwing ceremony inter se the respondents. If I knew, I
Now
would
you
have,
know. Now you know. Yes.
I would have wanted at least a copy of their affidavit so that I knew what mud was coming on me. Well, so far as the petitioner is concerned, the petitioner wants from me a refund of the balance 19 lakhs, which is lying with me. The petitioner had informed me, the bank, on the 22nd of March about the alleged fraud. What the bank immediately did, put a freeze so that no further amounts could be withdrawn from the particular bank account. The banker also wrote, Yes Bank also wrote to the bank account holder that a mistaken transaction has taken place, because without the authority of the account holder, the bank cannot reverse the money. Otherwise, that account holder may come later and say this money was due to me. So bank wrote an email, send a copy of Malad in the format that you allow us to reimburse the money. We did not receive any reply, so we could not transfer the money back. As on the 22nd of March, when Yes Bank was put on notice that a fraudulent transfer may have taken place, by then a substantial portion had already been withdrawn by the account holder. About 29 lakhs around was lying in the bank account pursuant to an order of a court. A certain sum had to be transferred. What remains now is 19 lakhs. And what I've understood from the submissions of the petitioners, they are interested in Yes Bank so far as that 19 lakhs is concerned. My lord, if the court directs, we will transfer the money. Now the allegation, my lord, which has been made by the State Bank of India, the red flag circular, if my learned friend has, my lord, if I remember correctly, that particular circular, clause 2.4, red flags come into force as a statutory requirement or as a statutory duty only if the amount concerned exceeds 5 crores. Admittedly, here the amount concerned is 50 lakhs. So a question of red flag wouldn't arise. If my lord is pleased to take up my opposition now, lord. My lord, if my lord takes up page 31, that is the circular, the entire circular.
This is Shilaito Channel, Sanderson Morgan's.
No. This has been, yes, Shiladitya Sen.
Yes. Sen, I'm sorry.
Our opposition.
Right.
My lord, the entire RBI circular, my lord, we have disclosed.
Yes.
Starts from page 12, if my lord comes at page 31. My lord, 22.7.1.
Yes.
Processing inward transactions based solely on account number information. In the CBS environment, the customers of a bank can be uniquely identified by their account number across all branches. In terms of the excellent procedural guidelines for such and such, banks are generally expected to match the name and account number information of the beneficiary before affording credit to the account. In the Indian context, however, given the many different ways in which beneficiary names can be written, it becomes extremely challenging for banks to perfectly match the name field contained in the electronic transfer instructions with the name on record in the books of the destination bank. This leads to manual intervention, hindering the straight through processing STP environment, causing delay in credit or due return of uncredited instructions. The manual intervention also provides scope for error and fraudulent intent. Being essentially credit push in nature, well, this part is very important. Responsibility for accurate input and successful credit lies with the remitting customers, that would be the petitioner, and the originating banks. The role of the destination banks is limited to affording credit to beneficiaries' accounts based on details furnished by the remitter originating bank. Instructions for processing such inward transactions based solely on account number such and such. So, my lord, the liability of providing correct input is cast upon the customer and the originating bank. Once they have provided the details, the destination banker cannot prevent that money from reaching the account. If I do that, I will be facing, there will be floodgates of litigations, because the banker, the receiving banker, is deciding what money will come in and what money will not come in. The entire commerce of the country and the state would collapse. I cannot be an adjudicating body which will decide whether the input given by the originating bank and the customer is correct or not. Then I have to carry out a mini investigation on every transaction. The reason why I was reading the first paragraph is because in the Indian context, the existing difficulty faced has been canvassed there. Which is why in other countries, that doesn't happen as much. Because of our population, we are facing that problem. Now, on that, if the recipient banker has to carry on mini investigations, then the entire system is going to collapse. The only responsibility cast on the destination banker is if there is any allegation, fraud, etc., post-credit checkups have to be done, which he was, perhaps my learned friend was placing, the post-credit checkups. But post-credit means after the money has reached the account. Money reached the account. The moment I got the information that this is a fraudulent transaction or there is an alleged fraud here, I froze the account. No money came out except the money directed by the court.
That money went out to Arindam Mukherjee?
From his account. It's because I am not aware of 3 litigations. I am aware of one, where a court had directed you refund 10 lakh rupees. That was an erroneous transfer. So we refunded that 10 lakh rupees. And I have also annexed the bank statement. And also that we have asked Arindam Mukherjee, my lord, to give us the permission to transfer whatever money we hold to the petitioner. But he did not respond. That is why, my lord, the first day when the matter had come up before a different, before the coordinated bench, even then we said there is a freeze, my lord will direct a freeze on me. Whatever comes in, we will allow it to come in, but we will never let something to get out.
That freeze already is there.
It is already there.
Right.
And if this court,
yes, the coordinate bench, as Mr. Chatterjee said.
yes,
Yes.
and if my lord directs to transfer this money, we will do that forthwith.
So Arindam Mukherjee is not a party anywhere.
Not a party anywhere.
Very well.
My scope is very limited here.
Okay. Yeah.
I'm grateful, my lord.
One thing I forgot to point out, it was
Yes.
my duty, I couldn't find the page. My lord, we'll just take the Reserve Bank's affidavit. I'll just take 2 minutes for completeness. The Reserve Bank's affidavit.
Yes.
The first ombudsman order, 16/6/2022, which I was at page 40. Page
Yes.
40.
Yes.
Which says the complaint rejected under in the second paragraph last under 16(2)(e). 16(2)(e), your lordship find the same affidavit, page 32. Just the relevant clauses for completeness. 16(2)(e) is at page 32. I have annexed the ombudsman scheme. I'll take just 1 minute to complete my, I couldn't
yes.
find that. 16(2)(e), your lordship has got that the complaint requires consideration of elaborate documentary evidence. Now, when the second complaint, that is at page 42.
Yes.
That is at page 42, which says your complaint is accordingly classified as paragraph 3. Complaint has accordingly been classified as non-maintainable under 16(1)(a) read with 10(2)(b)(1). Now 16(1)(a), again come back, my lord, to 32. 16(1)(a). 16(1)(a) is non-maintainable under clause 10. Now clause 10 is before that, 10 2(b)(1).
Page 27.
Page 27. Yes, 10(2)(b)(1) is as page 28. The complaint, page 28, the complaint is pending before ombudsman or settled or dealt with. So this was already dealt with, so that's why. And the third ground is pending before any court that the ombudsman did not take, that I submitted on the basis of that Supreme Court judgment. These are my submissions.
Yes.
I'm very grateful, madam.
So Bhattacharya, only one thing. Now, even if you hold, suppose Yes Bank is exonerated for the time being, apart from paying that 19, that I'll have to consider whether without Arindam Mukherjee's present we can do. That you'll have to satisfy me in reply. One aspect of the matter. Second aspect is the dispute now boils down to State Bank and you. Obviously, there is a lack of motive on your part to give 2 letters. But for the time being, since State Bank throws a cloud on it that yes, it was not their fault, you gave 2 letters. Despite the absurdity of that proposition, that remains. That dispute is sub judice in a criminal court. RBI does not have the mechanism as per the guidelines also. So according to, I mean, one of the aspects is regarding the liability, respective liabilities of you and State Bank in that. Now, even if I hold that the State Bank being the originator was liable vis-a-vis Yes Bank, that is between the 2 banks. But between you and the State Bank, unless it is decided by a criminal court who is liable and the investigation reaches fruition, I mean, how can I direct anything to be done regarding State Bank and you? I mean, State Bank cannot compensate you at this juncture without the criminal court holding something.
Fine.
How can it be done? Yes. And
After
that
hearing-
19 lakh.
Yes.
19 lakh also you have to satisfy me that without Arindam, whether we can do that. Yes.
Now let me give the first answer.
One by one, yes.
First answer. Arindam Mitra's account details I'm not supposed to know. Even in my FIR,
yes,
I straight away asserted the State Bank and 3 officials or 4 officials whom I knew, they are the responsible persons. I did not indicate any name of Arindam Mitra. When Arindam Mitra transpired, when Yes Bank came into play and Yes Bank indicated us that this particular account belonged to one Arindam Mitra.
Yes.
Now, in my case, Arindam Mitra was arrested. He was arrested initially in connection with another fraud.
He was arrested?
Yes, he was arrested and he was bailed out ultimately after spending 25-26 days. Now he was tagged in my case and he was produced before the learned CMM. So Arindam Mitra came
in
into
your
play.
allegation against the State Bank, Arindam Mitra was also produced, arrested.
No State Bank official till date has been arrested.
No, then
Only Arindam Mitra.
Trace must have gone up to Arindam Mitra.
Yes.
For him to be arrested because you did not allege anything against.
Now, second question and the answer to second query. My lord, what troubling me is
difficulties, Mr. Bhattacharya. At least I can speak for myself. I am not sufficiently equipped on technicality to exactly know whether it is possible for one account to attract money from other accounts. I mean, there are 2 or 3 absurdities. Arindam Mitra is sitting with Yes Bank, Dalhousie Bank. Suppose Yes Bank, Dalhousie Bank, Yes Bank, Dalhousie branch is bona fide. Now they have an account. Arindam has an account there. Now this Arindam Mitra, he is attracting money from different banks, from different customers of different banks. And in every bank, I mean, 2 letters are being produced. If that be so, there must have been something must be going around Arindam Mitra. Can it be done? How can it be done? Then he has to have people in every bank so that they produce 2 letters and all this.
Absolutely.
It has to be a racket, I mean.
Now,
Anyway,
in this particular case, after hearing their reply, particular reply of State Bank, what troubling me is page 26, page 30. Where are the originals? Did they produce it? Have they ever able to show the originals? There must be two letters. Both the letters I have annexed contains stamp and signature of the SBI.
But Mr.
Commercial
Bhattacharya,
branch. Where is the original?
And criminal investigation is
So
pending.
the fraud, what they particularly SBI is trying to portray before your lordship is a complicated scenario of fraud. In my case, it's flagrant. It's evident.
How far can I decide here in its jurisdiction because the criminal investigation is pending? That is the only question.
So my case is completely different of what SBI is portraying. SBI is portraying is a large scale fraud, or in the Mitras.
I'm not going into that.
I'm not into that.
Cannot. Yes.
My case is very simple. The fraud is apparent, is evident before your lordship through the record, through their averment made in opposition. When
So
your
what, sir,
lordship
are you
indicated, when
seriously
your lordship
inviting the-
indicated, the blame game.
Are you seriously inviting the RIT court to hold that the fraud is very evident when you have lodged a complaint which is under investigation before a criminal court? Can I do that? I mean, should I do that? I mean, that would be extremely arbitrary. I may feel many things, but should a RIT court do it? That
My
will set a
answer-
very bad precedent.
I understood. I bow down to your lordship. My answer would be, your lordship, I am before your lordship is, I'm not saying your lordship to unearth fraud. Unearth fraud is the adjudication purely cast to the police.
If I can't unearth, can I hold conclusively it's fraud?
But your lordship can hold with the risk petition and annex document, read with the oppositions, that there is a contributory negligence on the part of SBI.
How will
First
that help?
negligence is SBI.
What can be the
second is
relief
yes
granted then? Suppose I hold so, what will be the relief granted?
refund of money.
The
I am the
entire money.
customer. SBI has full duty and responsibility towards its customer. What role they have perpetrated as a banker? Now, banker-customer relation has been dented.
Yes.
I am only to this contextual aspect before your lordship. Fraudulent transaction is apparent. My lord can direct State Bank to refund this money. Because State Bank has failed and neglected to act like a true banker.
It
And so
has
far
two
RBI
letters.
is concerned,
It has two letters. It says your man did gave those letters.
my lord, in their
Both
opposition,
continuous.
kindly
same
consider
similar
their
signature.
opposition paragraph 6.
What does it say? I mean,
In State Bank opposition in paragraph 6, my lord,
yes.
as the money was transferred. However, the Yes Bank, the recipient bank could have easily checked and verified.
That is the second
That's
aspect. of it.
complete blame game they play.
That is the blame game part.
Yes.
You are not bothered with the
The
blame game.
once a banker is adopting a blame game means they are negligent. They are negligent. The disputed transaction they are accepting. Thus, they are shifting the whole onus on the Yes Bank. And this paragraph D at page 6 is apparent. It's
I may
evident.
have to relegate it to the criminal investigation. I mean, I'll decide the writ petition either way. But fraud, I cannot probably at this juncture hold. Even 19 lakh, I'm in doubt whether, I mean, Arindam Mitra is an accused. He's not a convict in any
No,
of this.
I knew from the word go that your lordship, that role perpetrated by Arindam Mitra would trouble your lordship. I knew that.
Not that. Obviously, it's there. It's obvious for all of us
That
to.
would trouble your lordship.
Even then, he is not. I mean, we are a court of law. I cannot go on presumptions. Arindam Mitra is whatever he may be. He is an accused till now. He's not a convict in any of the cases.
No.
So we cannot say he is the culprit.
No, unless and until there is evidence, how could we
So
say
now
this?
what is happening? 19 lakh is there in his account. We are drawing that and giving it to you. But that you may have a very good case on that because that amount in the first place, more than that amount, was deposited in the first place in his account by mistake. Maybe there you have a very good case. And the account is still now frozen. So that relief may be granted to you. That's the probably best relief I can give to you.
Now, let me come back on Tuesday with some.
I'll come back with the order, not on Tuesday. I'll close
Your
argument.
lordship already.
Enough hearing on this. Yes.
Well, so for 19 lakhs, keeping with Yes Bank.
19 lakh is the best remedy probably we can give you for the
That
time.
can-
being, yes.
that
But
can
I'll
be
think
directed-
it over. I mean,
uh,
heard learned counsel for the parties. Full stop. Needless to say, comma, the previous interim order passed directing the Yes Bank Dalhousie branch to keep keep the amount of rupees 19 lakh to retain the amount of rupees 19 lakh to retain the amount of rupees 19 lakh in the interim order is already there. I'll not complicate it. Hearing attached to the actual line, hearing is concluded, the judgment is reserved. I won't touch that order for the time being. Yes. কতটা ডিলিট করলেন আপনি কি লিখেছেন বলুন তাহলে সব ডিলিট করুন থ্যাংক ইউ ইয়েস
Grateful.
মানে সিএবি
আমরা কি একটা নোট ফাইল করতে
ওই জায়গাটাই তো বারবার বলছে
Item number 3, High Speed Logistics Private Limited and another versus Food
Lordship,
Corporation
I'm
of India.
appearing for the petitioner. Mr. Sudhosoto Banerjee is appearing in the matter. He's not well. He had to go home.
Why? What happened?
I do not know. During lunchtime, he was not well.
So not today then.
Let it be taken away instead of Monday. Let it be taken Tuesday.
Your Lordship, Tuesday he has some difficulties.
I'll give it on Wednesday then.
Wednesday.
Fair. On the prayer of learned counsel for the parties, the matter is adjourned till September 6, 2023.
At the logically may pay for only at the top logically.
No, Original said there are not too many matters. It is already fairly at the top.
Yes, fairly at the top logically. See, this is the parted matter.
Grateful.
Only this is my only humble submission.
No, Mr. Kun, no further.
Lordship, may I file the affidavit in reply in that case?
Today, opposition has been filed.
Your Lordship.
I have filed the opposition on lordship.
একটা লাইন অ্যাড করে দিন তাহলে affidavit in reply filed today be kept on record.
I'm grateful.
Item number 4,
May please.
Food Products Private Limited and another versus the state of West Bengal.
My lord, Mr. Oyan Banerjee is appearing on behalf of respondent number 2 and 3. Lordship, there's some difficulty today and on Monday.
I can
Lordship-
start, my lord. This is affidavits have been complete, so this will take time. I can start, my lord. She can take notes and then Mr. Banerjee, possibly his turn won't come today, my lord. This is in respect of non-payment of subsidy. There has been a previous round of litigation, my lord, between the parties which had gone up the writ petition. In fact, the matter had gone up to the division bench. The division bench had passed an order and then remanded it back and directed the authorities to.
Mr. Bhattacharya, I will not start the matter at this hour. I am unnecessarily keeping it parted. Let us come back on the next date.
On Tuesday, Lordship, I beseech you, Monday.
But this is your last chance because on several occasions, either you have been
Lordship.
paying for time or yes. An adjournment is sought by on behalf of learned counsel for the respondents 2 and 3. Full stop. As a last chance to the respondents, the matter is adjourned till September 5, 2023. Yes.
Grateful.
Deeply obliged, my lord.
Yes.
Item number 5, Dalmia Securities Private Limited and another versus the Calcutta Stock Exchange.
Yes.
My lord, I'm appearing for the petitioner in the matter.
Yes.
My lord, I'm led by the AG SN Mukherjee in the matter.
Yes.
Keeping in view hardly any time is left, the matter may continue running in the list.
Good.
Your Lordship, I'm for the respondent number 1 led by Mr. Joyanta Sengupta and Mr. Anirban Ray, Your Lordship.
I'm not recording any order. I'm just passing, making it not today. Well,
Obliged, Your Lordship.
Item number 6, Sunny Rock Estates and Developers Private Limited.
not today.
Item number 7, Khattu Housing Solutions Private Limited and another.
My lord, I'm appearing for the respondents, my lord.
Yes. None appears for the petitioner, although the respondent is represented. Let the matter stand adjourned for the day.
Grateful.
Item number 8, Shoujo Das versus the state of West Bengal.
Not today.
Item number 9, West Bengal Power Development Corporation Limited and another versus the New India Assurance Company Limited.
This matter, Lordship may recall, had been mentioned by Mr. Chayan Gupta also. Lordship had heard it at length. We had made our submissions on the insurance claim. The second surveyor appointed by the insurance company had assessed and accepted the, I mean, had assessed our claim, which was accepted by the insurance company. After that, they are not paying it. They are not making the payment and rejected it without giving any reasons why they are not agreeable with the surveyors. The other side was making their submissions, but then thereafter, for no fault of theirs, of course, the matter was not called on. This was heard at length. That's why, my lord, we were hoping that lordship will have to give up a 5 minutes recapitulation, of course. Lordship.
So let us take it up on the next day.
If it can have some precedence, because then we will give 5 minutes recap and then it'll all come back to my lord for sure.
It's fairly at the top, so we won't put it further up. So let it be as it is. Yes.
Your lordship not looking too well. You're sounding a little.
No, the entire days. Thank you.
Not today.
Not today. একটা order record করেন?
Yeah, Lord, can you make an order that we shall inform the other side so that they can also be?
Yes, you are for the petitioner.
Yes, for the petitioner.
None appears for the respondents, although the petitioner is represented through senior counsel. Push up. Let the matter stand adjourned for the day.
Should Dr. Kanikali give us
Very well.
to inform?
The learned advocate on record for the petitioner shall serve a notice intimating his adversary that the matter shall be taken up for hearing positively on the next date when it is called on.
I'm grateful.
Thank you.
Item number 10, Devashish Dabriwal versus
My lord,
Reserve Bank of India.
this is my writ petition, my lord. I know there's nobody.
I'm
I
beginning
can
not to.
I can inform the other side because I don't think the last occasion also, I mean, may I actually give a notice to the other side because
You're for the petitioner.
I'm for the petitioner, my lord.
None appears for the petitioner, although none appears for the respondents, although the petitioner is represented through counsel. Full the petitioner shall give a notice to the learned advocate on record for the respondents, indicating that the matter shall be taken up for hearing on September 4, 2020.
Grateful, my lord. Deeply obliged.
Item number 11, Ishika Fertilizers Limited versus Reserve Bank of India and another.
Not today. Yes.
Item number 12, Ishwari Prasad Nathia and another versus State Bank of India.
ছেড়ে দিন আর ডাক্তার কেউ নেই।